Believe it or not, ladies and gentlemen, we are back. Thank you so much. You saw the thumbnail, you saw the title, so you know what we are about to do. Happy Friday to you all. We made it to the weekend, everybody. All we got to do is just make it at 5 o'clock. That's how we used to do it as teachers. Once you clock in, all you got to do is just make it to the end. So we've already clocked in, and let's just make it to the end of this thing. So today we're going to be talking about the YSL trial. It's going to be going back to day 103, I think it is. And there's a lot of speculation. There's a lot of speculation on what's actually going to transpire in this hearing on today specifically. So I'm glad that you all clocked in with me. So thank you so much, Donna, for tapping in. She's been a fantastic supporter of the channel. Thank you, Donna. Good morning to you, Love Bug. Absolutely glad to see Transplanted Texan in the building. Always holding it down, keeping everything in the middle of the road, along with my favorite Q, Kiana. Good to see you. Happy Friday, my people. Let's get our popcorn and let the circus commence. Who thinks the state will be ready today? Oh, I don't think so. I don't think so at all. I have zero. Look, hey, I talked to the bookies in LA. I talked to the bookies in Vegas. I talked to some bookies out there in Dubai. Nobody's betting on the state, okay? Nobody is. Not even a little bit. All right, let's keep this game going. Good to see. Thank you so much for becoming a new member, Nura. Thank you so much. Grace and peace. Welcome to the team. There she is. Mandy's in the building. Good to see you. There goes my brother Fred from another. There he is. Fred, good to see you this morning, sir. Paula's in the house. Paula was dropping some knowledge the other day. I think Paula's been cheating off my notes. You've been checking where my notes at. Make sure you're not reading my notes. I see you over there. Good to see you. M. Miller in the house. Thank you so much. Happy Friday to each and one of you. Mango gelato. I don't even know what mango gelato is, but it's starting to sound pretty good. So Grand Rising DWC in the chat. Good morning to you so much. Who is this? Emmanuel in the building. Mr. Emmanuel McCray, good morning to you, sir. Hopefully everybody is ready. I don't know where this trial is going to go. In my mind, it's like 60-40. Y'all know where I'm leaning. I'm sorry. Y'all know where I'm leaning, but anything could happen today. Anything could happen. I'm not betting. I'm not putting any hopes on the state coming in with anything meaningful and useful. And I think that's going to drive where the rest of this conversation goes today. So if we're here all day, it's because the state came with something. If we're here and Judge Whitaker is just trying her best to keep this thing on the road as best as possible. Let's see, make sure my audio sounds good. All right. I think it sounds pretty good. All right. So yes, there we go. I'll take that. I'll take that, Paula. Absolutely. Great minds think alike. Great minds think alike. So give you a lay of the land real quick. Court is supposed to start in about 9 minutes, and Judge Whitaker has not been disappointing as it relates to being timely. So I'm going to go ahead and say that it's going to probably start in 8 minutes because I think she's pretty serious about that. There's only 2 or 3 motions left that she had to rule on. She did shoot down 2 motions overnight, not overnight, but yesterday. Brian Steele's motion to be able to call Glanville as a witness. She shot that down, as well as I think another bond hearing. There was another motion. I should pull that up. Those were shot down. As I put on Twitter, you don't need bond and you don't need to worry. Oh, the recusal of the state prosecutors. You don't need to worry about the state prosecutors being recused, and you don't need to worry about calling Glanville because this is about to go to the House. I believe that's what's going to happen. So I'm going to lean on that again, like I said, about 60-40. I'm not going all in like I did last time because I lost my whole shirt the last time. But I think Judge Whitaker was just wanting to make sure, as I told you in my video yesterday, I think Judge Whitaker really just wanted to make sure that she had all her ducks in a row, all her I's crossed and her T's dotted, making sure that everything was going in the right direction so that when it goes to appeal or somebody attempts to appeal it, it will be upheld and not overturned in an appeal. So she comes in with a mistrial today is because the reason she didn't do a mistrial Wednesday, which would have made sense. I don't think anybody would have faulted her, but I don't think she had her ducks in a row. Because remember, they have to write a reason why they're doing this. So they could say something, but then they got to explain why they did it. And I don't think that she had enough evidence, in fact, to be able to say, Yeah, this is a whole dumpster fire. Yeah, I know Jason up there in Cobb County is saying it's a dumpster fire, but I have to have evidence and proof. I got to smell, the dumpster fire myself. I got to be in the midst of it and know that it's a pure dumpster fire myself so that I can say, this is a dumpster fire, and these are the reasons, the rationale, how I came to that conclusion. Not just my brother from another up there in Cobb County says it, not just the interweb says it, not just the best live chat on the planet says it, but I know it's because I saw it myself. Let me make sure they have not gone live yet. Okay, cool. All right, let's do this. We're going to get... Okay, well, I just want to make sure this stream is ready so we can pop it in when needed real quick. All right, looks good. Perfect. What does Donna say? Great. Hey, thank you so much. Very kind. Mango Gelato for the very kind super sticker. I appreciate it. Thank you so much. Thank you so much for that. Thank you for supporting what we're doing over here. Thank you. Y'all thank Mango Gelato. You know what? In honor of Mango Gelato, real quick, in the chat, very quickly, speedy, rapido, type your favorite type of ice cream. Let's go. Let's go. Okay. Favorite ice cream in the chat. Is that somebody checking in from Gwinnett County? What's going on? Angel, good to meet you. Welcome, sister from around the corner. Thank you very much. Look at, I want to see talk about Fonnie RICO charges from yesterday. We will talk about that. Yesterday, Black law student filed a RICO charges against the Fulton County District Attorney's Office. It was best. Send me the link real quick. Send me the file and I'll pull it up. We'll talk about during break. All right, we got vanilla in the building. We got chocolate chip ice cream, vanilla bean. And Fred is old school like my dad. Y'all, Fred is old school like my dad because his is butter pecan. That's some old black dad stuff right there. All right, Italian mango gelato. Well, there we go. Would have been anything else? Could have been anything else? Mango gelato? Absolutely not. Chocolate ice cream. I love Rocky Road. I actually have never had Rocky Road. I have to admit, never had that. I know it's early in the morning. We talk about ice cream. I know. But it's okay. The world's not going to come to an end. Every now and then. Uh-oh, new rule. Uh-oh. You rock the butter pecan too? That's something that was my dad's favorite ice cream. And the other day, this is about 2 months ago, I just said, you know what? I wonder what this butter pecan tastes like as an adult. Because I only ate it when my dad had it when I was a kid. And so I went and got it. And I was not impressed. I was like, what the heck is this stuff? I think it's because it was extremely sweet to me. I don't eat a lot of sugar and sugary stuff like that. And it was really sweet. I was like, Dad, what the world is this stuff? So, I mean, they would need like a very low sugar because it was just too sweet. I was like, wow, this stuff doesn't even taste good. Salted caramel. Okay, I got you. Mocha almond fudge. I'm sorry. Baby donkey. That just tastes like nothing but sugar. That sounds like nothing but sugar. It does sound decadent though. And oh wow. And it's all homemade when you buy it from an Italian ice cream shop. Okay. I can dig it. It starts at 9. Well, Judge Whitaker said 8:45. Branham. Let me tell you right now, bro, man. She been saying 8:45 and the camera's been going hot at 8:44. So I'm gonna be right here just in case. Because I don't want to be put on no contempt charges. I'm already under RICO supervision. All right. They got me on a RICO ankle monitor, whatever. So yeah, see, that's what we all about, Q. We all about the good ideas early in the morning. We all about them. Absolutely. And looking here at Law and Crime, they said it's starting at 8:45. So I'm just going to make sure that we keep them ready because who knows, man. I mean, Judge Whitaker has been popping, man. Maybe she say, hey, look, this is our last day together. I'm about to ruin the whole case for y'all real quick. Maybe she'll come in late. I don't know. Whoa, did that say Aussie? Michelle said hello from Australia. And this is not Australia, Alabama, right? Wow. Welcome to the party. Thank you so much. for stopping by from the land down under. I really would like to check out Australia. That's definitely a place I would love to check out. Get that coffee, retired. Get your coffee. Get your coffee. Susan, I live in Atlanta, so the joke is all this talk I'm doing about Fani, all these jokes I'm doing about Fulton County. I literally live the county next to Fulton County. So the joke is that they could put me on RICO and they could extradite me to Fulton County from here. So it's all a joke, okay? I don't want to be the first Presbyterian deacon brought up on RICO charges. That would be crazy, okay? No, and oh, by the way, let me just say right now, all of my jokes about betting are all jokes too. I don't bet, okay? So it's all just a joke, just to keep it all lighthearted. No, I'm not on RICO. Oh my gosh. But I did joke because I feel like you could use RICO for anything. Following their plan of attack, this live chat could be considered RICO. That's how you see. Don't wait. I done lost two viewers when I said that. Like literally, RICO is being used so broadly. I'm being facetious, but you could almost bring up this whole live chat on RICO charges, following the way that they handle it. So that's why I just make fun of it because I think it's really out of pocket. Ooh, Cuban coffee. Now I do like some Cuban coffee, but I'm gonna go back and say that iced coffee my family got popping. Let me tell you that it has been amazing. It has been amazing. Again, shout out to Lady Dear World Christian because that Keurig that she got. I don't know. I was looking at it like, why did you buy this thing? And now I'm like, why have we not had this thing forever? Because my Starbucks bill has gone down, down, down. Thank you, Mandy, thank you so much. Please, no joke, extradite Rico Jason. Please don't extradite me out of Cobb County, please. All right. The joke is how believable it is. Right? It is kind of wild. It is wild that since 2023, you really can't consider anything a joke until you've confirmed it. No, for sure. Pistachio almond ice cream. Oh, if you're just jumping in, we were asking what is your favorite ice cream in honor of Mango Gelato's very kind super sticker this morning. I was just asking, what is your favorite ice cream? If you want to jump in real quick and tell us. That is interesting. I would never thought pistachio almond. I'm not a pistachio eater. I'll eat some almonds like for days. Yeah, I can't say I don't know. I don't know what that one's because that would be like green because pistachio is usually green. Interesting. Turkish coffee. Sign me up. Fred, you know where I live. I don't know why we playing this game. We could do a live stream. Fred and Jason drinking Turkish coffee, talking trash. What does Black Law Student say early this morning? He says, if judge don't grant mistrial today, she could be a co-conspirator under the Twitter RICO. Did you send me that, Black Law Student? Let me make sure I got that ready. Black Law Student, make sure you send me your Black Law Student wrote up an indictment against Fonnie Willis in the Fulton County DA's office, and it was precious. It was the best. Okay, you didn't send it to me yet. Send it to me in email. That is hilarious. I'm down for some Turkish coffee. Let's give it a shot. Let's go, Fred. You know where I'm at. Don't play games. Don't play games. Costa Rica. Thank you, Bobby Long. Bobby Long is all the way in Costa Rica. I appreciate it, man. Thank you so much, man, for hanging out with us. That's what I'm saying. Like, this is the part that makes me kind of sad is that people from all over the world are watching Fulton County here in Atlanta. They're not watching Fulton County because they have such a great school district or because they're doing such a wonderful job of getting people out of poverty and encouraging home ownership. And they haven't done something like this wonderful program to encourage men and women to stay married and keep building strong families and building financial future for their children. No, people are watching this because of this crazy RICO insane case, also known as the Young Thug case or YSL. That is so sad. I'm like, Atlanta, we could do better than this. We could do better. Now, granted, I understand if it bleeds, it leads. I understand people like salaciousness and such like that. I totally get it. But my goodness, in the morning, at least give them an option. And the court is live. Let's go.
That's it. That's the
Okay,
only one.
thank you.
All
All right. So obviously, I think the first thing I need to say is my name's Judge Whitaker, which I'll do, which really has nothing to do with this particular charge. But so I think the first sentence, Judge Glanville is no longer the judge presiding over this case for which you've been selected and sworn to try. That's fine. There's no objection to that. As I understand, there's an objection to Judge Glanville was removed as the presiding judge. I would propose as a compromise, maybe just I will be the presiding judge in this case moving forward. Then you're not to concern yourself with the change, which is already there. And I would just preface the next proposed sentence that is in a trial, none of the decisions of the court, nothing the judge says is evidence. I mean, that's true, and that's a legitimate charge. I'll give that. I would just say, let me remind you, as I assume presiding duties in this case, that in a trial, none of the decisions the court makes, et cetera, et cetera. And then with regard to disregard any comments made by Judge Glanville that were disparaging of the defense lawyers, I would propose, because I am not supposed to be commenting on the evidence either, you are to disregard any comments made by Judge Glanville that may have been disparaging of any of the lawyers in this case.
Your Honor, would the court consider not instructing the jury as to anything?
If you want to think of some different language, I'll consider it, but that's what I'm thinking right now. I mean, he did make comments disparaging of lawyers. That's not evidence. It's nothing. There's nothing wrong with me saying disregard that.
Right.
So that's where I am right now. If you want to propose something else, then propose
You're just
it.
being difficult.
Orally or in writing? Does the court mind orally?
Sure, go ahead.
You are to disregard any commentary, any comments that you deem commentary on counsel for either side.
So instead of disparaging,
Yes, I don't. That's assuming that there were disparaging.
well, that's why I'm saying that may have been. So that may have been commentary?
Stop.
Well, I mean, right. He shouldn't, it's irrelevant whether he said you are doing a fantastic job today either. So
Right. Just let
Right.
it go.
maybe craft it a little bit more. And I understand what you're saying.
She's doing the most.
So if you want to come up with a word that kind of encapsulates disparaging or complimentary, let me know. Anything from the defense, or y'all just want to wait and see what she comes up with and then talk about that?
No, let's just leave it alone.
I don't have an objection to the part that you said about what you said.
All right.
I do not see the need to add also complimentary.
No, I don't think we should either. I wasn't suggesting that. I'm saying if we don't say disparaging, then let's come up with a word that would encapsulate any kind of commentary whatsoever, whether it's flattering or non-flattering.
But it should be disparaging. That's my point.
Maybe it might stay like that, but
And I think that I heard what you said, but I would continue to ask if you think it's appropriate to reconsider about the Judge Glanville has been removed.
okay.
Other than that, I don't have any other.
All right.
Man, those microphones. I wish they could fix those.
Okay, so we'll leave that for now. And if you, Ms. Love, want to propose another word or phrase, let me know. Otherwise, it'll read as I read it.
Yes, Your Honor.
All right, thank you. Okay,
Excuse me.
Yes.
May I just bring up may I bring up a brief issue before?
Absolutely.
You continue. You mentioned this morning about, that the court had several rulings that you put out yesterday.
Yeah.
I have not received any of those rulings on Odyssey. I haven't received any of the submissions from Ms. Steele that came through Odyssey. I know I've talked to several other counsel, but I haven't polled everybody.
Okay.
So I don't know what the issue is, but I'm not receiving
The issue is Odyssey.
Okay, yeah. So
Odyssey sounds crazy.
Yeah. And I can't do anything about that. I mean, Odyssey. So,
Anybody could email the rulings out.
sure. And I mean, usually, at least the lawyers seem to get things fairly contemporaneously. I know the court doesn't always get things contemporaneously, but, and it sounds like some of the lawyers have received rulings. I know Mr. Steele received some because he filed a petition for a certificate of immediate review about 5 minutes after I filed one of the rulings as to one of his motions. So I don't know what the vagaries of Odyssey are and why sometimes it seems instant and sometimes it doesn't. But yeah, I don't have a problem with, as I file orders, emailing them out to everybody, just like I asked that y'all email me with your motions and responses. So sure, we can do that going forward.
Thank you.
Okay.
House's beard is tight. I need to get my beard together.
You're exactly right.
In this case, for some reason, it's like they have this separate cases.
Yeah. Okay. So yeah, and I do not think that we have been filing our orders in everybody's case individually, every co-defendant's case individually. I think we've been filing them, like, for instance, if Mr. Kendrick files a motion and I'm ruling on that motion, I understand y'all have all adopted it unless, you say differently. But I think we've been filing it into Mr. Kendrick's case. And so that is exactly right, Mr. Short. That's what's been going on.
Yeah, for some reason, previously, we were receiving.
Okay.
So I don't know what's altered, but.
Well, maybe what's altered is that somebody on Judge Glanville's staff was individually filing it in every case, and I haven't been, and the clerk's office, I guess, hasn't known to spread it out into the other cases. So that's what's going on instead. Okay. All right. Thanks for bringing that to my attention. All right. So are we ready with any portion of
Anything.
Mr. Kendrick's testimony? What did I say? Copeland. Yes. Kendrick. I said Kendrick. Yes. Are we ready with any portion of going back, either any kind of agreement as to what's already been testified to? And if y'all haven't been able to do that yet, then, hashing through the evidence that we're going to have to face again.
So, Your Honor, there's several statements. I think what's really helpful is when we have, and we do have some of the transcripts now where we argued, so that can kind of prompt everyone's memory. And last time we had to go through all the contested segments. What we did is the state played them in court, and then we made our individual arguments. And now that we have the transcripts of regarding some of the statements, I think we're ready to do that.
Great.
And I'm just giving the court a heads up. It's going to be somewhat maybe disjointed at times, but we just got to plow through it. And myself and Ms. Hilton did the best we could to try to figure out where we were previously. I don't believe for the uncontested issues, I don't believe the uncontested issues have changed at all. I believe I speak for everyone on the defense that we haven't changed our view on the things that we agreed with the state. I think we just need to go over the contested issues.
Okay, that works.
Do you have the ability to play the statements to court today?
Yes.
Okay, good.
And
And the other thing I was going to say, the January 11th is the first, January 10th going into the 11th is the first statement by Copeland, and logically, maybe that would be the first one we review, but I don't believe that myself or Ms. Hilton saw a transcript of our prior argument of that one.
Okay.
So I would ask if we could start with the other ones
Sure.
first.
Yeah, that's fine.
Is that
Yeah, I
okay,
think
Ms.
there's still one day maybe
That's
that Ms. Weaver's working on. So that may be the day you're talking about. So yeah, we can start on whatever the next statement was. And are you going to be playing these through Zoom? So do I need to get on Zoom?
Yes, Your Honor.
Okay.
You do need to get on Zoom. What
And
I-
do you have transcripts of the
Zoom?
statements that are going to be at issue?
Yes, we do have transcripts. What I wanted to know from the defense, if there were any that were litigated that are agreed upon, because if there are some that were litigated that we don't have issue with moving forward, I don't know if we need to rehash everything, and we haven't had that conversation, so I don't know.
All right. Do y'all want to take a minute and have that conversation?
Yes.
Why didn't y'all call each other yesterday?
I can answer that. I think anything that was litigated before needs to be litigated again.
Okay.
And regarding the transcript, Your Honor, June 10th, we have the same imperfect transcript, but it's generally gives guidance. For some of the other interviews, the state has a transcript. There wasn't like an official
All right. Now,
transcript.
when you say June 10th, are you talking about his June 10th statement or our transcript
I'm sorry.
from June 10th of this year?
June
You mean
10th.
his June 10th statement? Okay.
2015. The state produced
Oh my
a
gosh.
transcript of that, and it's not perfect, but it gives
Okay.
guidance, and we're working off the same transcript.
Great.
For some of the other interviews, the state made a transcript at some point. Maybe, I don't know who made it, but it wasn't disseminated to us, and we made our own transcript.
Okay.
So we have like dueling transcripts, just saying.
Okay. Well, that's not for June 10th though, right?
No.
Okay. So maybe before we get to whichever statement has the dueling transcripts, y'all look at each other's transcript and decide which one you want to go by, or if some parts of it are better transcribed on one and some parts on another, combine them and let's get the most accurate transcript.
And that's why we were playing the statements.
Sure.
I just wanted to give.
Yeah, but
Judge Whitaker asked for a transcript, and there wasn't complete agreement on the transcript.
Yeah. And it's certainly a lot easier and frankly, a lot faster with the transcript. So if there is a statement that I particularly need to see and hear the statement for the evidentiary determination I'm going to make, that's one thing. But if it takes me 5 minutes to read a transcript or 20 minutes to watch the statement, I'm going with the 5 minutes unless there's a reason I need to be watching the video instead. Okay. Because I mean, honestly, for most of these evidentiary issues, I'm not here like making a credibility determination. For the most part, that's for the jury. I'm here trying to decide, does this evidence come in under XYZ exception under the law? Okay. However, right now I don't have any transcripts. So pass up whichever statement we're going to be looking at right now. If it's June 10th, 2015.
2015?
Can I email it to you? Like I don't have a.
Yeah, that's fine.
Wow.
In fact, we might have some transcripts of certain of the statements. So. Under what?
Wow. Okay. Well, Judge Whitaker seems like she's trying to move forward. She's trying to plow forward, man. Okay. I would have lost that bet. Glad I don't bet. Wow. I didn't
Ms.
think this was
Weaver
gonna happen.
provided our chambers with several of the transcripts of the statements that y'all had given to them, I guess. So I've got the transcript of that June 10th. And I actually have videos of some of his interviews too. I think maybe all of them, but
I forgot my bingo
some of them
board.
play under evidence viewer that y'all gave to me and some of them don't.
So, if you received 6 interviews, if you receive 6, 5 of the 6 are all evidence reviewer.
Okay,
And then the only one that's not evidence reviewer is the October 2021 interview.
all right. Okay, so I need to get on Zoom. Give me a second to do that.
And can I have the link as well, Your Honor? I'll email everyone.
Okay.
Thank you there, Texan. All right, so, sit
Can I
down.
get, excuse for a brief moment?
Sure.
That guy is a good, whatever his name is, he knows what to do. She left and she left her laptop screen up and he immediately reached over and turned it down enough so that nobody could see what she was doing. That guy is on his game. I gotta give him credit for that. Y'all stop. Why y'all got love out there buying Post-it notes? Come on, man, because she showed into her homework. We still talk about evidence. I got 3 on my, did she say evidence list? I think she did. So my bingo board is looking pretty nice right about now. That is true. That is true. Her laptop is at least working today. That is wild. Look at Germany in the building. Big Bot, good to see you. Germany in the house. The like button is wrecked on the way in. Grace and peace. Good to see you. Thank you so much. I see you, Seek Truth. How are you? Good to see you. Good morning. So those people.
June 10th, 2015, statement of Mr. Copeland to law enforcement, and we're all working off of the same transcript, and you're going to play the video as necessary.
Yes,
All right. Ready when you are. With regard to whatever portions of this are contested, tell me where they are, I guess, timestamp in the video, as well as what portion of the transcript, and then tell me what the dispute is, okay? Yeah, you can just come up here. Sure. And, Lon, can you shoot email? Down in there sometimes.
I see you, Amethyst Angel. Good morning.
And if not, then.
Yep, there he goes again with the laptop. He knows what to do. Okay.
We get let in to the.
Amazing.
All right, tell me.
Yes, and Your Honor, just to orient the court.
Sure.
So the state had proposed several redactions of portions of the interview that we did not want played.
Mm-hmm.
And the defense, for certain portions, wanted that portion to be played through the state.
Okay.
It's the state's position that if we don't play it, and they choose to play it, they can, unless we believe it's inadmissible.
Okay, so with regard to any of those portions that you just think they don't need to hear this, but the defense wants to play, I guess, have y'all talked about whether the defense intends to play it so that you can tell me whether you think it's inadmissible?
Yes, and
Okay.
so I just wanted to
All
orient
right.
the jury that's.
All right.
Where we are. So with respect to the June 10th interview, the first section, I'll just go in chronological order, that there was an objection. The defense wanted to redact timestamp 1019 to 1011. I mean, I guess I'll let defense counsel explain why they wanted that.
1019 to 1011.
101911 to 101941, which is page 61, line 22 of, beginning at page 61, line 22 through page 62, line 14.
I'm still surprised we're doing this. I'm so surprised.
Man, I need a go-to page number on this computer. So I don't have to just scroll and hope I get it right. All right.
Yes, sir.
Can you repeat what you said about this segment? Who wanted what?
This is a segment that defense counsel, you want it redacted, but we objected to it being redacted.
Okay, so this is what you, because a minute ago you said stuff you're not gonna play, but the defense wants. So now you want this, the defense doesn't.
Correct, Your Honor. So the way that we had organized it initially,
I mean, if we're just gonna walk through the whole transcript and then, that's fine. That's fine. I just need to understand what it is.
yes, so this was a portion that the
You
defense-
want, the defense doesn't.
Yes,
Okay, and that is, I know it's 10-19-41, no, 10-19-11 to 10-19-41.
yes, Your Honor.
Okay, all right.
Thank you for the super chat, Willie. Thank you so much, Willie Doc. Brother, we're going to go over just a quick recap during the break for sure.
And right now, we're starting at 10-18-52 with evidence reviewer. It's sometimes a challenge to get it right at the right timestamp, so you just bear.
All right, let me ask. So I had just said, I don't know that we need to actually listen to the video of everything. And I mean, I can read the words on the screen, so on the transcript. So unless we also, for some reason, I need to be hearing it out of his mouth. And if I do, and there may be times I do, then we'll listen on the video. But if I don't, I can read it.
So the state's position is we wouldn't hear from the defense, but I think it's inadmissible. So that's what we were waiting for.
Okay.
Okay, so just a little context, if we're just looking at the.
Turn your mic on.
As. My legal assistant failed to turn on my mic.
Ah, there you go. That's how you do it.
If we're just looking at this, the transcript,
Uh-huh.
add some context.
Well, no, let me stop you. If you, for a reason, want me to watch the video, that's fine. I don't have a problem with it. I'm just trying to be efficient with our time.
No, that.
You mean, let me tell you what's been going on beforehand. All right, sure.
So they were discussing beforehand the Lil Wayne bus shooting.
Okay.
In this discussion. And then Kenneth Copeland on line 9 of page 61 says they did it. Who is they? And they who? And he says, Shannon and them. So the first part of our objection is Kenneth
hearsay,
Copeland
right.
gives information about the Lil Wayne bus shooting. What Your Honor needs to know from me about the Lil Wayne bus shooting is Kenneth Copeland, it's not been alleged at all that he was at Club Compound on the night of the Lil Wayne bus shooting. It's not been alleged at all that he was present, that he was there, that he had anything to do with it. So, and it is not at all clear. So it's clearly hearsay.
Uh-huh.
We need to search for an exception, and I don't know what the source of his information is.
Mm-hmm.
There were, this was Dwayne Carter is Lil Wayne, and when his bus was shot, there was all sorts of internet reports on gossip blogs and everything else, and there's just no way to ferret out what his source is
Sure.
to suggest that it falls under any hearsay exception.
Okay.
Now, I have in my notes on the transcript that page 61, lines 1 through 10, were not objectionable. That's what my notes said.
Okay, that's right.
And then.
Hang on. Let's make sure that's right. That's right.
What line did you say?
62 lines 1 through 10.
So, Your Honor,
62 or 61?
Oh, well, 61 as well, both. It starts on line 11 or somewhere about there.
So
61.
you want to ensure that y'all are in agreement that 61 lines 1 through 10 are in unobjectionable?
in Your Honor, that will, we need 2 rulings before we can answer that.
Okay.
So, initially, that was the case. However, Your Honor, based upon, we filed the notice of intrinsic acts that we would need to hear if this intrinsic act regarding the Lil Wayne bus shooting, specifically as it relates to Shannon Stillwell, if that is able to come in, then we would want to play the portions page 61, line, starting at line 1. Also, Your Honor, depending on the court's ruling on co-conspirator hearsay, co-conspirator statements, excuse me, we would.
Well, I can't just give you a blanket rule on co-conspirator statements. I have to know what the statement is.
Yes, Your
Right.
Honor. So that would be my response to this question. What Mr. Shard just argued is that what's,
He's not arguing anything right now. He's trying to make sure we're all on the same page. So,
correct. And so what I'm getting ready to say is what Mr. Copeland is
It's
speaking
the
with the
state.
detectives
Yeah.
about, which is the Lil Wayne bus shooting.
right.
This is information that the state believes he received from Demekion Garlington, a co-conspirator.
Okay.
And so we believe that this would fall under a co-conspirator statement as in furtherance of the gang. So because he's telling him about an act that occurred between these gang members, and to give the court a little more context, the Lil Wayne bus shooting, what we call it, is one of the acts. We've already presented evidence about this act. It occurred in April of 2015 in the midst of what we believe to be an all-out gang war with YSL. Essentially, the state's allegations are that Mr. Williams was in conflict with Dwayne Carter, also known as Lil Wayne. On an evening in Atlanta, several members of YSL went to a venue in which Mr. Carter was performing, and they created some type of ruckus outside of the venue. Later on that evening, a number of YSL members followed Mr. Carter's tour bus to essentially to their hotel or en route to their hotel and shot at their tour bus. What Mr. Copeland tells police is that Demekion Garlington told him that the individuals that shot at the bus were DK, who's also known as Walter Murphy, a YSL member, and Shannon Stillwell, a YSL member. Jimmy Winfrey, another YSL member, actually ended up pleading to the case.
Okay.
And so we believe that this will be a co-conspirator statement. So that is
Wow.
kind of the context of that statement here.
Wow.
All right. So what Mr. Sharp was trying to sort out is, do you have, sounds like you had previously, and by you now I mean the state, had no objection to lines 1 through 10 of page 61 coming in. Is that still your position?
Y'all needed to stay up there or keep microphones.
No objection of it coming in. Yes, we have no objection of it being played.
Okay.
Right, that was never an issue.
Okay. And it's still not. All right.
And I don't think we need a ruling on the intrinsic. I mean, this doesn't really further my interest, but just to be honest with the court, I don't think this is an issue of whether it's an intrinsic act, because it's pled in the indictment as an overt act.
Yeah.
Part 1. So
Okay.
I don't think that's the issue. The issue is the state is just saying, well, we think he got this information from Demekion Garlington. There's 2 issues. A, we think he got this information from Demekion Garlington. I don't know where they're getting that from. That's 1, other than speculation. 2, then it also, if they were to be able to show that he was the source and that he's a conspirator, then we would also have to, it sounds a lot like spilling the beans. So there's there's two aspects to that where the state burden is on the state, and I just don't see them
All right.
meeting it.
So, DK, I'm sorry, y'all. It's going to take me a minute to get all the names. DK is who
Or-
in real life?
Walter.
Poor lady.
And Mr. Garlington goes by D, right?
There's
Who is
two,
little D?
there's two little Ds.
They're two of like lots of these people. Okay.
So one will be referenced as little D from Mechanicsville, and that'll be Demikion Garlington,
Okay. So does he go by both D and little D?
primarily little D.
Okay.
Or-
And he's Garlington, but he'll
Poor
be
lady.
Lil D from Mechanicsville.
And he also is referred to as Scarface.
Okay.
Shut up, not another name.
All right. And then the other little D will be,
Quindarius Zachary, Quindarius.
and when they said little D,
From Cleveland.
Cleveland. All right. So we
Oh,
got
come
They also
poor,
call him
poor sis wit.
Sick D.
sick D, Lil D, or
Little D, sick D, big D. Good gracious.
and he'll be from Cleveland. Okay, thank you.
And Your Honor, it's not speculation that Demikion told him this information on page 61, line 22 through 24. Mr. Copeland says, little D, that's how I get all my information through little D. Which little D? D ain't, and they clarify, he
This is the
says
best.
Mechanicsville, which
This
is
is the
Demikion
best.
Garlington.
Okay.
I'm just not reading it that way.
All right, let's see. So maybe we'll listen to it. See, this might be one of those times when we need to listen to it.
This is the best. This is clip worthy right here.
Sorry, little earlier, I'm sorry, about 10:18:52,
Okay,
but we're going to be listening around 10:19:12.
all right.
Oh my gosh, this is the best.
It was on, they say Shannon BK them. DK with DK right here, so the last name, yeah. See, that's how I get all my information to Lizzie. The mechanic. Yeah. See, he not gonna be able to tweet all day. Twitter-ish, man. This all he gonna do all day. I mean, he gonna be everybody, he'll miss everybody. Everybody, I mean, talk to him. You know what I mean? So I was just asking, like, I can't be right now. If he don't put he'll sit right and tell me what's going on. So, well, I'm ready to hear about this, bro. If you know you ain't gonna plan on killing me, bro, why you never told me? You know what I'm saying? Say you plan on killing Tit too. Say I'm gonna kill Tit. Nah, so why don't you kill Tit?
And I can replay it, Your Honor, if you need me to.
So, Your Honor, this is my problem with this argument here. Typically, in every case I've ever dealt with a co-conspirator statement, every case I've ever read involving a co-conspirator statement, an appeal, the declarant said to witness approximately 2 weeks after the murder, while at the Exxon gas station, that it was the defendant and his friend that committed the murder, and that the person needs to be quiet about it, etc. There's a time, there's a place, there's what was said, it's who said it. Here, Mr. Copeland comes out with some hearsay, some vague hearsay information about the Lil Wayne shooting and who did it. They ask him, what about Lil D? And I'll concede it seems they're talking about Garlington. And Investigator Dennis is the one talking, and he's clearly asking about Demikion Garlington, I think that's fair. And he just says, well, Lil D, that's where I get all my information. He's on Twitter a lot, he gossips a lot, essentially is what he's saying. There's, I don't take a general statement of, oh, Lil D, he's a gossiper, that's where I get all my information, as sufficiently specific to this particular piece of information to say, Demekion Garlington told me, and I know you don't need an exact date, but Demekion Garlington told me, about a week after the Lil Wayne, if the state wanted to bring this in, I would expect here. Yes, Demekion Garland told me about a week after the shooting, we were hanging out at the Exxon gas station, and he told me Shannon and DK did this, but that's not what we have here. It's just a vague statement. Oh yeah, I get all my information from Lil D. So I don't think that's sufficient to particularly say that he's the source of that particular information. And then, of course, again, it's spilling the beans when it really comes down to it too, because there's no context that would allow Your Honor or any of us to conclude that the state has proved by preponderance of evidence that somehow a statement that we don't even know was made, where it was made, the context of what it was made, was somehow in furtherance of any sort of conspiracy. So I just don't see how you are armed with making any sort of determination that it falls under 801 D2E. And of course, the burden is on the state to arm you with that information.
Why Shard up there today? I have no idea why we're still doing this. She has to be wondering, why did I not just throw this case out?
Yes.
While you're reviewing this, with all due respect, I want to renew my motion for mistrial based upon the entirety of the record up to this point. I think it's impossible for you to parachute into this. I think this morning demonstrates why it's very difficult for the court to do that without having the background of the last 6 months of testimony. We're now replowing people issues.
All right, we're replowing because everybody agrees that, and I don't mean to interrupt you, but I, want to clarify that. Everybody agrees that everything that Mr. Copeland testified to in front of the jury after the motion to recuse was filed on June 12th has to be redone. So that's why we were replowing this.
No.
Go ahead.
Okay, but
Yes, I don't know everybody's nickname yet. That's true. But this is not in front of the jury, and evidentially, I'll either make the right ruling or I'll make the legally incorrect ruling, and that's something for potential appeal. That's true in every case. And I don't ever know the facts of a case before I start to take, it to trial. I find out in the course of the trial, or I find out as the motion is being presented. So yes, it would certainly be easier if I had heard 6 months of testimony that came before this, but I don't think it is a basis for mistrial.
I disagree entirely.
I'm with you.
You would know the basis and the people's names in the testimony had you been the trial judge up to this point. And I get your point. Before trial, you don't necessarily know the evidence. We are way deep into trial now. You would have heard this evidence. You would understand the context, and we wouldn't have to replow the contextual basis. So I'm just renewing my motion.
All right, I appreciate it. You're not wrong about factually speaking, it is more difficult, but legally speaking, it is overruled.
Can I just
Mr.
ask,
Steele.
could you mind, as you're making this analysis under 20 OCGA section 24-8-801
Wow.
D2E, I'd like the court to just denote that in a good case is, that I think is a good case, is Stafford, STAFFORD versus State. That is 312 Georgia, 811. It's in Division 5A as in Elisa, 865 Southeast 2D 116, 2021 case. And the reason, I'm listening intently, I don't mean to interrupt, but the state's belief of the law over the past year is that any statement made by a supposed co-conspirator to another co-conspirator who speaks with the police furthers a conspiracy. And as Mr. Sharp said, that is just spilling the beans unless it really does something to promote the conspiracy. So even what the state just said, I get my information from Mr. Garlington. My point is that doesn't help the state, because if I'm in a conspiracy with Mr. Adams to steal a pencil, and I tell Mr. Adams, I stole the pencil, or Haley, who I'd like to introduce you to, stole the pencil as part of our conspiracy, Mr. Adams, then repeating that to law enforcement, doesn't do anything to assist us. Now, if he said, cover for Haley, give her an alibi, that is different. So the point I'm trying to make to you is, I'm not so sure that there is a conspiracy. Like, I'm just telling you, I know you're working hard and it's all appreciated, but Mr. Nichols hasn't really been mentioned in this case. He was not mentioned in an opening statement. He has one little section on I can't remember the year, 2014, but I don't know the year, small drug case. Otherwise, he's not mentioned. And I'm not trying to argue for the Honorable Ms. Westmore and Mr. Harvey, but that's why he's always asking for 105 instruction. But the point I'm trying to make to you is, this exercise also has to inject, if you don't mind,
Oh, there she
why
is.
the state is saying it furthers a conspiracy. Just getting information does not further a conspiracy. That's my point. Thank you.
Thank you.
And, Jerome, if I can add some additional facts, because I don't want to. This is not the only time in this interview that Mr. Copeland talks about the Lil Wayne bus shooting. So this is the first time. He actually talks about the details of the shooting. At least 2 more times throughout the course of this interview. So this interview is 9 hours long. And so in the course of that interview, he gives more and more details about the shooting.
All right, maybe point me to the parts of that. So yes, I don't know if you were able to pull up Stafford, or if you have it, if you've looked at it previously, but what it says is the same thing that Mr. Sharp's been arguing for a while about co-conspirator statements. And that is essentially that even where there is a conspiracy that has been established by a preponderance. No, I lost my place. Hang on. What is it?
New poll going hot. New poll just went hot.
Here it is. Hearsay statements that implicate a co-conspirator but do not advance any object of the conspiracy, such as statements that merely spill the beans about the conspiracy, are not admissible. So if you can point me to how this advanced the conspiracy, and I understand your argument is, hey, the conspiracy is they're all members of an ongoing gang. They need to know what's going on in the gang so they can react like appropriate gang members and be prepared if somebody's coming after them. And that's a reasonable position to take. So tell me how it is that this is advancing an object of the conspiracy, and not theoretically where your evidence is going to show that.
Yes, Your Honor. So during 2015, there were just a number of different events and actions that took place beginning in January of 2015, all the way through about October of 2015, Your Honor. This particular shooting of Lil Wayne's tour bus was a part of two events. So Lil Wayne, I'm trying to simplify how Mr. Carter is a part of this. So starting in 2014, Your Honor, Mr. Williams had began a musical relationship with a person by the name of Brian Williams, also known as Birdman. Lil Wayne was one of Birdman's artists at the time, back in 2014 and prior to that. Evidence has come in that members of YSL, specifically, have made threats against individuals who we believe supported Lil
thank
Wayne
you.
during
Indulge.
this
Thank you so much.
ongoing dispute that they were having.
Is Birdman alleged to be in a
Oh my
rival gang,
gosh.
or he's just a rival record producer in the industry?
He wasn't a rival to Mr. Williams, so he was friendly with Mr. Williams. Lil Wayne, we believe, became a rival, and we're talking about back in 2014 and 2015, of Mr. Williams at some point. At some point, there was some friction between the two of them, in which Mr. Williams made subtle threats to Lil Wayne via social media. That evidence has been entered before this jury. And
Why did Dragon Wayne up in here?
we believe that the gang, when Mr. Carter came to Atlanta, there again, like I said earlier, members of YSL just converged on the compound. They left their different, I think they were at a music studio. They all came there in an effort to intimidate or threaten Mr. Carter.
Okay.
So informing another gang member of those activities is keeping him abreast of those activities. I believe that Mr. Copeland, we're going to confirm, was incarcerated at the time of the Lil Wayne bus shooting. And I want to make sure I confirm that for the record. So we believe
Where's this
that
going,
he
though?
was being kept abreast of what was happening while he was incarcerated. And then once he was released, he was provided this information in order to, whatever the next steps were, whether it would be to further intimidate Mr. Carter, but he was made aware of everything that occurred while he was in custody.
So do you have any evidence that then when he got out of custody, he also began to participate in this threatening of Lil Wayne and his peeps?
No, we do not have any
Said
evidence.
peeps.
So then how is it furthering the conspiracy of being in the YSL gang and not just, hey, guess what happened today?
Because it fosters cohesiveness, the fact that this YSL gang could literally shoot at a bus of a famous individual. It made the news, it promoted the notoriety of YSL.
Yeah, the shooting might have, but how is telling Mr. Copeland doing anything to further it?
Because he then can claim notoriety as being a member of YSL.
That helps him? How does that help the gang?
Because it promotes their notoriety, the fact that YSL themselves had the ability to shoot at a famous person. That promotes the gang across it made headline news, it made news.
That may be. Again, how does then apprising Mr. Copeland of it further the
Right. I agree with, I understand her
purposes of the
question.
gang?
Because it furthers his involvement, because
He
he's
wasn't.
still in the gang. He can still promote himself. He still promoted himself as YSL, as being a part of the group that shot at the Little Wayne's tour bus.
Do you
So
have any evidence that he does that?
Oh my gosh.
promotes himself as YSL?
Mm-mm. As, hey, I'm part of the group that shot up the bus.
I don't have evidence of him saying I have evidence of him saying he's still part of YSL and claiming affiliation with YSL because collectively they shot up the bus, not the specific individuals, but collectively as a group, they shot at.
Does he post or brag about YSL shooting up the bus?
No, we do not have any evidence of him
All right.
posting on social media YSL shooting up the bus.
Okay. All right, so we are then looking at
I don't even know what she was trying to do with that.
61, line 22 through 62, line 14, where he says, I get all my information from Lil D. Because everybody's talking about it. He knows what's going on. And I don't think y'all have sufficiently satisfied the co-conspirator exception there. I'll keep that part out. Let's move on to the next one.
So, Your Honor, then there's.
There's blood in the water, y'all. There's blood in
This
the
is
water.
where I'm not sure what the state's, 62, the beginning of, I'm sorry, the beginning of 62, they just talk about Lil D from Mechanicsville just being a gossip. Now,
Yeah, that's what I just excluded.
well, you excluded, in my understanding, you excluded the part where he talks about the Lil Wayne bus shooting. And then after that information he gave, there's a section, and I don't have a strong.
No, y'all all said nobody cared if that came in, 1 through 10. Nobody cared.
Yeah, 62, 1 through 10, I agree. I don't have a strong opinion. I was just trying to understand what, if the state had an opinion about that, if all of that was coming out or all of it was coming in. The 1 through 10 on page 62. I don't have an opinion.
No objection to it?
Yeah, no. 62, 1 through 10, the state is okay with coming.
Okay.
Okay.
I was just trying to clarify. So
All right.
But then starting at 11 on page 62, there's another aspect of this where it's not the same issue. It's something about Kenneth Copeland talking about potentially Jeffrey was going to have Tick, and Tick is a gentleman named Trontavious Stevens, who is also known as Slug, who is he entered a plea in this case.
Your Honor, that portion is redacted.
Okay,
62, line 15 through 22 will be redacted.
Okay.
All right. Next.
Oh my gosh, this is so painful.
I believe the defense wanted next page 62, line 23 through page 70, line 16 out.
Tell me again, 62,
Page
line
62,
23.
Yes, line 23 through page 70, line 16.
16, okay.
I'm sorry. There's no way that the state can think they're winning. There's no way the state can think this is going in their favor. There's just, I can't believe they're that obtuse to think they're winning this or making their case. Because remember, they're going to have to bring all of this that they're wrangling with right now before the jury. The jury is going to totally lose their minds over this. And I think the defense is doing the right thing. Just let them just keep wrangling because this is their show. So as they wait, all this waiting is because of the state. All this long pauses and stuff like that, that's because of the state. Good morning, Patrice. Good to see you. Good to see you. Thank you so much for hanging out with us this morning. Yeah, I don't think this does not look good for them. I don't think they did a lot of work yesterday because they should have just come in and say, hey, this is where we're ready to go. And we'll work on other things. Kenneth Copeland they should not have come in here with Kenneth Copeland. They should have said, you know what? We're going to put Kenneth Copeland. We're going to take him back to the body shop. We're going to get that thing worked out. There's some dings and some dents, some flat tires and a blown engine. We're going to work on that, but we're going to bring other person in and we're ready to go right now with this person. We know what they're going to say. Here's all the evidence. Let's get rocking and rolling. After then, we got 2 other people lined up. Y'all still horse trading with Kenneth Copeland. That's how I feel like you all have. That's why I think this case is trash. I admit I'm a little bit surprised that Judge Whitaker said this can go up. You can bring this up in appeal. I'm sorry. I don't think that's a good way to approach it, in my opinion. Now, somebody told me, a legal expert told me, if a judge is going to call a mistrial, they do it first thing in the morning or right at the end of the day. So if you go back to like the Alec Baldwin case, they did that within the first 2 hours, if I'm understanding correctly. So it's pretty early. Okay, so it's pretty early still. So maybe Judge Whitaker could, or she could do it at the end.
And I'm not saying that the state's misrepresenting anything, but I don't recall having a blanket objection. Now, there's certain parts in this transcript as a whole, and they're coming up not to 72, but a little bit after 72 that go back to Lil Wayne's bus shooting.
Oh my gosh.
All that is covered under the last ruling. I mean, all of it's the same general situation. But regarding these pages 61 to 72, what I have is I objected to 70 page 70 lines 16 to 19, where it's just investigator Dennis identifying, it's not Copeland talking, but investigator Dennis says,
if Shannon is a shooter.
Shannon is meaning Jeffrey's shooter. Why would he put these? Yeah. I think that's inappropriate to have.
I don't know.
Investigator, just put that out there. And then after that, line 72, lines 5 through 13. Again, it's investigator Dennis.
Ladies and gentlemen, Shannon has confessed that they're not the shooter.
Everything in relationship between Kenneth,
The best.
Jeffrey, and Shannon, and it's not needed to add context to anything. It's just kind of him giving his theory.
All right. So does anybody have an objection to pages 62, line 23 through, I thought you said 70, line 16?
That's what
Anybody have an objection to that?
Okay, I'm sorry. No.
Nobody has an objection. speak now or forever hold your peace. All right, there's no objection to that.
And as it relates to what Mr. Shar just mentioned, page 70, line, we have 17 through 19, we have no objection to.
To redacting that?
No.
Okay, so 17 through 19 will be redacted. Page 70, line 17 through 19.
And also, I believe what he just said, page 72,
Lines 5 through 13.
no objection to that as well.
All right.
Oh. 72.
Okay, next.
The next portion that I had initially was page 70. The defense wanted redacted was page 72, line 14 through page 73, line 21.
All right, does the defense still have an objection to that?
The 73 line.
No, 72, 14 through 21.
No, 72, line 14 through 73, line 21.
Okay.
God bless you.
No,
God bless you.
Okay. Anybody, any of the defendants have an objection to that portion? Sounds like a no.
Okay. Then you're on the next portion, I believe would follow under your previous ruling, which would be redacted, which would be page 73, line 22 through page 78, line 16. So
Okay,
I don't think there needs to be any further
all
discussion.
right. Look at us making progress.
Your Honor?
Yes.
Can I briefly, having read Stafford, just address something briefly related to the case cited? Your Honor, in regards to Stafford, it's quite distinguishable by the mere fact that it appears from reading this that this was a co-defendant's statement to the police and that co-defendant did not testify. So what they were arguing was a co-conspirator in furtherance of the conspiracy was what this individual told the police. We have Kenneth Copeland here on the stand who can be cross-examined, so it's not what he said verbatim to Detective Dennis, it's obviously what he stated to other co-defendants.
Right.
And so I just think Stafford is quite distinguishable from the facts at hand, because there could be a situation where a co-conspirator is trying to throw off the police, tells them a lot of lies, which furthers the conspiracy, but that's not the situation we have with Mr. Copeland, who's live across the state.
Okay. I appreciate that. And when I made that reference to Stafford, I wasn't actually dealing with the facts of Stafford are influencing me to make this ruling. I was actually reading a quote from an entirely other case that's cited in Stafford just for the legal proposition. So, but thank you. All right.
Your Honor, that wouldn't, respectfully, that wouldn't be correct anyway. That would be a.
Oh my gosh.
Right. But that wasn't what I was using it for anyway. So, yeah. Thank you. All right,
What's
so
gonna be
our
the-
next portion of this statement?
What's the emoji for bless your heart? What are we gonna do
The
for that
defense wants
when she
out
finally says it?
is page 140, line 11 through page 143, line 16.
Ms. Hilton,
Yes.
I have 89, page 89, 3 to 25. Did you guys agree to that?
You said page 89.
Lines 3 to 25.
Yes, And I believe the full redaction that we agreed upon last time, correct.
This is crazy.
It's page 88, line 23 through page 92, line 20.
So y'all agreed that that's out.
Yes.
All right.
There's a small portion that we can play, which was page 91, lines 20 through 21.
91.
Lines 20 and 21.
Everybody good with that?
I don't know. I mean, in reality, I don't know how. Yeah, I'm fine.
Logistically, they're gonna
Yeah.
do that? Well, they can figure that out. All right, so then we're looking next at what line, I'm sorry, page 140, line 11 through, did you say 143, line 16? Or did I get that
Page
wrong?
140, line 11 through page 143, line 16.
And I'm sorry to keep doing this, but just so I'm certain, the other three before 140, is the, 112, 24 to 114, 25, we agree on that?
Page 112, line 21 through page 114, line 25?
Yes.
Yes,
Okay.
And y'all agree on that being out?
out. Yes,
Okay.
Your Honor. And then we also agree upon page 122, line 20 through page 124, line 10. Being,
22, 20. Okay, I'm in concurrence. And then 129, I have 129.20 to 130.20 approximately.
I have 129, line 18 through 131, line 25.
Is out by agreement?
Out.
Okay.
131 line 25?
Yes, sir.
Okay, great. All right. On the same page.
All right, so now I'll read 140, 11 through 143, 16.
Where did Love go? Love is gone again. Oh, she's back. She don't get a whole cart. She got a whole cart. Y'all. Oh, she done got a whole mailroom cart of files. They got her working. Y'all, they got Love working. Love is working hard, y'all. Y'all, they went and got, she done went and got a whole mailroom cart. She done beat up the mail attendant to get this cart. Amen. There we go. Let's go. We might need to go ahead and bless her heart. Bless her heart. Not a whole cart, a whole cart. Love with the CVS. Y'all are wild. This is, if it wasn't men's lives in jeopardy, this could be like a comedy skit. I mean, there's no other way around it. There's no other way around it. I guess we're gonna know. Bless her heart. Y'all, this is crazy. She really went and got a whole file. Now, remember, they came in here ready. You don't see anybody else scrambling over there. Look at her.
So you're right.
She gonna go get a Mack truck
Give a
next.
brief context.
All right.
So after the January 10th murder of Donovan Thomas, there were a number of retaliatory shootings.
Right.
One of those retaliatory shootings was on February 19th, 2015, in which Mr. Copeland is coming out of his home with his daughter and his child's mother. At that time, some members of the opposition gang drive by his house, shoot at him. He shoots back at them, and he's able to find safety. He goes to the police that evening, and when he goes to the police, they ask him for the gun that he uses. Initially in February, he tells them he'll get the gun. He'll give them the gun. He'll give them the gun. Of course, he never turns in the gun. Now in June, he is explaining to them why he did not turn in the gun. And so I wanted to give the court that context before
Thank
we
you.
go into argument.
Okay, and so what's our issue with this portion of the transcript?
Defense counsel, the state believes it should be played. We believe that this is intrinsic to that act from February 19, that it completes that particular story in which this is now the answer as to why that gun was never turned in. And so that's the state's position, that it is, if it does places we don't think it's character, the fact that Shannon Stillwell had this gun. I believe that was the previous argument, that the fact that Shannon is a convicted felon and has a gun is bad character. We don't believe it's bad character, and if it is character, it's incidental character. But this explanation of where the gun is intrinsic to completing the story of what happened on February 19, 2021.
Couple things.
Just keep hammering, Shard.
The shooting on February 19, 2015, where individuals shot at Kenneth Copeland, the story, the full context, individuals allegedly drive up, shoot at Kenneth Copeland while he's holding his baby, and he's with the mother of his child. He shoots back. He hits people, causes their car to crash. They're charged with this crime. Mr. Copeland's brought into the police station immediately and is questioned about things. He's never charged. Number one, if I concede that the incident itself is relevant to this case, the back and forth, that's fine. I'm willing to do that for the purposes argument. But I don't know what happened to, it's unclear to me what happened to Kenneth Copeland's gun or the gun that Kenneth Copeland fired. That is not relevant. It has no probative value to this case. My client, the fact that he is had to be in possession of a gun, he's not charged for that. It's not listed as an overt act. It does place his character at issue. It's very similar to cases that he's charged with in this indictment. I believe he's charged with 2 different counts of possession of firearm by a convicted felon. So the fact that he's charged with that exact same offense that would be implicated here increases the prejudicial value of this information. But in addition to the 401 and 403 issues involved, Your Honor, it's also based on hearsay. He's not claiming to have been there when he's saying Shannon came and got the gun. My understanding of the sequence of events, my understanding, and I'm not revealing anything my client has told me, I'm just going by what the discovery says. Shannon wasn't present. Mr. Copeland's goes to the police station. He's just been in a shootout. I don't know that he's basing any of this on firsthand knowledge. I think he's just heard this, and it's hearsay at this point. I don't think he's ever saying that I saw Shannon come in and take the gun. That's not the way I understand what he's saying. So I think there's a hearsay issue as well.
I'll hear from the state. So we've got relevance and hearsay.
And 403.
And 403.
So for relevance, Sharon, I think it is relevant. Well, let me start with the hearsay first. I don't believe it's hearsay. I believe I'm going back through the transcript that Mr. Copeland explains that when the police came to the house, Mr. Shannon Stillwell was inside of the home, that he left before Mr. Copeland leave. So I don't think it's
That's
his.
my reading of the transcript too. I mean, whether that's true or not, who knows? But what he seems to be saying is that when the police came by to get the gun, Shannon actually was there. And when Kenneth said, all right, let me go get the gun, by that time, Shannon had actually gone and gotten the gun himself and left the house. And so he was like, I can't get you the gun right now. Give me another day or two. So that's my understanding of it. So that would not be hearsay. So the hearsay ruling, the hearsay objection is overruled. How about relevance?
So as far as relevance, Sharon, we believe that the simple fact that he gets the gun from Shannon, or it's Shannon's gun, that he has to shoot back at the opposition gang, shows one, that YSL members, they interchange guns, Your Honor.
Oh my gosh.
That, more evidence is going to come out, that we have certain YSL members who may purchase the guns for other YSL members. So this again is a part of what the gang does, as a part of their enterprise or conspiracy. They pass guns around, so we believe that it's relevant for that purpose. And then as it relates to 403, Your Honor, Mr. Stillwell is charged with 2 murders in this indictment, both murders by handguns. So the fact that it comes in,
It's interesting. Where are they?
Mr. Copeland got this gun from Shannon is not going to, the probative value is not substantially outweighed by its prejudicial effect, given that the jury is going to hear, at least on 2 occasions, that Mr. Shannon used a gun, alleged to have used the gun, both in the Donovan Thomas murder as well as the Shamel Drinks murder. Additionally, Your Honor, when Mr. Stillwell was apprehended on March 17th of 2022, is the state's allegations that he threw a gun out of the window of a vehicle to dispose of it. So, Your Honor, we don't believe that the probative value is substantially outweighed by prejudicial effect.
If we assume the allegations to be facts, A, we would need a trial, but B, I agree, it wouldn't be prejudicial if we assumed, oh yeah, well, Shannon was in possession of a gun as he rode down the street on January 10th, 2015. But that's not what we do. That's the issue before the jury. So that's exactly what makes this excessively prejudicial, is because that's the issue that they need to determine.
I thought she came back another cart.
This story, which really adds nothing to the state's case.
Oh my gosh,
The idea
yes.
was evidence of passing guns around. I mean, they're going to have direct evidence of when Darius Zachary saying he's a straw purchaser of guns at Arrowhead Pawn. So they don't need that. And gives it to, and has distributed them to people in this courtroom or in this case. But that's exactly what's so prejudicial about this, is they're bringing in propensity evidence that is going to be prejudicial to the issues at hand, which is whether Mr. Stillwell was in possession of a gun and shooting at Donovan Thomas, whether Mr. Stillwell was in possession of a gun and shooting at Shmal Drinks. I submit to you, Your Honor, if Mr. Stillwell was charged with stabbing individuals, this would be less prejudicial.
All right, so you're now making a 404B objection also?
Well, it's 404B, but it dovetails into 403 as well. It's just a
Okay, because it really can't be 404B if it's intrinsic. And you just said you agree it's intrinsic.
Well, no, I agree that the shooting itself, the shooting involving Kenneth Copeland,
all right.
It seems they've argued it's intrinsic, and I don't think that my argument one way or another really makes a difference, but there's a separate incident, which is Shannon's possession of the gun. I don't believe that that's intrinsic.
Okay. All right, thank you. I find this evidence to be relevant and its probativity not substantially outweighed by the danger of unfair prejudice, so I'm going to permit that. What's our next section?
The next section I have, defense wanted out was page 188, line 9 through page 189, line 9.
This is so embarrassing. Like, What they're arguing about is not about these men, maybe Stillwell, but the Little Wayne shooting, what happened at Compound, what happened at Club Crucial, has nothing to do with anybody that's at this table. She's trying to say that they're in a gang, and I don't think any, or that they're members of YSL, which I don't think anybody there is saying that they're not a part of YSL. She hasn't proven that YSL is a gang, though, and that being in a gang is a bad thing. This is embarrassing. Maybe that's why Love is letting Hilton take the lead today. I don't know, but this is not. I don't see this as being a fair trial. I don't see this as being productive. Yeah, like I don't know. Like, so just being a member of, again, if you're a member of a rap group or a crew or a group of friends that get together and play Fortnite every Friday, could those be gangs? I don't understand how they're making this jump. I mean, there's groups of guys that go out bike riding, mountain biking, or paintballing on the weekend. They got guns. They share guns too. Like, how is this? This is sad. And if it wasn't the fact that there were men's lives literally hanging in the balance, again, this would be like a Tubi or a made-for-TV movie in its comedy. But there's literal people whose lives could be lost or put in jail forever because of this. And she's busy talking about people share guns. Like, I'm sorry, I didn't know that was a crime. And they're not prepared. They're talking. I'm sorry, they're not talking because they're sitting there paper shuffling.
Whatever he says, he does. And the context, in the bigger, larger context, is whatever Jeffrey says, she does. That is a broad character statement in and of, or whatever crimes Jeffrey says Shannon commits. That's a broad character statement that would violate 404B, bad character evidence, and 404
Wow.
Your Honor as well. But then, they get into how much Shannon's getting paid, and it's saying nothing. Well, guess who told me? Guess who told me that it's getting paid nothing? D. So.
Well, no, then Kenneth Copeland says no.
Oh, I'm sorry. You're right. And then they just talk about
How Kenneth Copeland can't flex because he doesn't get all this stuff.
right, and
How does she know that?
Yeah.
So I just
love her.
see the relevance of this.
Bless her heart.
I think it invites, it's speaking in very broad terms, and it's just broad bad character evidence about Mr. Stillwell.
All right, so it looks like Shannon told Copeland this, so it would be a party opponent statement, because he says,
Shannon told Copeland he doesn't get paid.
correct, for the stuff, but what, more importantly, not even to get paid or not getting paid, but that Shannon does anything Thug tells him to do.
That's
No,
not hearsay?
Shannon told me that is about Shannon not getting paid.
No, yes, Your Honor, let me be clear. Shannon tells Copeland that he doesn't get paid.
Right.
Yes.
Okay.
We're focused on the other portion
Yeah.
of what he says in here, which is he
But-
does everything that Shannon tells him to do.
That Thug tells him to do.
That Thug tells him to do. We have charged Mr. Williams with a leadership charge, which is count 56 of the indictments. And so we believe that that is relevant as it relates to Mr. Williams being the leader of the gang, and now a co-conspirator, member of the gang, is now telling law enforcement this other co-conspirator, this other member of the gang does everything the leader tells him to do. So we believe that that portion is relevant. What is surprising to Kenneth Copeland is that he doesn't get paid to do it, that he does it for whatever reason that he does it. And so we believe that that entire section is relevant for, one, to show evidence of the leadership count, Your Honor, and that Mr. Stillwell has conversations with Mr. Copeland about his role in the gang and why in the gang.
Okay, thank you, Monique. Mo Justice, thank you.
Where are we getting that Shannon uses the source?
Because if you watch the video, and maybe this is one of the ones where you might have to watch the video. He kind of whispers to him, and on page 189, detective says, he said Shannon. Shannon's telling him, but you have to see the video to see it in context. So we can play that portion.
Yeah, but again, that part was about the getting paid.
Yes.
And so what Mr. Shart is asking is, where's your information that Shannon is the source of Mr. Copeland's knowledge that Shannon does whatever Thug tells him?
So Shannon, so a few things. Mr. Copeland, Mr. Stillwell, and Mr. Garlington have all very close relationships.
Mhm.
They have known each other.
Yeah, that's established in the evidence.
Established in the evidence. And so really that is his personal observation of what he notices between the interactions of Mr. Stillwell and Mr. Williams.
All right.
So that's what we believe that's his source of knowledge. That's his lay opinion about what he's observing.
Anything else, Mr. Short, on this?
No, no.
All right. I am going to permit this over the 401 and 403 objections. And I don't believe, I mean, it's not improper character evidence. It's Mr. Copeland's firsthand knowledge, and it may be damaging to your client, but sometimes the state's evidence is damaging to the defense. All right, what's our next one?
Your Honor, the next one that we have that the defense wanted out was page 202, line 14 through line 20.
And we are in agreement, it's still in 197, 14, 199, 4.
Yes.
Did I get it right? For your notes, the exact line?
Page 197, line 14 through page 199, line 4. And that will be redacted, Your Honor.
Is it 202, 5 to 19?
14 through 20.
Okay, let me ask a question that is entirely irrelevant to what we're doing right now, except for the fact that we're all sitting in this courtroom. How's the temperature for everybody? It seems a little hot for me.
I was gonna say the opposite. Seems a little.
Dang. All right, well,
I agree with this.
darn it. Okay, I'm just gonna have to get a fan up here. Ah, well, it's not up here. Okay.
Your Honor, heat does rise, so it may be hotter up on the bench.
Okay.
Your Honor, since we called her, we have a.
Yeah, we can have a convenience break. Sure, let's break for until 10:30. That's down as far as it'll go. It needs to be adjusted.
Or you could just call this clown show is hot in the Big Tent. That's what the problem is, Sis Wit. Oh my goodness. I don't know what to say. I have no idea. I'll start with this. She's joked about it being hot before, and I bet she's gonna come back without that collar, that Ruth Bader Ginsburg collar on. She's gonna have that gone. I'm sorry. I have no idea what the state did the last 24, because it ended early. So let's just say, for laughs and giggles, the last 30 hours. I don't know what they worked on, because this just does not seem like they are polished. I have no idea, because she really seems like she is trying her best. You know what? Again, I'm gonna go back to what I said before. I really believe Judge Whitaker is trying to prove that I'm not just throwing this case away because I because I came in here and I was directed to throw it away. I'm literally trying my best. You will not be able to say that she is not trying her best. I think, in my opinion, I think she's giving a Herculean task. This is like the teacher that's trying everything to help little Johnny or little Sally become successful. They're staying after school, they're coming early, they're giving extra projects, they're meeting with the parents, they're meeting with social workers and reading specialists, they're going to reading conferences to learn how to teach. They're doing everything they can, and that child's still gonna fail. And she's like, look, I've done everything within my power. I've paired them up with reading buddies. I've done all of this. And at this point, I can't do anything but fail them. That's it. That's it. I'm trying to help them. Little Johnny can't read. Little Sally can't read. And at this point, she gave them a whole day off yesterday. And I'm sorry, they keep coming in and they're so used to blaming the defense. Because if you go back and watch during the trial with Glanville was always excoriating and punishing, hitting them on the knuckles with a ruler, the defense all the time. And they're trying it now and it's not working. They're doing the same things they were doing with Glanville. Glanville was the one popping them on the wrist and, challenging them and disciplining them and reprimanding them for, in my opinion, for no reason. So this right here is painful. Oh my goodness. The only thing that's making it not painful is the fact that Missy has come up with, Miss Mandy, please forgive me, has come up with the bless your heart memes. So there's the bless your heart, the sweet tea, and bless your heart, the heart with bless your heart in it. The browser and they'll pop up. And those are hilarious. Those are absolutely hilarious. I am here for them. But yeah, I feel bad for her because I mean she's really trying. I really have to give it to her. Whether you like her or not, whether you think she should have just threw it out, I think we all can agree she is trying her best to do the right thing. I think that's fair. Again, I think she should have just threw it on Wednesday. She should have called it quits on Wednesday. But she's at least trying. It's not like she doesn't want it to go on to the end or doesn't want to. I think at the end of the day, she's trying her best. All right, let me see. I got some good commentary right here. Yeah, man. It's getting hot under the collar. I do think she's getting frustrated with them for sure. And she's throwing a lot of shade at them. Yeah, that Ruth Bader Ginsburg thing going on there. What does Monica say? Thank you so much, Monica Mo Justice. I appreciate you stopping by. She says, from my point of view, they should be working through the weekend to get everyone's ducks. But they've had 10 days though. I don't even think the 2 days of the weekend are sufficient. They literally have had 10 days since we were introduced to Judge Whitaker until Tuesday. They've had more than sufficient amount of time to start plowing through this. And they came in, actually, in my opinion, less prepared after the 10 days than they did after yesterday. So 2 days ain't gonna do anything for them. They don't have a case. They're all over the place, from Woody getting shot at to shooting up the tour bus to everything else under the sun. Let it go. If this is the case, because please keep in mind, last thing, the jury is not here. They're going to have to do all this again when the jury's here. And they're going to be looking at those men and women who are going to be looking at them like, what the heck are you talking about? 2015? What? They're going to be looking at them like they're crazy. This is going to be a mess. That's if the jury actually gets back in. It's so obvious, Robin says, this case is all about Donovan Thomas, right? Big nut, nothing else. Fontenay's fingerprints are all over this. So why are we talking about all these other things, though? That's the part I don't get. Maybe I don't understand the process. Maybe they have a roadmap to success, and I just don't understand all the pit stops. But why are we talking about the Lil Wayne shooting if you want to talk about Donovan Thomas that was shot? Why? Wonderful commentary right there. I think Laura says she's planning on the jury being the reason she has to call a mistrial. The longer they're out, the more likely the jury is already tainted, because like Shannon is a juror. That's juror number 2 right there. Shannon's a juror. Missy is juror number 9. I'm pretty certain, I'm not confident, but Monica's probably juror number 11. So the jury's in the chat, for crying out loud. It's over. It's done. Throw in the towel. It's finished. All right. Let's see. Wait, but you were saying something. Let's see. Reason mistrial. The longer they're out, the more likely they'll be going to see and to hear what's going on. If they haven't heard this after a month of all of the chicanery that's been happening here in Atlanta, and knowing that I was on the trial, and I mean, you're going to hear buzz when you're at the doctor's office. You're at church at fellowship hour and somebody mentioned it, and you're like, wait, they said what? What happened? Oh, you're at Kroger and you hear it. I mean, come on, there's no way. There's no way they're not compromised. And what does and Doug say? There's absolutely no way after being off for 2 months, the jury hasn't heard or seen all of this mess. And please understand, we're right here in Atlanta. So it's not like they're literally, they drive by the courthouse to go to their favorite Dunkin' Donuts. They're aware of this. It's not improbable. She's showing all parties the need to resolve this matter equitable. I agree. The problem is the state is not prepared. I don't think this case, as I said before, when Paul Howard had this case, the rumor had it that Paul Howard told Fonnie not to do this. And lo and behold, look where we are. Dragging them feet, though. I don't understand why any of Woody's testimony, Laura says, is even in, because he didn't even want immunity and they lied to him. I mean, that's true. And he's also said he was lying to the investigators. I don't know how they pull that off. Robin said, coulda, shoulda, woulda does not equal guilty. Amen to that. Unless your mom is named Belinda Whitaker. Because if I said I coulda, shoulda, woulda, I was still gonna get in trouble as a child. Lil Wayne is like, what? What y'all talking about? Why my name being brought up? Right. So appreciate it. I see. All right, so Shannon has now confessed that he is not the juror, nor is he the shooter. Okay, well, there we go. But that doesn't mean you weren't the getaway car driver. There you go. At this point, all of us are guilty. We're all YSL. It just doesn't make sense. Right, there's a lot of us in here. There's 160 of us in the chat. There we go. RICO for everybody, especially Q. Fonnie came in and she threw RICO charges on you. So I would suggest that you hide. What did Bird? Yeah, I was wondering. I didn't get where Birdman was involved. Wait, it's right here. I want to know what Birdman did to avoid this RICO charge. Oh, okay. I've seriously heard his name more than Jeffries. That's interesting. I don't know. I have no idea. What's going on? What's going on, Cathead? Monica says they don't have the resources, personnel qualified enough to prosecute a RICO related to gang activities that occurred over a decade ago. Can y'all just put Monica in the chat? Let's just go ahead and type Monica. Because I've been saying this since the beginning. RICO charges should be state charges only. Y'all just type Monica in the chat. Just go ahead. Type Monica in the chat. Paula says she pleaded the fifth because she knows she's juror number 7. She knows she's juror number 7. You ain't supposed to even be in here in this chat. Plead the fifth. No, but I agree, Monica. So true. This is too big and it's too arduous. And dare I say, I don't think they're talented enough. I'm not trying to be mean. Maybe they could just say, hey, we think this person shot Nut, and just you know, a small trial like that. But when you throw in at the beginning, there were 28 people in this RICO indictment initially. That's insane. Okay. And now we're here. They got what, 7 or 8 at the moment? They've whittled it down to 7 or 8. And they're getting shellacked. Like, just let it go. You get a RICO and you get a RICO. Everybody getting a RICO, man. Everybody getting on RICO charges. Thank you so much for typing Monica in the chat, because that was a great comment. What's going on, Beth Davis? You know why Beth Davis is late? Because she's juror number 3. You know she's juror number 3. I mean, this trial is done. It's donezo. Oh, really a bunch of horse trading. Q, you really didn't miss anything. Hilton is horse trading. Shard is giving her that work. Sis Wit is throwing a lot of shade out there. And she also was talking about how it's getting hot in here. And she took a comfort break, or what'd she say? A convenience break. She probably wanted to go change that thing she had on. She said 10:30, so we'll see what happens. Yeah, I just do not get it. I have no idea why. I was gone for like 30 minutes. Yeah, we over here causing trouble. Let me see. Like I said, that was about it, the summary. At this point, all of Atlanta is YSL, Monica. At this point, we all YSL. I mean, it's crazy. And I think, I don't think there's consideration being given to why this is probably not the best idea. I understand it's like grandiose and kind of, you know, ooh, lots of star power because you're bringing a RICO charge against a big old gang. But I mean, this is going to probably, however this trial goes, I think people are going to start reconsidering states and local municipalities bringing RICO charges. Because it's just, I mean, this is the longest running case in Georgia history. And so I'm going to probably say it's going to probably end up being one of the more expensive as well. And mind you, we're nowhere near finished. We're not even at the halfway point. So unless Judge Witt really gets about it and cranking, let's say they get the jury back on Monday and they really get cranking, this case is going to go all the way through 2025, unless something really, really different happens. So yeah, I just don't see how this is, and it's sad because Fulton County is paying for this. I'm sorry, but I don't think some of these guys don't even know what RICO means. They just bled out, especially Antonio Sledge. Is sad they didn't have a better counsel. It's very possible. It's extremely possible. I mean, they're using it so broadly. That's why I say, like, the entire live chat could be brought up on RICO following the way that they went about deciding it. That's actually why Black law student wrote that RICO indictment against the Fulton County DA's office, because following their logic, they're a gang and they can be brought up on RICO. The exact same thing applies. I mean, like, that's how wild this is. Do I have that ready? I do actually have that ready. If you're not familiar with what I'm referring to, Black Law Student is a fantastic supporter of the channel. You've seen him. I believe he was a stream sponsor earlier this week. And Black Law Student is a law student, and he wrote a indictment against the Fulton County District Attorney's Office in the name of the whole Twitter community. I'm gonna put it in the chat because I don't want to lose. Let me see real quick. Make sure they're not starting yet. Okay, I don't want to miss out on starting the case back, but I'm gonna put it in the chat. Y'all can check it out. We'll read over. It's super short, but what he did was he took the indictment against Young Thug and them, and he just reverse engineered it and wrote an indictment against the Fulton County DA's office. And the sad thing is that it works for them. That's how crazy it is. The same things that they're writing up or bringing up Young Thug for could be said about Fulton County DA's office. That's how crazy they're using RICO. So anyway, it's super fun. He's not meaning it to be serious. So enjoy it for its laugh sake. Now, if he does, I don't know if they can do that. If they do decide to do that, at least you have this in front of you. So, okay, it is live. Let's go. Oh, she still got that top on. Very surprised. Turn on your mic, sis with it.
I have 5. That is my objection.
You're amending what you did before, that's fine, but before I have for you, page 202, 14 through 20, but you're saying it's.
I have 2, 5, and 19 in my notes. But either way.
Okay.
I can dig that, Amethyst Angel. I can dig that. Andre, good to see you, friend.
Okay.
It's just a off the cuff, not referring to any specific incident of Kenneth and Shannon getting into arguments and then people coming to shoot it down. And then Kenneth saying Shannon doesn't stand for people shooting at him, is my interpretation. And then where does Shannon keep his guns at? Kenneth Copeland says, shoot on him. And that man got a gun every day. He gonna run though. And we're not talking about a specific incident. We're not talking about an overt act. We're just talking about character. Shannon keeps a gun on him. He gets into arguments with people and they shoot at us. Again, not talking about a specific act. Just generally, and Shannon ain't going for it when people shoot at us. I mean, all this is just.
All right, so
very
let's
prejudicial and harmful.
kind of take it piece by piece. So there's kind of like the 5 through 13, and then the kind of 14 through 19.
Yes, Your Honor. So first with 5 through 13, Mr. Copeland talks within this interview specifically about another retaliatory shooting that occurred in January of 2015. Again, after Donovan Thomas's murder, there's an incident in which Mr. Copeland, Mr. Garlington, and Mr. Stillwell, I believe they're all in the car together when and they're driving on the highway somewhere near University Avenue and I-75, and the opposition gang shoots at their vehicle. Either before this portion or after, Mr. Copeland tells the detectives that Shannon was upset with him because he didn't want to shoot back at the other car. So I think when you think about that part of the transcript in context with this, what he's saying in lines 5 through 8, but when I'm saying me and Shannon get in an argument plenty of times because these N-words done came, shot at us, or did something. And what I believe you hear him say, I never did shoot back at him. And so he's talking about that particular
And
incident.
Shannon didn't like that. Yeah, I saw that in other interviews. Okay. And
Yes.
so
we believe that's relevant, that that furthers what he just said earlier in this interview about Shannon not liking the fact that he was
Right.
not retaliating back against the individuals shooting at them. Now, when you go down to 14 through 19, Your Honor, we do not believe that this is bad character, incidental character, Your Honor. We have a case that I would like to cite for the court, which is Lyons v. State, 309 Georgia 15, which is a 2020 case, Your Honor. And this case specifically talks about the defendant in this case thought that the trial court abuses discretion in admitting a photograph showing the defendant in possession of a gun because it improperly placed his character in issue and was highly prejudicial. And the Supreme Court disagreed, and I'll just go to what they cited.
309 Georgia.
15.
Yeah, I mean, is it basically just for the proposition that owning guns and having guns isn't character evidence?
Correct, Your Honor. And what we've also, and it won't, owning or frequently carrying a pistol does not impute to him generally bad character, Your Honor.
Okay.
So the fact that his friend knows that he keeps the gun on him would be relevant, especially in this overall conspiracy and gang indictment that we have before the court trial.
Congratulations.
Anything
My
else, Mr.
church is
Sharp?
now a gang.
I'm trying to
Okay.
look at Lyons
Sure.
real quick because I have a suspicion.
If you have a,
Lyons a convicted felon?
Well, nobody's convicted felon, no.
Your Honor,
This
I
is so
know Ryan
wild.
was a convicted felon, and I have not found a case in which the court distinguishes if a individual is a convicted felon, that imputes more bad character than not. And I don't know if that's the argument that Mr. Sharp is about to present to the court.
Well, okay.
Gun
So
ownership
I'm
does not
reading
mean you're a bad
Lyons
person.
Very quickly, but it seems that in Lyons, there was an argument that the gun in the picture could have been the weapon used in the crime. I mean, that's not what we're dealing with here.
okay, but is it standing for well, whether it stands for it or not, there is a general proposition in the law in Georgia that owning and frequently carrying guns isn't bad character evidence.
Unless you're a convicted felon.
Do you have evidence? I mean, not evidence. Do you have case law on that?
I don't, but
Maybe let's put that issue on pause then, and y'all do some research and get back to me on it, because that is maybe potentially a different issue than just in general. So we'll have y'all take a look into that.
But I'll also point out in Lyons, Your Honor, it says the photograph was relevant to show that Lyons at some point possessed the type of gun used in the crimes at issue. The probative value of this evidence was not substantially outweighed by its prejudice. So it's we don't have the same probative value there.
Yeah. Why are they zooming in on them like that?
All right, well, how about we come back to the 14 through 19 portion of this page with the gun.
And I never argued about the first part of 5 to 13. I don't believe I did.
Go ahead.
But it's, again, we got an intrinsic act of them being shot at that's come out in trial. Mr. Copeland and Mr. Stillwell being shot at.
Right.
I don't know why. I don't understand the relevance other than propensity to show that Mr. Stillwell's a quote unquote hothead. I don't know what the relevance of him being upset that we didn't fire back or retaliate or do something. I'm not following how that's relevant.
Okay.
Did Stillwell, is he being accused of killing Nut though?
Your Honor, it's not relevant to show he's a hothead. It's irrelevant to show that he wants to retaliate against the opposing gang in the middle of a gang war between these two rival gangs. And so that evidence that while one YSL member didn't want to retaliate, this one wanted to retaliate in this ongoing war between YSL and YFN. And he's also charged in another retaliatory shooting later on in 2022 as still part of this ongoing war between these two rival gangs.
They
So
love
from
that war
2015 to
word.
2022, this war is going on, and Shannon is one of the members who wants to retaliate. And I think that this is evidence of that.
All right, well, I mean, it also shows the relationship between the two of them, which I would think is relevant to sorting out his basis for, okay. I am going to permit the 5 through 13 portion in over the objections and don't find it substantially
I
more
object.
prejudicial than probative under 403. And y'all can get back to me with any law you can find on 14 through 19. So we'll remember to revisit that.
You want a case, Your Honor?
Yeah, if you've got one now, that'd be great.
So Hall, Hall versus State. It's old. It's 180 Georgia Appeal 210.
I'm sorry, say the first three, 280?
No.
What did you say?
180.
180, an oldie.
We're going back.
180 Georgia.
Appeal
Oh, app. Okay.
210.
Okay.
And it's 348 Southeast 2D 736. It's 1986.
Okay.
Wow. At least it got Georgia law.
Your Honor, what it says is the defendant stated on direct that he knew what was in the bag. At worst, he admitted only one of the elements of the crime of possession of a firearm by a convicted felon. The simple rule announced by the Phillips Court clearly states that character is not an issue until a defendant admits any prior criminal conduct. However, no criminal conduct could be shown until after is italicized, the prior conviction was admitted into evidence over the objection of defense counsel, because possession of a gun is presumptively lawful. Allowing the prior conviction into evidence in order to place the defendant's character in issue demands circular logic and defies even the broader parameters of the simple rule in Phillips. Here, I'm telling the court that there's an exhibit, I don't know the number, that Mr. Stillwell is a convicted felon.
And additionally, he's charged with possession of a firearm by a convicted felon several times in this indictment. So that increases the prejudicial value because it goes right to a substantive charge.
And
I
to say that he runs around with, I'm sorry, did I interrupt?
Go ahead.
To say that he runs around, he being Mr. Stillwell runs around with a gun at all times, his conviction is back. It's in his
Everybody
case.
does.
Somebody, please help me, but I'm going to tell you it is before the supposed conspiracy even started. The conviction's back to like 2012,
Co-conspirators.
I think, but I'm not sure on that. I don't want to make that right.
The trial, Judge Glanville allowed the state over my objection to actually admit, I think, 5 prior convictions of Mr. Stillwell to establish he was a convicted felon.
Okay. All right, I'll take a look at it over the lunch break and give the state a chance to come up with their own case law on that. And so, I mean, are y'all kind of arguing that this is, and by y'all, I mean the defense, are you arguing, I mean, I know you're arguing, so this makes it really prejudicial because it makes it more, well, I don't know, I don't want to rephrase, but are you saying, well, this evidence makes it more likely that they will find him guilty of possessing a firearm as a convicted felon as charged?
Right, he's charged with, I think, 2 counts. Maybe
Okay.
3. And essentially, Mr. Copeland saying, hey, he always illegally carries a gun as a possession,
Okay.
as a convicted felon. And of course, that is, in our estimation, very prejudicial and shows propensity, which should not be considered by the jury when they consider these specific
All right.
charges.
So on the propensity issue, though, are you saying this is like 404B evidence?
Well, they haven't given 404B notice.
Right, because all of this is intrinsic. And so I'm thinking if it's going to be out on the basis of its, illegal propensity evidence, it would have to not already be in as intrinsic evidence.
Well, my understanding, and I know Your Honor has a long background in appellate law, so I could be wrong. My understanding is intrinsic evidence we're dealing with specific acts. This isn't dealing with a specific act. This is just a gentleman saying, oh,
This man is known to carry
this man
guns.
always carries guns. He always has one on him. So, I mean, it would be like if someone's charged with murder and then like someone just says in a tape, oh, well, this guy's everyone knows he's the biggest killer of all time, you know, and it's just like, well, that's a problem in front of the jury.
Well, okay. So, I mean, this is essentially, to my knowledge, by me, I mean, at this point, Copeland saying, hey, as far as I know him, and I know him, he carries a gun on him all of the time, which obviously y'all would not like to come in because it does make it more likely that he had a gun on the instances in which he's charged in the indictment with having a gun. But why does that get excluded? So y'all find some law and then we'll take it
Right.
up.
Find some law.
after
Don't be just saying it
presented
because you don't
whatever
like it.
You have and after lunch. Because I'm not sure that being able to say, I know, you know, from my own personal knowledge of him, that he typically carries a gun is excludable. Simply
Excludable.
because it makes it more likely that some of the charges against him might be true. That makes it relevant. So I don't know, y'all come up with something, hand it to me later. Let's move on to the next thing. We'll circle back on that one.
Okay, go ahead, Whit.
The next one.
I understand her
So
point.
are we in agreement on 213:20 to 214:16?
It does seem like they're just dragging their feet.
Yes.
You agree, we're in agreement.
Yes.
That it's out. Okay. All right.
And I just want to confirm, we're in agreement 220:11 to 21.
I have 22012 through 15.
Well, 11 just says overlapping conversation.
You said to 15?
Yeah, 12 to half of 15, so we stop after,
Either?
yes.
Okay, all right, we're in agreement. And then 222:17 to 223:6, is that what you have as next?
Yes, 222. Yes, 222 last time, 223 last.
All right, let me get to that.
I still think this is part of the
Sorry, I
problem,
was reading the wrong page.
that they don't have all this stuff ready. I still think this is working really in the negative for the state. This is not working for their benefit, that they're doing so much paper shuffling and cart rolling, all this stuff. They should have all this ready. They've had better than 2 years to prepare, and they've been in the throes of
All
this
right.
for almost a year and a half, 2 years almost.
Your Honor, I'm just going by the transcript I have and the amount of writing I have on it. I don't know if the transcript, this might be one that we need to hear the
Okay.
audio.
Do you want to tell me what your objection is or objections are?
Well, from my notes, I believe that Mr. Copeland is claiming that the game was, something involved in the game was shot up,
Mm-hmm.
and that Jeffrey supposedly told Shannon to do it. Now, this doesn't go to admissibility. I don't know of anything involving the game being shot up, first of all. So I think this is just a big lie. But that being said, the game had nothing. I mean, this is an overt act. The game is a gentleman named, I think his name is Jason Taylor. He is not, to my knowledge, we've heard no evidence that he's affiliated with Lil Wayne or anything else. This is just like a completely separate incident that's uncharged in count 1 and uncharged in any other count as well.
So, Your Honor, as I mentioned earlier, during the period of time when there was the conflict between Mr. Williams and Mr. Dwayne Carter, a number of other artists took sides, and we believe that the game took the side of Mr. Carter. And during that portion of time, we actually have entered into a video in which Shannon Stillwell and Quindarius Zachary are in a video threatening the game. That, you know, if he comes here, he gonna have to come see me, and he's threatening him.
All right.
Now, what they're discussing in this portion, my understanding, but we'll play it, is Detective Dennis asks, well, how is the beef with Game and them?
Mm-hmm.
And Kenneth says the Game was fixing to get his ass shot,
Mm-hmm.
shot up, and Thug would have, if Thug would, and Thug would have and told Shannon to do it. Shannon told me out
It
of
probably
his
says if Thug would have told Shannon to do it, because then it says Thug told him no.
right, and he says Shannon told me out of his
That's not hearsay.
mouth he was up.
Where does it say Shannon told me?
When you
out of
hear
his-
it, so when you hear where it says indiscernible, so I think
Okay.
the last time we heard this portion, there was a lot of dispute in the courtroom as to what it
Okay.
said. So we need to play it,
All right.
and
I also,
we'll believe that's the context that's right.
Okay.
And
but
Doug,
this-
thank you
okay,
so
this
much
is
for the
essentially
memberships. Make sure
somebody
y'all
not
say
doing
thank
something.
you.
Maybe y'all want this in. Well, you wouldn't, but
Gosh.
Mr. Williams might.
But
Make sure you say thank you to
So
N Doug.
why is it relevant? Because it's
so it shows that Shannon's ready to do anything on behalf of YSL is
All right.
why we believe it's right.
all right.
and that's exactly why it's problematic.
Okay. It's problematic. Why is it evidentially inadmissible?
Oh my gosh.
Because it's showing what type of, I'm not asserting this, but the state's asserting is showing what type of person Shannon is. Not that he did this or did that. It's just, as far as the charged acts, it's just showing, oh, he's a hothead that's ready for action. And
Okay.
that's what-
Why is that evidentially inadmissible?
Because it's propensity.
To say this is somebody who stands ready to act.
Well, yes. Well, not only stands ready to act, but wanted to act. On, you know, it's just like,
All right.
it's bad character, and it's, he's not charged with these events, and they're just essentially Mr. Copeland saying he's the type of guy that would do these events. And I just don't think that he's the type of guy argument. I think that just gets to bad character, and I think that's the essence of bad character and propensity. I respect it.
Okay, well, maybe you want to come up with some law that shows me that it's inadmissible evidentially, character evidence, to establish in a gang RICO case or something similar that somebody who's essentially charged with doing tasks for the alleged leader is ready to do such tasks or anything that the alleged leader sets.
And Your Honor, also, I'm going to defer to the tape when we hear it, and I've been notorious for mishearing some things on tapes, but I don't.
Good to see you, Corey.
I'm hearing was shot up, and if that's what's being said, I would ask that the state provide us with some reports about something happening to the game at some point.
Your Honor.
Because I don't know anything about that.
John, can I add
Yeah.
a flavor when you get a chance?
I'm listening.
Okay, thank you. I also think it's important for the court to be aware that the state did not call Mr. Carter, Mr. Dwayne Carter. He's on their witness list. They said that they were going to call him. They did not call Mr. Brian Williams. He's on their witness list. They stated at one point they were going to call him because we have a short list. And evidence came out that, and I don't know how familiar the court is, but when people are in the entertainment business, they advertise themselves, promote themselves, drum up interest by doing things that are, I'm promoting an event for young children, or come to my concert, I'm going to kill somebody. It floods the internet, and it's a marketing tool.
Mm-hmm.
So you're being told like it's proven. It's not proven that there was this feud and Mr. Stillwell is going to do this. There's zero evidence. I've interviewed these people that the game, it's a band. It's a musical band. Game is GAME. That they were shot at, that they were bothered, that there was any issue. This is all the theory of the state. It's also, their real theory is that there's this gang war. I'm just repeating a term, between a alleged gang of YSL and alleged gang of IF. These other people have nothing to do with that. I heard you ask earlier, so this was involved in the, there's nothing. This is just what we've been dealing with in this case. It's just everything has come in on a state's theory without the evidence backing it up.
Yeah.
And then the gang experts, quote unquote, come in and they say, well, this is what we said, and we found out. And I asked, well, who'd you find out from? And they say, I don't know. I don't have a file. I can't give you a report. And that's what we've been dealing with. Ms. Hilton said earlier, oh, and Mr. Winfrey pled guilty to this. That's a subject of emotion that I don't think you touched on yet, but I did an attorney proffer. I sent it to you once you were announced as the Honorable Court taking over. I sent you 8 attachments. And what happened in that is Mr. Winfrey did plead guilty. He was charged in another county, Cobb County, before the Honorable Judge Staley. And he pled guilty. He was charged with a RICO violation, gang act.
Shout out to Cobb County.
He was indicted alone with the shooting on April 26th of 2015. You've been referred to it today as Lil Wayne bus shooting.
Okay.
What the state did, though, was rather shocking. They had Detective Racy on the stand. Over objection, they played a recording from jail of 2 people who are not testifying in the case, saying that when Mr. Winfrey gets out of jail in Cobb County, there's $250,000, $250,000, and a Porsche waiting for him, a Porsche vehicle waiting for him. The state took that with Detective Racy, who was under the directive of Ms. Hilton, and said, well, that's his reward for not folding and giving testimony against the gang. And then Ms. Hilton asks Detective Racy, and within a month, Mr. Winfrey pled guilty. So I asked to approach the bench. There's a case. It's Winfrey versus State in the Georgia Supreme Court. I could get to the site that vacated that guilty plea. That guilty plea was found to be coerced by the Honorable Judge Staley, and it's void and cannot be used. I raised that with Judge Glanville to say, well, how did that happen just now? Judge Glanville would not let me ask Detective Racy about the fact that Judge Staley coerced the plea. It was not a plea. The state comes back after that and compensate, and then within the next year, was there just, for whatever reason, another guilty plea entered by Mr. Winfrey? That wasn't true. It was 5 years later, and Mr. Winfrey entered an Alfred plea, specifically said, I do not admit guilt. This is on the record.
Yeah.
And he had the Honorable Steve Sadow, which is S-A-D-O-W, representing him. And he specifically said, I'm going to trial, except I've been in jail for 5 years and I had a time served sentence. The point I'm trying to make to you, and thank you for allowing me to speak long. I didn't expect to go into all this, but it is, you know, you need the lawyers to tell you what went on because you're catching up and accurately. And just to say that this is intrinsic, this is extrinsic evidence. This is not dealing with the gang war. This is dealing with an issue that arguably it's up to the jury. I understand that. Arguably is all advertising or puffing. And to act like this is reality without giving you the other side is just wrong. So that's what I want.
All right, thank you. I understand that a lot of this, portions of this case, the state's theory is, hey, they may be saying this in the context of promoting or of singing even, but they're talking about real life and we can use it as evidence. I know that the defense position is, and I assume you're going to argue to the jury if we get to that, is y'all, this is a music industry kind of, this is how the business works. And that's all it is. And that's not up to me to decide. That's up to the jury to decide whether, you know, which theory they think is the convincing one and whether the state has proven its case beyond a reasonable doubt or not. So I appreciate the background and I understand that. With regard to the guilty plea that at the time, I mean, he did enter a guilty plea. My understanding is, and I read what you had filed, I didn't know that there was anything still pending in terms of anything for me to decide because that's already happened in this case. And even if his later plea was an Alfred, we all know that an Alfred plea is this, I mean, he may not be admitting guilt, but it can be used. He's saying, I'm pleading guilty because I think it's in my best interest. Man, I've already basically done the time. I might as well plead guilty and have this done and in my past, but it still can be used as evidence against him. So, you know, I may have, I don't know what I would have done with regard to whether I let you probe that issue or not with this witness. But that already happened. So is there anything still pending that I need to rule on with regard to that?
Yes, and this has happened a lot. So Mr. Winfrey, to my belief, is not going to testify either. He's charged in this case.
Okay.
He's in the Fulton County Jail. As I'm going to say has counsel, but now I'm not 100% sure. I believe he has counsel, but I'm not sure. But there's a case. So he's not here. We can't cross-examine him. The tendering of an Alfred plea or a guilty plea or a NOLO plea. NOLO plea can't be used. So
Well,
ignore that.
right.
But guilty plea or an Alfred plea. The person, Mr. Williams, has the right. That's a confrontation clause. That's a statement made in court for purpose of prosecution. That triggers a confrontation clause.
Mm-hmm.
And that's under Overstreet, Overstreet versus State. It's 312 Georgia, 565. Your Honor, it's in footnote 8, 864 Southeast 2D 14, 2021. And in that footnote, it argued a case called State versus Jefferson, like the third president. And what it says is a co-defendant, co-indictee's guilty plea, when they're not testifying, is a confrontation clause violation to be used against, in this case, Mr. Williams.
All right.
So
Let me ask you something. So what he is indicted for in this case, this,
RICO.
right, this, this instant case, that's not what he pled guilty to before Judge Staley and then entered a Alfred plea to later, is it?
He did, because it's also an overt act.
All right, he pled guilty to something that's alleged as an overt act as part of RICO.
That's true.
Okay,
He being, I'm not.
he Winfrey.
Yes, that's exactly
Okay.
right. But, when saying, yeah, but he pled guilty and it came in, none of it, in my opinion, this is my argument, should have come in because you need the person, in this case, Mr. Winfrey, so he can be asked, why did you plead guilty? The juries have no clue. And the state did not put in his guilty plea. So it's all oral over objection. So I want you to understand this, when the state is telling you, and I went backwards, I guess, but the man already took responsibility, pled guilty, we proved all that. They really didn't prove it. They got hearsay evidence, which I objected to, and therefore it's an objection. Judge Glanville disagreed, but it shouldn't have come in. Judge Glanville let it in for a statement against a co-conspirator, a statement against his interests. He's not here. That doesn't apply either. That man's not on
Hates
trial.
Judge Glanville.
Okay, so I'm asking what's pending for me
What's
to
pending
decide.
before you is going to repeat. The state constantly is putting on guilty pleas of people who are not here, who are not going to testify, and then they use it as a weapon against Mr. Williams. So that's one thing. And then the second thing that you're really why I stood up, I just want you to understand, it is not like this has been proven. The game and that they were shot at, it's just a theory. And I understand you're saying, yes, then they have to prove it and it's up to a jury. I agree with that. But I don't want you to just buy into like, oh, this is so important because it's already in evidence and the state needs to,
Okay.
evidence is prejudicial.
All right, thank you. Okay, so I'm not even sure where we were
I
with
think we're
regard to
gonna
this.
play it.
Yes,
We're just-
exactly. Okay,
Your Honor, we're gonna start just slightly before at 12:16:45.
Woo, goodness gracious.
And this will probably be somewhere around page 222, maybe around line 1.
Well, him, he not taking no shit. He not taking no shit from nobody. Well, this, nobody else care about nobody else. You know what I'm saying? Don't take shit from nobody.
Well, how did the beef with Danny then?
The game lead is shut up and do it. We told Shannon to do it. Shannon told me his mother he was up there winning.
Just give me the word.
Yep. And do it to him. No. Say some the GD, I can't Nipsey Hussey, something like that. He ended beef. You know what I'm saying? He stopped. I mean, I ain't here to play. You know what I mean? I just don't want to go to jail. I mean,
And we're gonna stop it at 12:17.
all right, if y'all want me to figure out what got said, then I'm gonna have to have that tape. I'm gonna have to slow it down. I have no idea what he said. I mean, I know a lot of it, but the little part that y'all don't know either, I'd have to listen to it a couple of times. So, I don't know.
You want to play it back?
Yeah.
Something else?
Yeah. Not the whole thing, just that part that is kind of hard to, like line 19, the game fixing to get their ass shot up, as I think, but after that is what the. Before you hit play, is the sound coming out of that little white speaker? Is there any way I could get any kind of a speaker closer to me? I mean, is that where that's coming from?
I can't, Nelson, Hersey, something like that. He can't be.
It may not move far. In which case,
I think that's about as far. Your Honor, but
it's not gonna do much. So just put it back where it was.
This is
Thanks.
hilarious. This is hilarious.
Your Honor, I don't know if we can play it slower in evidence review, but I can play it multiple times as evidence reviewer.
Oh my gosh.
I'm trying to do that. Whoa. She not taking no shit. He not taking no shit from nobody. Well, this, nobody else care about nobody else. You know what I'm saying? Don't take shit from nobody.
Well, how does it beef with Danny then?
The game lead is shut up and do it. We told Shannon do it. Shannon told me
Alright.
to use all that win.
What I hear them saying is the gang fixing to get his ass shot up if Thug had told Shannon to do it.
And I think it's the next.
Okay.
That's the most concern.
That's what it said. Let me tell you what he said.
And do it to him. No, say turn on and do it. The game
This is
lead
crazy.
is shut up and do it. We told Shannon do it. Shannon told me to use all that win.
Just give me the word.
Yep.
Shannon, nobody's something
The
like
game lead is shut up and do it.
if Thug would have told Shannon to do it.
Well, how does it beef with Danny then?
The game lead is shut up and do it. We told Shannon do it. Shannon told me to use all that win.
Just give me the word.
Yep.
I hear.
A theory?
They told me out of his mouth.
Okay, well, I assume that matters. So I will listen to that in my chambers where I can actually hear it a little better. So we'll have to revisit that as well, but go ahead.
I'm not trying to beat a dead horse here. I think that when it comes down to it, my objection is that, first of all, anything involving the gang is not charged, is not in the indictment at all. So it is extrinsic in my estimation. I don't know how this fits into the story or is needed to complete the story. In addition, it is bad character evidence about my client. It's a prior, if it's extrinsic, it's a prior bad act as alleged. And also, I'm not hearing the told me out my own mouth. So there's speculation involved as well, or, I don't know what the source of his knowledge is, but he's not saying that he was with Shannon waiting on the game. So there's that issue as well.
Okay, so with regard to that issue, they probably are not doing police questioning, thinking I need to establish exactly who everybody. It may be that through this, we don't know. And if it comes in, you may just have to ask and maybe establish, or maybe beforehand, what was the source of your knowledge when we have Mr. Copeland and not the jury, and we can find out, is it total rank hearsay or is it not? I don't know.
As long as we're allowed to do it outside the presence
Yeah.
of the jury.
Okay, and then with there being a prior bad act, there is no act here, so it can't be a prior bad act.
Well, the act is
Being willing to do what Thug says.
Mr. Stillwell is, according to Mr. Copeland, is waiting, I don't know where, waiting somewhere to shoot another individual. That's an
I'm
act.
not sure it's a crime to be willing to do it if you don't do it
No,
unless.
I'm saying waiting, not, I heard waiting, like he was in, I don't know, I'm just making this up. I'm speculating, but an alleyway or something. I hear he was waiting.
Okay, I don't think that's what it said, but I'll re-listen to it. Okay, let's move on to the next one.
The next one. We agree with, based on, of course, prior ruling, cover that page 231, line 5 through 233, line 22.
I think it should start at 230, line 20.
Yeah, 230, line 24.
Well, 230, line 20 says, this is Mr. Copeland speaking, that car that they're saying shot the tour bus. That seems pretty clear to be hearsay.
That's fine, Ryder. Page 230, line 20.
And where did you say it ended?
More paper shuffling. More paper shuffling.
38, line 20.
This is,
Really, 239, line 2.
yeah, I think I agree with you. Wait, what? I don't think that's what I heard, but at this point in the game, like, what are we doing? This is craziness. This is
All
preposterous.
right,
We're in agreement with that.
all right.
Next, I have that we agree upon page 243, line 9, and page 256, line 7.
I have 241, line 3. Where we get there, to 242, line 21.
That was,
It's talk about one of Pee Wee Longway's people shooting up a club named La Cura, which is on Metropolitan, and Kenneth Copeland was initially blamed for it, but it's just talk about that shooting, and then there's talk about Tick, who's Trontavious Stevens, robbing Bentley, who's known as OG Bentley, who is Kelvin Treadwell. It's just a bunch of, I presume, rumors, because I don't think Mr. Copeland was there, about completely unrelated things that he's heard.
okay, so 241, line 1. through 242 line 14.
I have 242 line. Yeah, that's fine.
All right, so y'all agree that's out? Yes, no?
Oh,
Okay.
yes, I'm sorry, no. And then Ms. Hill, the next one I have is 243 line, I'm going to say 1 because I don't have a line. 243 all the way to 248 line 11.
All right, so I'm glad we're doing this. What I want y'all to do is get together beforehand and everything that is agreed to, y'all agree that it's agreed to, so that we spend the court time talking about the stuff that's not agreed to, okay?
I agree.
Yes, Your Honor.
I
I know
agree.
y'all are doing the best you can, but
No, they're not.
try to do better.
They're not talking. That's the problem.
Not agreed to, but I can do one, two, that I think is
Oh, really?
page 321,
No
line
way.
21 through 23.
All right, let me get there.
Yeah, flood some heart emojis in the chat. We need some love up in here. Might need some bless your hearts in there.
So,
Okay.
Poor woman. She sounds so tired. She sounds so tired of this foolishness.
Is the objection speculation?
We appreciate you. Thank you so much, Red. Thanks so much, Red Jacks.
yes.
So,
Like personal knowledge.
so here, Your Honor, he's repeating, this is a part of co-conspirator. This is the night of the shooting.
Mhm.
Murder Donovan Thomas.
Okay.
And he's repeating what Demetrius told him regarding what happened with the murder. And specifically that line where he says, I guess that's where Thug went.
Mhm.
When you listen to Kenneth Copeland, it's not speculation, because this is what.
This is just the way he talks.
Look at line 24, he says, and when Thug was at Bentley spot, which was more of an affirmative, this happened based upon what Demetrius told him. So this is all in relation to what we argued the other day regarding co-conspirator.
Where is the state getting that he got this particular information from Mr. Garland?
Because throughout here, he talks about, this is what Demetrius told him when he got into the car with him and explained the murder to him once they got to the car.
I thought when they got in the car, all they had time to say was they shot nut. And then like some other little tiny bit after somebody else got out of the car again.
And then that's when they drove up to
Sky House or wherever.
And Nard got out the car. And it's our understanding that's when more detail came in.
Okay, and maybe you're understanding, where is the evidence that all of that got said in the car? You might need some time to come up with that.
I'll look again, but what we do know is that he says in this interview that Demetrius told him everything that happened that night. Now,
All right,
whether
well,
in the car or not,
I mean, if you show me the part where he says, D told me, what's his name? What's his little D from Mechanicsville, told me everything that went down that night, then we're in a different situation.
So, visiting.
20. All right, so I see if we go up a page on 320, around line 9 through 13, or really 17, 18. That he's at least saying Dee told me this is all the people that were involved, and he personally knew it because he was with them.
If we go to page 318, Your Honor.
Okay.
Line 10.
Right.
And he says, this is what little D broke the story down. He said, and then he goes into what Demetriana said, which is all of them leaving the Sky House and said they rolled past and met outside. They went somewhere to change cars, and that was it. I dropped Shannon B on the Doug's house, and he continues to elaborate.
Right. So that's all what happened beforehand.
Right.
And I think,
That's why I didn't object. No.
Right.
I'm objecting
So,
to co-conspiracy.
I understand. So I understand. So where's the part where we have any kind of foundation that, and I mean, maybe it's just in context, it's clear he told him the whole thing from start to finish. Maybe, but y'all show me where that is. I mean, I guess Lil D broke the story down, maybe.
Y'all show me where that is. Translation, you don't have any case law.
Our understanding from this interview is that the breaking down happened in the car.
What doesn't matter where it happened, as long as it did happen, as long as you have some evidence that shows he told him all of it.
This, yes, from
Okay.
everything he says to the detective in this interview, everything about that murder that night is what.
This is, okay, this is him saying, here is what he told me. Okay. All right, I'll take a look at it more in context over the lunch break. But that seems to be a pretty good basis for arguing that.
And he says it early, so this is the second time he's telling the story, so for the purpose of this interview, Your Honor.
Okay.
He tells the story initially early on in the morning to Detective Gaither, Detective Dennis.
Yep.
And Detective. And then later they bring in Detective Thorpe, who was the homicide, the lead detective on the Thomas case. He reiterates the story again with a little bit more detail in front of Detective
Okay.
Thorpe. So he's telling them all.
All right, and he's already said, I got it all from Lil D. Okay, all right,
Lil
I mean,
D.
I think that is satisfactory, as, yeah, he had a source for this.
The next.
I have 341 to 341, I think 19 to 350, 17.
Is that the whole BB?
Correct.
Yeah, that's not an issue.
Okay.
So that is out by agreement? Okay,
And then 356, 9 to 19 was the same issue, I think.
Yes, I think I have the full redactions, 341 line 19 through 350 line 13.
What about 356?
Yes, 9 through 20.
Yes. And Ms. Hilton, the next one I have is 361, line 1 to 362, 10. I don't know if we had agreed to that.
What I have as the final is that we were going to take out 361, part of line 16 to line 17, where it says Shannon shot up that tour bus.
Say the lines one more time.
Half of line 16 and a portion of line 17, the sentence reads, Shannon shot up that tour bus.
I
So
agree.
that's out by agreement.
Amethyst.
There may be another part we need to take up, right?
Right, well, part of that, Detective Thorpe says, listen, this is 362 lines 7 to 10, which was included in my objection. I guess the state doesn't do it then. Detective Thorpe, listen, but you said a key piece of stuff we've been asking you. You said without a hesitation, without a doubt, Shannon the one who shot the gun. And then Kenneth says, y'all keep thinking I'm doing stuff. And I'm not 100% certain on the context as I sit here now, but it's right after discussing the Lil Wayne.
Well, what I believe is happening in this portion, Your Honor, if you go back to 361, Kenneth is elaborating that he's not the problem, it's Shannon. And so he goes on and he's saying Shannon is doing everything. Specifically, he says Shannon killed Nut, Shannon shot that tour bus. Based upon prior ruling, we know that should come out. Then he continues to go on. And he's saying, I ain't retaliate one time, now I'm on 362. And then Detective Thorpe, I guess, is trying to clarify, says, because you just said a key piece of stuff we've asking you, you said without a hesitation, without a doubt, Shannon the one who shot the gun. Because, and this will be speculation on my part, but I think because he's the investigator of the Donovan Thomas murder, that is what he was focused on. And then Kenneth Copeland doesn't even respond. He just says, y'all keep thinking I'm doing shit. I'm not doing nothing. I'm telling you, I'm fixing to go back to jail. I'm not trying to hurt anybody. Right. So he doesn't even respond to Detective Thorpe.
So maybe we could just take that part out then?
It's right.
The Detective Thorpe part?
Well, without a hesitation.
Yeah, okay. So why don't we just take out 7 through 11? So 362, 7 through 11. Or 10 or whatever. 10, I guess. Okay.
Yes.
All right, next one that we have dispute about.
The next one we have this.
Yes, because y'all can spend your lunch break talking about the ones you agree on. And then you can come back and put it all on the record. I guess if you don't know, then we have to talk about it now.
365 lines 6 through 8.
$365.
Why am I on mute? I still don't get it though. I don't understand.
Yes,
But-
that's in this. That's in dispute.
Okay, so, Your Honor, on 365, 6 through 8, the context of this is,
I think this is a very good point.
Also known as the other little dude, from Cleveland. He allegedly would buy, he's not a convicted felon, he allegedly buy guns. At some point, he bought a gun for Kenneth Copeland. Kenneth Copeland allegedly, Kenneth
Mhm.
Copeland ends up getting arrested. Then he wants to get the gun back, but then wants to get rid of the gun. And it's a gun that's later, my understanding is later, Kenneth is arrested for because he's carrying it to
The rec
from
center.
our rec center and leaves it in the bleachers.
Mhm.
Kenneth is saying that Jeffrey told Quindarius to buy the gun back from Kenneth.
Who's Quindarius?
However, Kenneth was incarcerated throughout that period, my understanding. So I don't believe he's speaking on firsthand knowledge. He's just speculating or passing on hearsay that Jeffrey instructed Quindarius to buy the gun back from Kenneth. I don't believe he has any firsthand knowledge.
So I have a different analysis. I believe that they are talking about initially buying the gun from the pawn shop. So if we go, but they're talking about the fact that Quindarius buys the gun, specifically most of the guns from Arrowhead Pawn Shop. And for the reason that Mr. Shard stated, the state believes because he was not a convicted felon, he would purchase a number of the guns on behalf of YSL members. And what the detectives are saying to Copeland is, you told him to buy the gun.
Right.
And he said, no, Thug told him to buy the gun
Uh-huh.
Initially. And then later on, there is some conversation about Mr. Copeland was arrested and he was going to try to sell the gun, which when he got out, and that's how he ended up.
Yeah, this looks like the buying it to begin with, not the buying it back afterwards.
Well, either way, Your Honor, I don't see any indication that it's anything but hearsay. And here's the other thing. Quindarius Zachary is apparently going to be called. So Quindarius Zachary would certainly have firsthand knowledge of who told him to buy a gun. And right now we have Kenneth Copeland on an out-of-court statement, possibly speculating or passing on hearsay. And it seems to me that we would have a live person on the stand that could answer that question pretty clearly.
My position is, one, if this statement comes in, it'll be contingent upon us asking some foundational questions on the stand first. And then depending on what his response is,
Okay.
this would probably be a prior inconsistent statement, depending on what his answer is. I don't know what it will be, but we can lay more foundation as to when, how did this come about? How does he know Doug told him to buy the gun or not?
All right.
I would just ask that the foundation is laid
Outside the presence of the jury. Yeah, absolutely. Outside jury. I just wrote that down. Okay, so we'll need some foundational
Jury.
questions
Got that on.
on that.
This is crazy.
Assuming you can lay the right foundation that he actually knows it, then he ought to be able to say it, but we don't know that yet. All right. Hang on just a second. Miss Winfrey.
Turn off your mic. Yeah, you're right. She said that. All right, so I don't know where they're going to go next. This just seems very nerve-wracking. Poor Judge Witt, she's got to be pulling her hair out about this. Like, what in the world did I get this?
Portion.
It's not as much downtime as Glanville had, but I totally agree with you.
there was a portion of, so page 370.
I can totally see that happening.
375 line 17 to page 376 line 9. The state only had an objection to page 375 line 17 through 19. Defense counsel wanted that line out. That Mr. Copeland says Doug is connected to a lot of people. We wanted that portion in. But that was.
I don't have a problem with that. And then 375.
All right, so hang on. So all of 375-17 through 376-9, there's no objection to, is that right? Is that right?
Yes.
Come down, right?
Okay. Wait, coming out or staying in? Y'all seem to be
Agreed that it
saying,
comes out. We're agreeing that it comes out.
Wait, hold on. 375 lines 1 through, you said 1 through 9, Your Honor?
no, I'm saying what you said.
Oh, I'm sorry. Yeah. I thought I heard
You said
that.
375 line 17 through 376 line 9. Are you agreeing that all of that is in or all of that is out?
Everything from 375-20 to 37, everything from 375-20 to 376-9 is out.
Out, okay.
I agree.
All right. All right, what's next?
I have 378, 1 through 8.
You said 378, 1 through 8? Yes, that is.
Agreed, out.
No, that's in this.
Oh, okay. All right, tell me why that's in. Oh, I see, that's not the detective saying 7 through 14, that's Mr. Copeland.
Yes.
So then, Mr. Sharp, tell me why that's out.
Well, two reasons. First of all, it's speculation about what other people will say. And also it's a comment on individuals' right to remain silent. I mean, they're asking, we call people in here, who's gonna tell, who's gonna give it up, and then he just speculates. And I don't think that's relevant. I don't think that's appropriate. So I don't know why it would be admitted.
What's the state say?
Your Honor, so this is a portion, if you look at right before, on page 377, the detectives are asking Copeland, specifically talking about the murder, who do you think we can call in, who will speak to us about the murder? And what Ken Copeland's response beginning on page 378, line 1, put it this way, Thug and them already knew those 4 right there, they're not going to tell. He's talking about Yak, Nard, Shannon, and one other, and it's slipping my mind who's the 4th person. And he says, I don't know about doo-wop, but them niggas not gonna tell. That's why they not saying it. You feel what I'm saying? I understand why everybody doing this stuff, but I at least want to make a way to be like, well, Woody told us, you feel what I'm saying? This is a YSL member who knows the individuals in which he is around. He knows who will come and talk to the police and who will not. And who will protect the enterprise. And that's what we believe he is telling them, like, these people are not going to talk about our activity. So there's no use in you trying to speak with them because they're just not going to talk. And Thug knows that they're not going to talk as well. As it relates to commenting on pre-arrest silence, Your Honor, I'm looking at an 11th Circuit case, United States v. Reeves, REEVES 742, Fed Third 487, which is a 2014 case. And I
Sorry, just tell me that whole site again.
sorry, and if I went too fast, I apologize. United States v. Reeves, 742, Fed Third 487.
Okay.
And the key holding that we have is the government may comment, and it's really on a defendant's silence if it occurred before the defendant was in custody and given Miranda warnings. In this case, at this time, none of the defendants were in custody at all. They were still investigating the homicide. At this point, no arrest warrants were even taken out. During this interview in June of 2015, warrants were not taken out until October of 2015 for the murder of Donovan Thomas. So this would not be commenting on any pre-arrest silence, Your Honor.
Okay. So aside from the pre-arrest silence objection, what other objections do you have?
Well, it's speculation, and it's also, I guess, relevance. Like, why is Kenneth Copeland giving why would a jury hear an out-of-court statement by Kenneth Copeland about whether my client will give a statement to the police or not?
All right, so y'all had pointed me as the objectionable portion to 379 lines 1 through 12.
No, 378. I'm sorry.
Okay. That makes a lot more sense. Okay.
Bless her heart.
All right, I don't find it to be any kind of a pre-arrest silence kind of potential
Pre-arrest
violation.
silence.
And this is his opinion as to how strong they're going to be with backing up and keeping silent about what the gang is or is not doing. I think that that's permissible for him to say. I don't think, it's only speculation to the extent that anybody's opinion about anybody else is speculation, but it's valid to come in. So I'm going to permit that in. What's next?
The next portion that I have that's in conflict is page 386, line 20 through page 387, line 12. And
Silence.
Is that in dispute?
yes, yes, Your Honor.
Okay.
I don't have the dispute quite as broad. I just have the dispute over 387 lines 6 through 13. And it's just simply hearsay.
So, Your Honor, the state would say that this is not hearsay. We're not offering lines, page 387, lines 6 through 12 for the truth of the matter asserted. When you go back to page 386, Mr. Copeland, I think it's around here, he starts to explain that he never had an issue with Donovan Thomas, like that they've had conversations with each other. And some of the subject of that conversation was Mr. Copeland's relationship with Mr. Thomas's brother, Kelvin Watts. So when you get to page 387, lines 6 through 12, he's telling them about a conversation that he had with Mr. Thomas prior to his death. Now, whether or not Mr. Thomas said, I'm going to go holler at them, or whether or not Mr. Thomas did go holler at Kelvin is not what we're offering it for. It's solely being offered for the fact that they engaged in conversation that was amicable prior to his death. And so we're not offering it for the truth of the matter asserted.
All right, so it's on 386 where he's talking about actually having the conversation with Mr. Thomas, right?
Yes.
Okay, and that's fine. That's not objectionable to the defense. So the part that they're objecting to is the part where, I guess, who is it that's walking up and saying this? Shannon, right?
No, so when we go to 6 through 8,
Yeah.
he's saying that Shannon was right there in the presence when the conversation was happening.
And it's Shannon who says, if I'm understanding it right, man, what's up with you and Kel, right?
No, it's Donovan Thomas.
Oh, and he was like.
And he's referring to is Donovan Thomas, so.
And I agree with her.
Okay, all right. Okay, and so you're not offering it for the truth, you're offering it for the fact that Kenneth Copeland and Donovan Thomas are cool with each other.
Yes.
All right.
Well, I mean, that already comes out in 386 that they had a conversation. My objection is when Kenneth says what Donovan Thomas said, allegedly said, which is, man, I'm gonna holler at N-word and I'll let you know what's up. Because it's giving the impression that, and it is coming in for the truth of the matter asserted, that Mr. Thomas was playing the role of peacemaker.
All right.
And
So I'm sorry, I don't mean to interrupt, just for purposes of keeping the record clean. So now what we're really talking about is just lines 10 through 12 of 387, right? Okay. So in that, they're saying, hey, man, you got to be offering that for the truth.
I mean, they make their point without, the point that they're claiming to be trying to make is made without that last one.
But I think that gives context when you continue to go further down that page. And when he says, that's what Nut said, and then Kenneth says, yeah, so when me and Kel seen each other, I believe he says, when me and Kel seen each other at the skating ring, Kel was like, well, he wanted to see what Thug got to say. So I called Kel on FaceTime.
Okay.
But give us some more history. In the week leading up to Donovan Thomas's murder, there are a couple of events that
Yeah,
occurred.
I actually am already familiar with
Yes,
the
so-
skating rink event.
So it appears that on that Sunday, Kenneth believes, based upon his interactions with Donovan, that him and Kel are cool. And matter of fact, they actually do talk and have a conversation. And then the next day is when Kenneth Copeland gets beat up at the skating rink. So all this is in context of what is happening or developing those days leading up to Donovan Thomas's death. So I think it puts the second part of this page in context.
But the only way way it provides context.
Is if it's being offered for the truth. Right. I was about to say, so now you're conceding it is being offered for the truth.
Right.
Not whether or not he hollered at him, but the fact that they just had this conversation, whether or not, because we don't know if he hollered at him or not. We just know that something may have occurred, then they saw each other the next day. Donovan might not have ever talked to his brother that day before. We don't know. We're not saying. He definitely went and spoke to Mr. Kelvin Watts once he left that meeting. We don't know. We're not offering to say he did talk to him. We don't know. What we know is the results, whatever that conversation was, there was an amicable meeting between Kelvin and Mr. Thomas that Sunday
Even to the
before.
extent of the discussions about his own brother, it was amicable.
Correct,
And
whatever. Whatever.
Okay. But not for the truth of whether he's actually going to holler at him. Right. All right. Well, that seems like it's then not offered for the truth. So, all right.
There
let me
is.
come in. All right. Let's take a lunch break. I know the lunch is here for the defendants. So let's be back. Will it be enough time, you think, to get everybody fed to come back at 12:20? Not 12:20.
Oh my gosh.
Will not be enough time. 1:20. 1:20. Will that be enough time? I'm asking the deputies. Yep.
All right. 120. That was hilarious. All right. So it is currently 12 o'clock here in the great state of Georgia. Judge Siswit has told us to come back at 1:20. So what I'm going to do, there we go. What I'm going to do is leave the stream on. I'm gonna come back in about 30 minutes. I need to give me some lunch. I'm gonna come back and through Black law students, RICO, as well. Transplanted Texan is dropping some homework assignments on y'all. Dropping some lunchtime homework for you. One of our good supporters of the channel, Phil Holloway from Inside the Law, has a project that he's wants the people to check out. So if Transplanted Texan can drop that in the chat, I'll also make sure I put it in the description so we can and pin. I'll put it in the pin comment, and we'll make sure we support one of our fellow content creators in this LawTube space and as such of that nature. So there's the link right there. Here's the lunchtime break homework. Check out Phil Holloway's breakdown of the outside motions to dismiss filed in the YSL Weinstein. So there you go. See you in 30 minutes, Monica. Thank you so very much. And we'll go over Black law student. Maybe he'll come over and see if he's available to come on. So I'm gonna leave the stream on, but I'll see you all in 30 minutes. Grace and peace, everybody. We're back. Hopefully you had a great lunch. And I guess we're ready for the second part of this YSL trial. I don't even know what's going on anymore. I spoke to two people that are legally minded and know more than me, and both of them said they have no idea what's going on. So I'm feeling really bad about this because I had no intention, did not think this was going to go on this long and be such a dumpster fire. I don't get it. I really don't. I'm really lost, but it is what it is. So I want to thank y'all for coming back. Thank you to everybody who's been hanging out with us today. Really, this whole week has been really interesting. Court week. I mean, we've got a lot to see. We've got a chance to see what Judge Whitaker is about. And I think for the most part, most people are pleased with. They think that she should have gone ahead and called this case. And who knows what's going to end happening in the future. But most of us seem to be pleased with her as a judge, at least in that regard. And I think one of the reasons why we're pleased with Judge Whitaker is she's showing us what we kind of thought already about the state and the prosecutors, that they really don't have a case. Their case is not really as solid as they make it out to be. It's not as rock solid as they wanted it to be. So that's, I feel like, a really telling situation there, that the state, after all this time and all this work and all this man hours and money being wasted, have really just gotten, this is where they are. If I mean, this is where they are. So it's pretty wild. I'm hoping that I'll maybe put together a little compilation of this week. I can't promise because this weekend's kind of rough, but I think that's kind of, I'm sure somebody's going to do that. Of course, Phil Holloway from Inside the Law, he's done a breakdown of the ex parte and what's the importance and why they're, what's going on with those. So I know we gave you that as like homework to do before we left, and that link is down in the chat. Let me find it real quick before we leave. Get too far afield. Here it is, right here. All right, and that's the Phil Holloway from Inside the Law. Him and Rachel are breaking down ex parte communications and star chamber meetings, and it's pretty interesting. So definitely go check out that. I think you'll have a good time checking that out. We might even have some time before this case actually gets started back up. But before we do all of that, I told you we would have some fun, a little bit of not really meaning to be serious here. We are going to look at, okay, hold on one second. I lost my, what I was about to do. Don't allow that. Okay, we are going to look at Black law students filing against Fulton County. I thought this was hilarious, but Black law student, been a great supporter of the channel, has filed an indictment against the Fulton County District Attorney's Office. So what does he say? The whole Twitter community versus Fonnie Willis, Oral Glanville, Adrian Love, Fulton County District Attorney's Office, and Simone Hilton. He made up a case number and everything, bless his heart. All right, the indictment. Let's see, what do we have here? What is going on here? The enterprise, because he's bringing them up on some RICO here. So the enterprise, the Fulton County Star Chamber, the FCSC, is an enterprise consisting of a group of Black lawyers, judges associated, in fact, although not a legal entity. FCSC constitutes an ongoing organization whose members function as a continuing unit for the common purpose of achieving the objective of the enterprise in furthering their personal careers on the backs of Fulton County residents. The history of the FCSC is a criminal street gang started in late 2022. Black law student, you are out of control. This is so crazy. In the Fulton County Judicial Plaza, FCSC claims affiliation with professional Black people, but after research has been denied. FCSC founders were all Atlanta-based lawyers that made FCSC a well-known name by violating defendants' rights and holding secret ex parte meetings. Thus, the following indictment covers all listed crimes below. I don't know. I think he should maybe fill this out a little bit more. Give us a little bit more of the background. You don't have to like true gang leaders and stuff like that. But I think maybe just break us down a little bit more on the background, Black law student. All right. So there's several indictments here. There's almost 29 indictments. So let's go. Conspiracy to violate the Racketeering Influence and Corrupt Organization Act. We know that to be RICO. Okay, I'm sorry. I got a little bit distracted checking out what President Not Perfect says. Oh, okay. Got you. That's fair. President Not Perfect said that Kayla confirmed that the card is always in court. It's not just in the view of the camera. That's fair. I can give you that. I just thought it was funny that it popped up today. Conspiracy to misuse the Racketeering Influence and Corrupt Organization. I'm gonna just call it RICO Act. Conspiracy to misuse the RICO Act to further their political career. Participation in criminal street gang activity. Participation in political weaponization, furthering personal career. Corruption of public office. Breach of public duty or office. Violation of the Georgia rules of professional conduct. Violation of all of Georgia professional conduct. How are these different? Rules of professional conduct and all of the professional conduct. It seems like these two are the same ones. Violation of the United States Constitution. Violation of the United States Constitution, Sixth Amendment. Violation of defendants' rights under the Confrontation Clause. Violation of defendants' rights to a fair trial under the Sixth Amendment. Violation of defendants' rights to an impartial, under the Sixth, I think it means impartial jury or trial rather, under the Sixth Amendment. Violation of the United States Constitution, Fifth Amendment. Violation of defendants' rights under Due Process Clause. Violation of the defendants' rights to a speedy trial under the Sixth Amendment. Violation of the Georgia Constitution. Participation in hiding exculpatory evidence from defendants. False imprisonment under the Georgia Code. Participation in influencing a witness. Violation of the United States Code, Title, whatever that is. Violation of the United States Witness Tampering Codes. Violation of Georgia law tampering with a witness. Group participation in giving a witness invalid legal advice. Participation in violating defendants under Rule 43 to be present during critical states of the trial. Abuse of the ex parte meeting. Having ex parte meetings without defense. Participation in criminal street gang activity. Is that it? That's it. Did you sign at the bottom? So this was Black law student wrote an indictment against the Fulton County DA's office. I thought this was out of control. No one is for, what is that? No one is Rule 4102. Did I read that wrong? Okay. So it should have been the same one. Oh, it's only the first draft. That's cool, brother. Let me tell you, it's the first draft. Let me tell you, we'll let it slide. I think this is great. So if you wonder what I was reading, I'm just going over the whole Twitter community versus Fonnie, Earl, Adrian Love, Simone, and all of the Fulton County District Attorney's Office. This was a little indictment. I don't want to say it's a mock-up, but it was an indictment written by a Black law student. And we appreciate you, sir. Thank you so much. Where are the IG posts? Eight and 9 are different. One has a direct rule and the other one is all of them. Okay, I got you. I got you, my friend. So back to this. I don't know where this is going to go. I have to admit, I have zero clue where this trial is going. To say that we're confused is an understatement of the century. I mean, there's so much that's going on that people are like, I have no idea what's happening. Let me test the audio real quick.
All right, let's
They're
take a
not
lunch
back
break.
yet. They're not.
I know the lunch is here for the defendants, so
I just
let's
want
be
to test real
back.
quick. Drop a 1 in chat. You all can hear this.
Will it be enough time, you think, to get everybody fed come back at 12:20? Not 12:20.
I'm just
No,
testing it.
that
Just
will not be
testing it.
enough
Just
time.
testing it.
1:20. 1:20, will that be
Perfect,
enough
perfect. Thank
time?
you.
I'm asking the deputies. Yep.
Okay, cool. I just want to make
1:20.
sure. You got to do periodic system checks, make sure nothing's changed. Even during lunch, come back, something went different. Funny is Shimalots or she's seen how our current VP rose to the top politically and socially. Fonny's trash is being exposed in real time. Scam a lot. It's history being flushed out. There we go. I got you. Yeah, this is going to be a very interesting, the mix, if you will, the commingling of Atlanta politics and national politics is getting really, really interesting. So I'm not surprised that you didn't see Fonnie Willis around Kamala Harris this past week when she was here in Atlanta. I'm surprised you didn't see her. Now maybe they were, but it definitely wasn't in the news cycle that I saw. But I think it's because Kamala maybe is not feeling her like I thought she was. So I think they do bag lunches. I'm not 100% certain. We'd have to ask like Miss Sylvia or somebody like that. Robin. I'm sure they're probably better than what they get in jail. Better than what they're gonna get this weekend while they are in the jail. I wonder, can their attorneys bring them lunch? Just wonder. So I think this is gonna be wild. I don't even know what to say. I know we were like, yo, I just knew this was gonna go a different way, but it looks like Judge Whitaker is trying her best to get this thing back on track as best she can. And hat tip to her for trying her best. I think she's trying. I do think it's showing again. Though the defense is talking a lot more today, I think a lot of it does go back and look at the defense. I'm sorry, the offense, the prosecution, because they don't seem like they know what they're doing. So, yeah, I think it's telling, and I don't want to keep holding out hope like, oh, she's going to do the right thing, because I'm like, we will see. But let me see what we got. Any other good comments? Did you all get a chance to check out Inside the Law, Phil's project? Him and Rachel were doing over there. Hopefully you all got a chance to see that. And if Transplanted Texan could drop that back in there and remind people to go check it out when they leave, that would be great. She is legit, though. She's legit trying not to quit. I agree. I think Sis Wit is trying her best not to quit. And the defense is like, whatever. But the prosecution, they are doing their best to. I think they are literally trying to scuttle their own case, trying to goad us into it. Oh, shout out to Black Law Student. Even though that was the first draft, you got some good shout outs. So they are all at the behest of Fani. She is Jeffrey. She wants Jeffrey in this indictment. Okay. I really, at this point in the game, would like to know, like, what did Jeffrey Williams do to be indicted, to be in this? What has he done? Because I think that's the question that the judge should ask. Like, at this point, what are your facts of what this gentleman has done to, or any of these gentlemen really have done? Sure, bad things have been going on, but can you tell me which one of these gentlemen are responsible for those bad things? And then let's go ahead and get one of them at least, two of them at least, in the where they need to be. Because it just doesn't seem like it makes any sense at this point. Monica's back. How are you, friend? I can dig that. I can dig that. But in my opinion, I mean, remember she just had Meg the Stallion up twerking for her presidential decency is on the ballot campaign. So I mean, there's a lot of she's got a lot of problems. So I will take that for sure, but it's not that she doesn't have more other problems to worry about. What is going on with Brando's up in the building? What is happening? I was watching Professor Nez last night, and it is interesting to see the difference in temperament in Glanville versus Whitaker. Oh, I agree 1000%. That's not even a real thing. But yeah, I agree absolutely. Whitaker wants work done. I don't know if Glanville wanted work done, but Glanville's camaraderie and familiarity with people was overruling his ability to run this court case. Because I'm telling you right now, I feel comfortable in saying Judge Whitaker's gotten more done this week than Glanville has done in quite some time. Hour upon hour, I think she's got him beat. What is going on? Q in the building. Good to see you. Grace and peace. Wait, it's the ethics. Oh, there's definitely ethics questions on the table. And I do think that Fani and Kamala do, in that regard, do want to probably keep their parades from crossing one another. Totally get that. So yeah, I get your point. Yes, thank you. It's a cold box lunch. Black law student says, but lawyers can bring them lunch also. Okay, cool. Man, Q, they done already put you in the 0-second timeout already. Man, we getting serious over here, man. We believe in that 0-second timeout. You know what I believe in? I believe in putting in some dope tracks. That's what I believe in. Let's see what we got. This is I'll go with this. Just a little bit of background music. Just a little bit. I'll cut it off when the court kicks back up. Court should be kicking in. She said 1:20, so I'm assuming I'm gonna give her room because she's been pretty serious all this time. So I'm gonna believe that she means that. So it's gonna probably be in about 14-15 minutes, give or take. But yeah, here, I'll just drop the link real quick. If anyone has their camera on and you would like to just real quick, give me your perception real quick. I'd love to hear your thoughts. Please make sure that your camera is on. We don't use any profanity or language that is below bar. And of course, we want to keep it on topic. But if you want to jump on real quick, just give me your 2 cents. What do you think's going on? Where do you think this is going? Do you think we're actually going to see a jury? I don't know, man. Maybe so. But there's a link right there. Feel free to let me know or hop on me. I see you right there. MN Cat. I agree. For a woman who doesn't believe in emasculating a black man, Fani's fangs are sure showing. Oh, this is a working lunch, so the prosecution might be late. That's nobody's excuse. I'm sorry. Given the fact that I don't believe they've done much of anything, what they're bringing in here, and I could be wrong. Like Black law student, let me know if I'm wrong. If I think Monica is involved in law as well. I don't know. Do they need to come up with like a day schedule and just say, thank you so much, President Not Perfect. Thank you so much, brother. Grace and peace. I don't know if they need to come up with a day schedule. And what I mean by that is, as a former school teacher, you know, at the end of the quarter, these kids need to learn this, and this. There's a couple topics, some heavy lifting that they're going to need to do. There's map testing, there's standardized testing coming, whatever like that. So then you work backwards from there. And so you make out a plan, and many of our teachers have like lesson plans planned out all the way to Thanksgiving because they already know what they want to teach, and they already have the remediation planned, and they already have acceleration planned, and homework is already laid out. And it's arduous and it's nerve-wracking because you got all these books that you're going through and such. Oh, you're paralegal. Okay. Well, if you want to jump in, Monica, I would love to hear your 2 cents, and I would love to get your insight for sure. So as a teacher, you're planning this stuff out, you know, sometimes quarter by quarter, but definitely for the week. If there's a science lesson that you're going through or science curriculum that you're going through, and you know that it's going to end with this large project, the diorama, the shoebox diorama. Okay. I actually love doing those, by the way. Those are a lot of fun. Most of y'all know what the shoebox diorama is. So you work backwards from what you want the kids to learn so that they can demonstrate their learning with the shoebox diorama. To me, I feel like the prosecution needs to do this. Like, do you have a plan of attack so that at any moment, so any week of my lesson plan, my principal was able to say, what did your kids learn this week? And I could show them the Friday assessment. I could show them the spelling test. I could show them the temp check. I could show them all these little things that demonstrated that my students learned something this past week. And then the following week would be the same thing, but it would build off of the week previous. And every week, the assessments get a little bit more detailed. The information, the artifacts, so forth, get a little bit more intricate, but they're built off of the ones prior to me. But I don't think this prosecution has anything even in that ballpark. I don't think they have any plan to say, if we poll the jury on this day. Oh, okay. All right. Thank you so much. Monica, if you want to shoot me an email, I'm going to pull it up just so I can see it read right here. If you want to shoot me an email, we can plan something one day. I might do a recap tomorrow or Sunday when I do a recap. You're welcome. Absolutely. But I think, and this is just me, again, I'm a pre-K law student. I know nothing. All I am is a retired classroom teacher. And I'm looking at this and it's giving, as my daughters like to say, it's giving that you're not prepared. Okay. It's giving that you're filibustering. I don't know what they're doing. And I personally think that's what Judge Whitaker is expecting. She's expecting them to have their ducks in a row. She's expecting them to say, hey, if you do a temp check of the jury on this day, they will have learned that this person bought the gun, this person drove the car, this person pulled the trigger. And then the next week, now we know that this person drove the car because we have this evidence. We know this person drove the car, rented the car or bought the car because we have this information. And we know this person pulled the trigger because of this. It's like building upon each other. Right now, they're all over the place, everywhere. We over here in jail calls. We over here on Cleveland Avenue. We over here at the hospital. We are everywhere but in this courtroom convicting these 6 men of something. At this current moment, I don't even think she could convict these men that they got dreadlocks. Okay. I don't even think they could convince me that Young Thug has dreads. That's how bad this case is. Let me find a picture and just see. Like, Young Thug don't even have dreads following this. Like, they can't even prove it. Prove to me. Okay, we're going to have like a meta moment. I'm going to pull in a clip. I'm going to pull in a video from my previous video from earlier. So it's actually earlier in the show. All right, this is gonna be wild. So it's gonna look like super crazy. I don't think that this prosecution could convince me that that man has dreadlocks. That's how bad this case is. Prove to me that man has a dreadlocks. Prove to me that this dude has that hat on that says, find your grind. I don't think they can prove it. That's how bad this is right now. Like, get your stuff together. But I don't think, I don't know what, if this is how they do or what, but at this current moment, this dude is bald headed. Like, I could go in here and say, Judge, Young Thug is bald, and the state could not prove otherwise. That's how bad this is. There's no cohesion. There's nothing that looks like we've thought this out. We have a well-ironed, well-executed plan. And again, maybe it's the way I'm approaching it. I know that the way that lawyers think is not the exact same way that the great unwashed handle it, which is fine. I totally understand that. I respect that there's differences in our professions. What I am saying, however, is where is the cohesion? Like, for crying out loud, if you took your car to a mechanic, the mechanic would probably have a plan of attack. Your car is making a weird sound, or there's smoke coming out, or the tires won't stay inflated. They have a checklist of things to do. And we could probably stop them at any moment and say, hey, Bob, where are you in this process? And Bob will say, hey, well, I already checked this. I've inspected that. And now I'm about to hook it up to the computer and see what the onboard computer says. So there's some steps. Now, maybe Bob is so adept and he's been a mechanic for so long. He's, oh, I know exactly what that problem is. He walks over exactly to this place and he makes the adjustment and fixes the problem. Well, that's fantastic, but that's because he's a master mechanic and he's shown and demonstrated, and he can show and prove that he can resolve the problem. I'm going to go on a limb. Fonnie Willis needs to remove these prosecutors and get people on here that can actually do this task. Because I don't think she doesn't have people here that can do this task. I'm sorry, somebody needs to say it. Love and Hilton, and I think his name Atkins, the man that's between them. I'm sorry. If this is what they've been doing, they're demonstrating their complete and utter incompetence. And that's it. There's no reason for them to be doing this, because this is foolishness. It doesn't look good for Fulton County. I live here in Atlanta, and this is not a good look for us at all. Here we go. Yo, thank you, Present Not Present, for joining us as a new member. What's going on? Absolutely, man. Thank you so much. All right, let me see. Y'all are not going to let Glanville rest. And y'all have come up with some great, I really believe this. I do believe that the recused judge was really the lead prosecutor, the 13th juror. I do believe that, because it doesn't seem like, now it looks like this team doesn't have a star player. Who's a star player on the prosecution right now? Who would you say it is? Love, Hilton, Atkins? No, I wouldn't say any of them really know what really are leading this charge. Now, I think we could also flip on the other side and say, on the defense, who is the lead attorney? Who's the lead attorney? It would probably be like a toss-up between Steele and Shard, but we can definitely say the third member would be Weinstein, for sure. It's Steele, Shard, Weinstein. They all seem to be working in concert pretty well to defend their clients against the state. Go back over to the state. Who's running the ship over here? Who would you say is a lead? If you didn't know their proper titles and know they had there was a particular lead there, who would you say it is? I don't know. I have no clue. And I feel like it's part and part is because Glanville was a part of this team. So now they're really missing their star player. They're missing their Kobe Bryant. They're missing their Michael Jordan, because it was Glanville. I know. I think, yeah, and I think this is now coming to light. Third string. Right, but who would you say would be their star? The cart. Y'all are out of control. The cart. YSL Silver Fox. Who's that? Is that the older man? Not the ponytail guy, but the other one. Or the black man with the white beard, the Morehouse man. I don't know. I think you're talking about the Morehouse guy with the totally complete white beard. I think his last name is Matthews. We got to put you, Shannon. We got to put you in 0-second timeout. We got to put you in 0-second timeout because you're wilding out. You're wilding out. Okay, lights are on. Let's go. Let's go. We are back. Oh, well, the camera moved. Hold on. Okay, the camera moved, but they're not back yet. Sorry. Okay, so you're saying, all right, so this is your order. You said YSL Steel, Shards, and Weinstein. Yeah, absolutely. I can rock with that. Absolutely. Absolutely. By the way, 0-second timeout is just our fun way of looking at it. The older man and the client that hasn't been mentioned yet. The older man with the client that hasn't been mentioned yet. If he's the black man or the white, I hate it because the white man's name, he has all white hair and his last name I think is Bott, B-O-T-T, I think. And then the black man that we can see facing us when the camera comes on, he has a completely white beard. His last name is Matthews. And then next to him, I think his assistant, he has like a completely black beard. I don't know his name. Ashley Merchant is the queen of case law. Now that is true. Now that is true. YSL grandpa. Oh, I love it. I love it. Get your behavior together, Shannon. You got to get your behavior together. You got to behave. But just finishing it up before they come on, that's where I think and I'm not saying I want this case to go out because I just want it to go out and I want to be right or anything of that nature. It's so poorly executed. There's no reason to believe that justice is being served. It's kind of like, again, back to the classroom example. Sure, you got activity going on in your room, but there's no learning going on in your room. So we need to do something different because we can't just have activity. We just can't have people doing things and not actually learning what is needed to be learned. And I don't think that I'm not putting learning and justice on the exact same plane. I think you all get my point that I don't think justice is being served here in this courtroom. And maybe it'll go all the way to the jury. I don't know. At this point, I'm just taking my hands off the wheel and say, take the wheel, Jesus. I don't even know what's going on. But I think within reason, I think Judge Whitaker should declare a mistrial with prejudice because the state really truly has no idea what they're doing. The tall attorney representing Nichols. Okay. He gets to tell the judge direct. Oh, here we go. Fire in the hole. All right. Say something, Sis Wit, so we can make sure that audio is good. Okay. Drop that one in the chat.
All right. So over the lunch break, I did not get a chance to do any of the things that I told y'all I was going to do. However, one thing I did do was work on the further revision of the jury instruction. I saw that the state had sent over a couple of different proposals, and I thought a part of those were good. And I'm just going to tell y'all, I'm just going to read out what I've come up with, which is a little bit from here and a little bit from there. Ladies and gentlemen, my name is Judge Whitaker. Judge Glanville is no longer the judge presiding over this case for which you have been selected and sworn to try. I will be the presiding judge in this case moving forward. You are not to concern yourself with this change. And I propose to say, and to calm any concerns, Judge Glanville is fine. Because if I don't say something like that, they're gonna be like, oh my God, did he have a heart attack? Or, so that way nobody's searching on the internet. Okay, then let me remind you, as I assume presiding duties in this case, that none of my decisions and nothing I say during the trial is evidence, just like none of Judge Glanville's decisions and nothing Judge Glanville said during the trial is evidence. The decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in the case. I am only interested in seeing that this case is tried fairly based on the laws and the Constitution of the state of Georgia and the Constitution of the United States. You are to disregard any comments that may have been made by Judge Glanville about any of the lawyers in this case. To maintain the dignity of the jury system, I remind you that you must decide this case based only on the evidence admitted during the trial and the laws I will explain to you. Thoughts, objections?
I do not approve.
Being inconsistent with what Mr. Williams filed yesterday, which I know was part of the file, we would object to. I think that it's important not to say that don't worry about it, Judge Glanville is fine.
Okay, well, I just mean, if you want to come up with another way to say that, that's fine. Do you not want to say anything at all? Just.
I'd like to say what I wrote. He's been removed from the case. That's it. It's not disparaging. It should be disparaging, but it's not. It's just since he's been removed.
Well, he is no longer the judge presiding over the case. I think.
Isn't that what he said?
Says that. All right.
Oh, love.
Mhm.
You were very kind in emailing us transcripts like June 7th. Is that, can I ask you, do you know if that's in the record?
It is not yet because it was the rough. Are you talking about of the ex parte? No, when Ms. Weaver sent it to me on request, she said at the time, this is still rough. So as soon as it's ready in final form, I can ask her to file it, but it's not yet.
Thank you. It's just because we've been referring to it.
Sure.
In an appellate court meeting.
Now, it will get in the record.
Thank you, Your Honor.
All right.
Your Honor, with respect to the instruction that you are to disregard comments that were made regarding any of the lawyers, the only concern I have is that, of course, the judge ruled on objections, and in the ruling, I don't know if anyone could perceive any of that as comments. I know it's kind of silly, but it's plausible. And I would ask that the court, with respect to the pattern or the altered pattern instruction, instead read the decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in the case. The court is only interested in seeing that this case is tried fairly based on the laws and the Constitution of the state of Georgia and the Constitution of the United States, rather than.
I am.
Right.
Is that the change you're talking about? Instead of saying I am, say the judge is?
Correct. That, and instead of saying disregard the comments that the judge has made, instead read the decisions and remarks of a judge do not mean that the judge favors or leans to one side or another.
So you're saying just say that, don't say disregard.
Right.
Okay. I'm overruling that.
Okay.
So neither side's happy. So that probably means I did a good job.
Well, the court, is the court considering, instead of saying I am, saying the court is? I didn't know.
That's fine.
Okay.
I don't think that's a particularly substantive change.
Love isn't getting put in her place. I'm sorry. She getting put in her place.
That takes care of that. And we were on. I think we had finished the 387 lines 10 through 12, and we hadn't moved on to the next thing yet. So let me know what the next portion is.
Yes, Your Honor. We will actually have to go back a little.
Okay.
Mr. Shard and I had the ability to meet
Okay.
during the lunch break, and we did discuss those redactions that we agreed with, and there were a few early on that we realized we still disagree with. So,
Okay.
The first, Your Honor, is page 266, lines 14 through 24.
Okay.
My stance, my belief is that this goes back to the issue of the hearsay about what he believes, quote unquote, Doug, Mr. Williams, said to other people. And so really the key part of this is, the last section. So Doug was like,
Yeah,
that gun, you know, and it just.
it looks
We need to know. Yes.
that, yeah, that's definitely nothing but hearsay at this point, and we have no idea. So that we need a foundation.
I got a foundation. It's
And that
called,
also
you have a foundation of
outside the
mistrial.
jury. Agreed. All right.
Your Honor, page 270, line 4 through 18.
You know, I stand by my objection to this, but in candid court, or I actually can't say the page number, but previously stated that, Mr. Copeland's statement said Shannon was in possession of the gun, would be admissible over my objection. I think this falls under the same.
Okay. So you're just making the objection to this part as well. All right. Thank you.
So the next, Your Honor, I think we're back on track, and we're
Okay.
at page 389, lines 1 through 17.
That's a good question, Laura. I don't
let me
think
read
so.
it. Give me just a second.
I object. You know, they've been asking to see the order for his immunity and what were the stipulations of it. Nobody's seen that actually.
Okay.
So if you go to just the last line of 388, back it up.
Yeah.
It says, they're asking who's talking about the Donovan Thomas case. And he says, I never heard Shannon talk about it. He says, I heard Nard talk and laugh about it. You know what I mean? And he doesn't say what Nard said. So there's no statement. The fact that I've heard Nard laugh about it, we don't know the context of it, but that may be admissible.
Laugh?
Against Nard, his name is Demise McMullen. He's on the indictment, but he's not sitting here with the rest of these gentlemen yet. So we think it's inappropriate to talk about how Nard has reacted or Demise McMullen has reacted to this.
Can I ask, so it's either in evidence or going to be in evidence, all of the people that the state alleges committed this particular alleged crime, right?
What is the
I
crime?
mean, the jury's gonna know, they think Nard did it, that they, the state, think Nard did it?
Well, I would say the state thinks Nard did it. The state in their opening statement has standing by my objections about Kenneth Copeland's testifying about what Mr. Darlington said. But that's their stance, that Nord was there and involved in the car. But, so yes, I would agree that that's their theory. I don't know what the evidence is going to show or how strong the evidence is going to be, but again, his reaction to this and laughing about it is prejudicial to our clients and irrelevant because he's not sitting here with us.
All right, I'll hear from the state.
Your Honor, we do allege that the person he's referring to as McMullen is a member of YSL and one of the individuals who shot and killed Mr. Thomas back on January 10, 2015. And so what precedes this conversation or this portion of Mr. Copeland's, what he tells police is that they ultimately brag about the fact that they killed Nutt, either by laughing or Mr. Williams' sister. We believe that that's a person by the name of Max. We believe that she is an unindicted co-conspirator in the YSL gang enterprise. We have put in evidence already phone records of Miss White, specifically with the Little Wayne bus shooting, that she was in the vehicle following that bus, so actively being part of the enterprise. We believe there'll be a jail call that's going to come in regarding some comments that she made specifically about the murder of Donovan Thomas. Basically claiming that they were the ones responsible for killing Donovan Thomas. And so these statements corroborate that ability for this gang to be cohesive regarding a crime that they have committed, and talking about it freely amongst themselves, we believe would show cohesiveness with the gang, would show, and that would be in furtherance of this gang cohesiveness.
Okay.
So now I understand that the statements, the argument for admission is A1B2E. I don't understand how states arguing that Nard, according to Mr. Courtroom, saying, laughing and saying, man, F that B, furthers conspiracy in any way. We don't know any of the circumstances around when he supposedly said this, who was around, or how that would be speaking for anyone other than Mr. McMullen himself. And then when we get to Max, who she allegedly said something about, and I guess this was afterwards, according to Mr. Copeland, I don't know. You better not play with my brother. We're really getting to the conclusion that these are statements in furtherance of conspiracy. These seems to be individual statements, just what they think about things. I don't know, maybe Max doesn't like Mr. Thomas, maybe Max does like Mr. Thomas, was mad, but Max is not, it's not a statement by a co-conspirator, it's not furthering anything. Max and Nard do not speak for Mr. Stillwell. Mr. McMullen laughing is not an indication of how Mr. Stillwell feels about anything. And neither of these two individuals, Max or Mr. McMullen, are seated here today. So I don't know why it would be municipal.
Okay, so, well, because it's alleged to be a gang and it's alleged to be RICO. And I mean, it's, kind of good in contrast that your client never laughed or said a thing about it. And these people are it's not true, and you can point at somebody not here if you want to or not. But I think under the state's theory, and given that you're telling me evidence that these people are going to be shown to, at least by a preponderance, be part of this gang or associated with this gang, and this is kind of bragging on the gang.
Well, Your Honor, regarding the association with the alleged gang, I just want to make sure I'm clear. Max is not indicted.
Right.
She's not charged.
No.
Really, this is the first time I'm
Hearing that she's an unindicted co-conspirator?
Yes, I've heard her on help calls talking with me. But
We need to take up a donation from Max Shard's microphone.
Now you know.
And I believe you did during the entire Little Wayne bus shooting.
Mr. Steele corrected me and said that they have.
Okay, all right. So, yeah, I'm gonna let that in.
For Part A, we're complete. I know Part B is probably gonna be handled by Mr. Adams, I think. So we have.
Part A and Part B. I don't know where you are now.
So Mr. Shar handled some of these redactions.
Neither do
previously, and then
we.
Mr. Adams handled
Okay.
the rest of those.
All right, take it away, Mr. Adams. So give us the next portion we're gonna be contemplating.
Question go from page 413,
Okay?
the end of the transcript.
Ooh, that's a lot.
That is good news. And I believe that I'm really just going to be reciting to you what we've already argued, discussed,
Okay.
and agreed to.
All right.
I don't, and Ms. Hilton will correct me if I'm wrong, I don't believe there's going to be any disagreement about what I'm about to go. But if I can have about 30 seconds just to check one.
Sure. All right, so you're just gonna put on the record the stuff that's agreed to?
Yes.
Okay. Sounds good. Pages of lines. Might I ask, if it's already in writing anyway, and y'all can sort out that you do agree to it, if you might just file it instead of reading it out for the next 20 minutes?
I could. What you're actually seeing me flip through our email exchanges between
Okay,
Ms. Hilton and I.
okay. Well, you don't have to file the emails, but maybe that might be a better use of our time and easier for you.
I'm happy to do that if
All
that's
right.
the court's preference.
Let's do that. Okay,
One
so
moment,
y'all,
if I
okay.
can, though. Let me just make sure we agree on one point.
I have no clue. I have no idea. I'm in uncharted waters now. I have no idea where we are. Did they switch up and rest Steele? I'm thinking that a lot of these well, he just didn't want it. I think Brother Man said, look, before they file a mistrial, let me at least get a little bit of drum solo. So I think he's just trying to get Brother Man, Mr. Adams, has got to get a little, he got to like, look, let me prove my worth here. But I don't know. I don't know why Steele is not talking that much. Yeah, I don't think they know what they're doing. I'm sorry. I'm sorry. For the judge to say, I don't know where we are. And this is wild. And again, it's just more video evidence, but evidence that goes to where though? Where's it going to? That's what I want to know. Where's the evidence going to? Because I promise you, I don't think they can convict Mr. Adams of being bald right now. They could not convict a ham sandwich. They couldn't. Very interesting. I have no idea. Okay, so I'm just looking at the way people are interacting. You see my guy, my Morehouse brother, he's over here talking to his client over there. Matthews, I think his name is. Look at Weinstein. They're just kind of yucking it up. There's a lot of camaraderie over here. I think these guys, he's over here talking him, he's over here whispering to him. He's over here showing him something on his phone. Yeah, it looks like a lot more positive camaraderie, and you see that between the attorneys as well. So, oh wait, okay, what happened? Negative. Adams argued these before. This is typical Friday afternoon trial. It's fatigue. Oh, okay, gotcha. Steele and Adams cover different components of co-counsel. This part is so confusing. Okay.
And speak, and I will follow the court's instruction.
Thank you.
I think we can very well go ahead and I can put an email together that outlines what we have agreed to in terms of the redactions. There is one portion that we may or may not have agreed on.
Okay.
And between checking the transcript of that and also just talking, we can go ahead and resolve that. We don't have to do that right now.
That sounds good. All right. So, and you can just file, I mean, it doesn't have to be in email form. You can just print out here's what we've agreed to and file that.
I'll do that.
All right. So what's our next statement we're moving to?
Wow.
Apparently. Mr. Adams got the easy part. Wow.
So we have the statement on the 21st,
January 21st?
February 21st, 2015.
Okay, right. We've got January 11th, January 28th, February 20th, February 21st, and June 10th, right?
Goodness gracious.
Right,
So this is February 21st.
yes.
All right, let me get that transcript and y'all can switch to that video to the extent we might need to ever watch a portion of that video.
Stop saying that. Stop saying it. You hurt my heart. On a scale of 1 to 10, 1 being not so much, 10 being I really do hate it. How much do you think Judge Whitaker is hating this right now? 1 to 10. How much do you think she's hating this right now? I'm going to go with it. I'm dropping to 8, but 1 being not so much, 10 being absolutely vehemently hated. How much do you think she's hating this right now?
Okay.
Wow. Adams, I think Adams does his homework. Adams stays homework. Wow. They're not playing, they said. 50. Okay, that's an 8. Thank you, Kenneth. Man. Q for real. Really? A 3? Okay, okay.
Your Honor, and I apologize. Never mind.
Okay. All right, so for the February 21st statement, what's our first portion we need to look at?
Wow, 9,000.
21st.
She's not happy.
First thing I have is page 13, line 19, page 14, line 3.
Okay.
At this point, I can give you that now. Gladiator girl, I can give you that. A 1? Really?
Do you have timestamps for when you said page numbers?
So this has 3:59:50 to 4:20, 4 o'clock and 20 seconds.
Projecting on my bingo board since you're projecting Q. I think I should. I'm going to take it.
All right. What's our issue?
Ms. Hilton. I'm sorry,
Everything.
Ms. Hilton. Could you say now that I have the time, I wanted to make sure we were talking about the same thing. What, page 13, line
19 through page 14, line 3.
we got different transcripts.
So is this with Detective Gaither starting? You have it in your mind? We can't do nothing about it? Is that a different transcript? I can email you what I got. I got whatever I got from Miss Weaver.
Please, Your Honor.
Okay, Laura, can
We
you?
have different transcripts. I'm just.
Yeah, no, that'll be crazy if we're not working off the same transcript.
Look at Love with her hand on her head. Like she looks like she is defeated. Her body posture looks like I got my butt whooped. And she's definitely sure it could be Friday fatigue and such like that, but man, her activity level is way down. Way down. Her energy level is down. I think this is going long. Yeah, I don't like those green nails, I tell you. Yeah, I don't know. This is really bad. I have no idea where it's going though. No clue.
And Your Honor, what I'm going to try to do to keep this moving a little bit, I have a transcript provided yesterday by the court
Okay.
regarding my prior arguments about some of these issues, and I'm just going to try to keep up with the transcript and reiterate what I've argued in the past.
What are y'all doing? Why are we still here?
Okay,
Why are we still here?
And you have the transcript.
I do. So let me pull that up. Can you tell me what date?
February 21st.
No, I'm sorry. The date of the transcript for this trial where the February 21st statement by Copeland is argued.
It is June 21st.
Okay.
2020.
All right, I have that up as well.
Okay, so if I seem to be arguing something that's not consistent with the transcript, please just let me know it's not intentional. It's just I got too many transcripts going on. But my understanding of what we're talking about here is Investigator Gaither is prodding Mr. Copeland for information about who shot at him. And in this
Right.
context, it is
Why are we doing this?
February, I believe it's February 19th or 20th shooting that they're prodding information about and asking Mr. Copeland to tell them who shot at him and his child and
Right.
his mother's child. And Investigator Gaither goes through an extended, I'm not going to say monologue because it is broken up, but she is attempting to extract information from Mr. Copeland, and she's talking about the need to protect the community, to keep babies safe, and just essentially makes an argument in that interview that would draw an objection, at least for me, if the state were to make the argument in closing arguments. So I don't believe, I think, the focus, if we're admitting these statements in part, if they are admitted, they would be because they're inconsistent statements by Mr. Copeland. And I don't know how that somehow opens the door to Investigator Gaither to give basically her, thesis on why her job is important and gangs are bad and the community needs to be kept safe by her and her coworkers. So that's our objection, 403, 408, and it doesn't fall under prior inconsistent statements.
Okay, I'll hear from the state.
So previously, Your Honor, when Mr. Copeland was here in court, his testimony in court was essentially, and I'm going to paraphrase, I didn't care about snitching. I didn't care about telling on police. I didn't care about telling the police who did the crime back in 2015. And so this portion of the interview was in contradiction to what he was saying on the stand, because in these 2015 interviews, especially early on, January and February, he would not tell the police who shot at him and his child. And so this portion of the transcript, he's explaining, if I tell you, you can't protect me, you can't do anything. And so Detective Gaither is having a conversation with him about some of his concerns, because this interview, Your Honor, is immediately the day after his first interview regarding this shooting. So he's interviewed on February 20th. And then either in the morning hours or late at night, he's arrested on a probation violation. And then he's brought back in again to further, they're trying to find out who shot at him and his children. and he has extreme concern about telling the police who shot him, actually admitting to that. And when we were in court, his testimony in contradiction to that was, one, that the individual that he eventually says shot him didn't shoot him. He says that in court. And then he also says that he wasn't concerned about snitching.
Meaning I didn't have any problem with that. I was happy to tell them what happened.
Yes,
Okay.
and so.
So if he testifies consistently to that, or if y'all decide that you're going to stipulate to any part of the testimony, then this would become relevant as a prior inconsistent statement.
Yes, Your Honor.
Okay. All right. But that wasn't the objection from Mr. Sharp.
So even in going to I give that context because their conversation here is the effect on him, what she's trying to tell him in order to get him to actually tell her who's the person who shot him.
Right.
So we're not really worried about her. We're not offering her commentary for the truth of the matter asserted,
Right.
but we're offering it for her, what she's saying, the effect that it has on him in order for him to come forward and finally tell who shot at him.
Mr. Sharp, I'll give you the last word.
Well, I mean, I understand the state's argument, but I don't think necessarily the need to provide context opens up the door to investigators just going in.
Okay, well, I mean, it may be that there are other portions of this that we're going to take up. Right now, I'm looking at 13 line 19 through 22, and then basically 14 lines 1 through 3, where she's saying essentially, hey, buddy, you got to tell us what's going on, which is pretty much the beginning of any conversation, interview, interrogation between the police and anybody. And it shows that Mr. Copeland is very hesitant to do that. And so if he ends up testifying, man, I don't have any problem with that, then this, I would think, can appropriately come in as a prior inconsistent statement. I don't see any real other kind of like 403 or anything issues with it. So this is in assuming obviously the foundation for getting it in as a prior inconsistent statement is laid.
At this point, I think we all need to go ahead and turn ourselves in because they got us thinking we all did this crime.
Page 25, line 15 through page 26, line 3.
Okay.
Timestamp 40840 to 40940.
And Your Honor, last time we discussed these, this one, the one we just discussed, the one we're just about to discuss now, and the next one, we discussed all together because they're the same issue.
Okay, well, I'll look.
And you, I think you'll see, I hope you'll see that
I hope you'll see.
that Gaither says more and more, investigator says more and more. They're all the same issue.
Oh, all right.
It's almost at this point where I don't want her to declare a mistrial because she's made everybody do all this work. And it would be like such a gut punch if she says, before they leave out the door, like, I'm declaring a mistrial because this is crazy. It's almost like now we know she's going to have to go ahead and carry this through.
So y'all said 26 line.
Look at
3?
Adrian. She praying? What is Adrian Love doing?
Page 25, line
Right,
15.
line 15 through 26, line 3?
Yeah, it's probably more like line 7.
Yeah, okay. That's what I thought. This one looks okay also to me. I am going to let this in. I mean, she doesn't seem to be saying we're the heroes. She seems to just be saying, gotta tell me something if you want it investigated. All right, what's the next one?
page 28, lines 7 through 14.
Okay.
I'm sorry, the time is 4:10:55 to 4:11:05.
Any additional argument, Mr. Short, on this?
I mean, it's the same thing, it's just, we care about, you know, the life of children and those sort of things. And we're trying to put an end to all this. We find that prejudicial.
All right. Any response from the state?
Yeah, I think it's the same thing. She's just trying to get him to tell her who is the person who shot at you. And
All right, now, if she ends up standing up in closing and starts saying, look at how great the police are, they love this guy's baby, then we'll have a different issue. But just as a part of the interrogation technique going through a statement, I'm gonna overrule that objection.
the next, Your Honor, is page 29, line 9 through, I think I might have this. I have page 48, line 11. I think that's a script. Of course, indulgence. 'Cause I didn't do this, so.
We can hear you. So
I think it's page 29, line 9 through page 30, line 18.
All right, and what's our issue with this?
look at Weinstein. Weinstein is chilling back.
Is this the same concept, or is this
Now he moves because I said
moving
it.
on to some other evidentiary issue?
And I believe Mr. Shar wanted it out initially.
So Phil, will the jury poll be filmed? I'm sure it probably won't, but I'm just wondering. Doug is listening to me. Doug, holla at your boy. Come on, man.
This is more side conversation that is, at this point, I don't believe, well, I know our stance is that just because if the state successfully lays the foundation for specific prior inconsistent statements, our stance, my stance, I believe I stand for everyone, speak for everyone here, is that if prior inconsistent statements are included on a tape, that does not necessarily mean that the state just gets to play the tape. What they play still has to be linked to prior inconsistent statements.
Okay.
And here, we're just kind of going in talking about things that are not subject to these prior inconsistent statements. Of course, I don't know what a prior inconsistent statement is right now.
Right.
But I think that there's a lot of fluff in between.
Right. Okay. And is the state proposing to, I've got a prior inconsistent statement somewhere in this 30-minute interview. I'm gonna play the whole interview, or are y'all, I mean,
So the state's position, again, depending on what we do with Mr. Copeland's testimony, he denies, and I think that's what we talked about yesterday. What he says is, I spoke to the police, everything I said, but it was all a lie. I finessed it all. So we're at a position that I don't know if we have to go line by line, because his general statement here in court is, I may have said everything that you said, I said, but I was only saying everything that I said because I was trying to get out of going to jail, because I was trying to get out of getting in trouble. I was trying to get out of trouble.
Right.
And so a part of it is we believe that we don't have to now go line by line, looking at the Scudder case, going, I think it's Scudder, I'm citing the wrong case, going line by line. But specifically as it relates to this portion, we asked him about being a snitch, and this is her trying to explain to him, you need to tell us. It doesn't matter if you're a snitch or not. You need to come forward. When in court, he says something opposite. He says something inconsistent with what he said in his interview.
Okay, so if he ends up saying, I don't know what I said before, but everything I said was a lie, then you can't necessarily just play everything he said. But if he says, everything I said was a lie and I just said it to get out of jail, and then you say, aha, this shows right here, you were willing to go to jail and keep quiet, then that's a prior inconsistent statement to what, if we assume he says that on the stand. But no, you do not, I mean, it still has to be, and it may not be, it has to be like every line, but you can't play an hour-long video unless at least most of that video in some way is inconsistent to what he's saying on the stand. So I don't know if I can, I mean, this is pretty theoretical right now, but.
I think we just need to see what he says while we're, because a lot of people believe two things, not that it's just a prior inconsistent statement, but he's also contradicting what he says. So he'll testify, at least previously, that he'll testify, they were trying to force me to only talk about thug. They were trying to force me to do these things, and that's inconsistent.
That would be,
so
this would show that's not true. Okay, so yes, potentially then, I mean, obviously for all of this, we have to, but I guess what I'm asking is, Mr. Sharp wants to make sure that y'all don't operate under a theory that something in this, and I'm just
Thank you so much,
making it
Claudia.
up. I don't know how long the video is, but 30-minute video is an inconsistent statement. We can get the whole video in. Y'all know that. I mean, is that your position?
Shout out to y'all. Shout out to y'all.
Okay, so yeah. Okay, so then assuming that, I guess we don't have an answer to that right now, but I would not think the entirety of something can come in just because one sentence in it is inconsistent. So for y'all's edification, that would probably be my position.
Y'all type
However,
Claudia in the
assuming,
chat. Thank you so much.
that all of this is going to get used as prior inconsistent statement because of whatever he says. We have to assume it for now. Like, that's why we're going through this. Then what other evidentiary objection do you have to it?
Well, I mean, I just keep going back to the same question, which is if the purpose. My problem is all the talking that's, Mr. Copeland isn't really saying anything. It's all investigator gave, and I just don't really understand how we're just giving investigator, and I know Copeland said something, so I'm not trying to mislead the court about the transcript. You have the transcript, but I don't know how we're giving basically Detective Gaither the mic when the purpose is to be impeaching Mr. Copeland with his prior words.
Okay. Well, I mean, I think we got to have the context of what questions he's answering or relating.
To the extent that other people's words may give context.
So, I mean, I would think, I think that in terms of evidentiary issues, then assuming, which we're doing for the sake of this entire exercise, that it comes in as a prior inconsistency, then there aren't other evidentiary issues that would keep this particular part out, 29.9 through 30.18. All right. So what's our next stop?
Thank you so much, Andrea. Thank you so much for the super chat right there. I would love to know,
Oh, sorry.
is this common practice?
Next section.
I would love to know, is this prosecution actually prepared? To me, it looks like they're not. If Phil is still here, I might have Phil come on the channel or something, because I just got questions. But again, I don't have a question for saying, Andrea, thank you so much for the $5 super chat. Let's go ahead. You know what? Let's mix it up. Let's go ahead and put Andrea in the chat and tell her thank you so much for supporting what we're doing over here. And maybe we can get Phil to come on and like holler at us and explain this, because this just seems like somebody was called into the office and they're just scrambling to get something to put in front of their principal. That's what this looks like to me.
All right, what's our issue?
We won't object to this portion being redacted.
Okay.
Don't object to anything. Just let it go.
I think it,
She just said she's fine with it being out.
right, I'm not sure.
Don't keep going to the well, man. Don't keep going to the well.
47.9 on your transcript.
So I'm taking a note that I believe I got some.
He on his Twitter arguing with Shannon.
Okay, you're right, 47.9, okay, I got you.
He's on his Twitter arguing
Okay.
with Shannon. That sentence is crazy.
Next.
So the next is page 65. Line 1 through 5.
Oh yeah, people. I mean, we have people in the chat right now in Australia watching this with us. Germany. We got people all over. Matter of fact, why don't y'all just go ahead and tell where y'all from? Because y'all, all of y'all are the jurors, so y'all go ahead and tell where y'all from. We got people all over the place watching this.
Okay. Any memory about why this was objectionable?
I think it may have been the program that were used that was confusing. I'm looking at the transcript.
Yeah, I'm not putting any money down that this prosecution is prepared. Sadly, I think that Judge Whitaker is going to try to keep this
Y'all.
thing on the tracks, but I
Anybody
don't think
know?
that's going to work.
Oh, okay, I know what it is.
All right.
This was my objection.
Now they done called in reinforcements.
It was, okay. It was, I think it's likely to confuse the jurors. This is a very poor transcript, but essentially, and you can't really tell from reading the transcript, my understanding is, Investigator Gaither is asking, when's the last time that Shannon and Demekion were hanging out together? And when it comes down to it, the answer is, his answer, it comes down on page 65, line 5. It says, since they shot at their car. And when I hear that, in that context, it seems that he's referring to
They as in Shannon and
Shannon as shooting at a car. I believe what Mr. Copeland meant by that is it was an incident where they were all shot at. But I just have a problem with this being played and putting that perception in the jurors' mind.
okay. All right, and is there a redaction that could be made? So what is it that you potentially want this for?
If it comes and it gives a lot of context. So Mr. Copeland, in this interview, this is now his third interview that he's had with APD.
Right.
His second with Detective Gaither. So, and excuse me, this is his fourth interview, and I'm saying this in context. In the January 28th interview, he talked to Detective Gaither about the shooting in the car with Demekion and Shannon with him. So when he's discussing right now in February that the only people he hangs out with is Little D and Shannon, and that the last time that he's really seen them is since they shot at the car, that's going back to what he's already talked to Detective Gaither.
All right, in this particular interview, have he and Detective Gaither just been talking about that particular shooting where the three of them were the ones who got shot at?
He's talking about collectively everything that's been happening since January 10th.
So no then? Like if you're the jury listening to it, you might be confused when it says they shot at the car.
But this is the only car incident that when you look at all the interviews.
All right, hang on. So y'all have alleged, I don't know how many different acts in furtherance of a conspiracy, and you've got 8 or 9 different incidents, I'm sure some of them involving cars, where people are getting shot. So it is entirely possible if they hear this that they, the jury, will be confused into thinking, here's Mr. Copeland saying Shannon and Mr. Garlington are out shooting at a car. And that would not be fair to the defense. So is there a way that maybe we can redact out that little part about they shot at the car, since nobody knows who the theys are if you don't listen to the whole 4 interviews in their entirety to know the context of it, so that we don't confuse the jury? Yes, there is a way to do that, is your answer.
Yeah.
Later on in his answer, you're saying, I don't need the house anymore, I
Yeah.
stay away, so I don't think that confusing sentence really
Adds anything to it.
Yes, there's a way we can redact this, Your Honor.
So y'all could just redact out that part.
Yes.
All right. So that is 65 line, is that 65? Yeah, 65 line 5, the part that says since they shot at the car. So the rest of it's fine, right? Is the rest of it's fine, Mr. Sharp, essentially?
Yes.
Okay, next.
The next part we have, Your Honor, is page 155.
What we doing? What we doing, Simone? What you doing?
Through page 156 last one.
Okay.
Come on. All right. Okay, so at
All right.
3:00 Eastern Standard Time, I'm going to give away a couple memberships to DWC as well. Hopefully,
I'm ready for.
you have your membership options turned on. If the mods can remind people how to turn on gifting memberships on, that would be dope. And I'm going to do that at 3:00. So in about 30 minutes, give or take. I'm telling you, this thing right here is going so far off into the weeds. I would love, like, again, a legal expert or someone like that to explain, is this common? Like, I know Inside the Law was here. I don't know if he's still here, but I know he had mentioned that this is kind of common for Friday.
Issue,
That's
Your
wild.
Honor, is, so, little context, there's a shooting at a gambling house, where
Yeah, no
by
more study
this
all
time,
days.
Mr. Copeland has determined that an individual by the name of Kelvin Watts, as well as some of his friends, I guess, were responsible. And I
Okay.
think Mr. Copeland was allegedly shot out. I think Mr. Williams was allegedly shot at or present in the gambling house. Maybe some other individuals as well. Mr. Copeland tells a story, and it's tough to really grasp from the transcript, but no one knew who did, according to Mr. Copeland, no one knew who did this shoot. It was supposedly, and everyone thought it was another group called NBC, had jumped to meet on Garlington on that same day at a club somewhere. So the thought was NBC was responsible for shooting the gambling house. Now, by this time of the interview,
Gambling house.
Mr. Copeland has determined it was Kelvin Watts. How did he determine it was Kelvin Watts? What's his basis?
Okay.
Well, Kelvin Watts was apparently dating a lady named Trivia, who Mr. Sledge also dated. So
Trivia's getting
flow of
around.
information,
Watch
as I
out, Trivia.
understand it, is Kelvin Watts, according to Mr. Copeland, Kelvin Watts tells Trivia that he was responsible for shooting up the gambling house. Then Trivia tells Mr. Sledge, and then Mr. Sledge tells Mr. Copeland. So these are not observations based on Mr. Copeland's firsthand knowledge. These are, it's like game of telephone at this point. And he was under the impression that it was NBC based on speculation.
Ooh,
So,
shot
you know,
nut.
if Mr. Copeland gets on the stand and starts talking about what he saw at the gambling house that night, that's one thing. My understanding he was there, but to say he did it and all the rest is just layer and layer of hearsay. And then on top of that, he's talking about Mr. Garlington being jumped at the club by NBC. And my understanding is Mr. Copeland was at the gambling house and not at the club. So I don't know what his basis of knowledge on that is either. So he's talking about two different things that he doesn't know.
Okay.
So I'm not sure if Mr. Sharp said he doesn't know about the shooting. He does know about the shooting because he was present at the shooting. So the shooting.
Right, for that, it's who's responsible for it might be hearsay on hearsay on hearsay. What do you say to that?
Well, what he says here now is that Gucci, he found out from one person, which was Gucci Red, and that is not Antrevia Smith. That's two different people. Gucci Red and Antrevia are two different people.
Okay, so where's the part where he says, here's who I knew it from?
So if you go to page 156, round, it says unintelligible, so you need to hear it. But it says Gucci Red. I can play that portion for you.
What part of, give me a line number.
Line 17.
Okay.
And if we skip to line 15, it says, goddamn, the next night we at the gambling house. They ain't putting no picture. We in there gambling. They taking pictures and shit. Then they came up and shot at us. Only reason we found out it was Kel. He had got into it with Gucci Red. And then she talked to them and she came back and told us, like, man, that was Kel and them that shot y'all.
Them names again.
Because they shot it up.
Okay.
And then they went and shot at another spot. And then Monday we got into it with NBC. And then he goes on to talk about whatever happened between them and NBC. So whether or not Gucci Red told them that Kel shot at them is irrelevant, because what this incident at the gambling house does is kind of form the basis of other events that happened after the gambling house. So some key incidents early on in this conflict between YFN and YSL is there's the gambling house shooting, and that becomes important because after the shooting, I believe it's the next week or the next day at Cascade Skating Ring.
Oh, man.
Kel, who's the person who shoots at them, and Mr. Williams have a phone call in the presence of Copeland, in which Mr. Williams wants Kel to pay for his car.
His window, right.
So this, whether or not Gucci Red told him doesn't matter. It's what happens afterwards, which is the impetus for this conversation about paying for the car that was shot up at the gambling house.
Okay.
I mean, in other parts in the discovery, it's the flow of information is described as different, but either way, if it comes from Gucci Red, it's still hearsay.
Well, it is, but they're saying they're not offering it for the truth. Right?
Yes, Your Honor, to the effect on the listeners.
Skating rink. They will shoot at the skating rink.
After it derives from them knowing that it was Kel who shot at.
All right, so if that's the only objection, then I'm going to overrule that objection. Okay.
Next, Your Honor, is page 173, line 7 through page 174, line 2.
I don't think he said anything today. He has said things, though. He has. Fred Ryan. He has spoken. I just don't think he spoke today. He did speak on Wednesday, though. He was boisterous on Wednesday. Well, if somebody was shooting at me, I'd be a competitive speed skater too. I'd be speed skating up out of there.
Okay. All right, Mr. Sharp, you want to articulate your argument?
And, Ms. Hilton, you said it ended at 174 too?
Yes, sir.
Just trying to get it.
Okay, so my question is, where are these questions coming in
We'll withdraw that.
All right.
the line of reasoning? Like, will they be arguing this on Wednesday or next week? If not, like maybe they should talk about what they're going to talk about immediately, aka
Next
to get
is
those
page
jurors back in.
181, line 8 through 12.
Because I'm wondering, should they work through the
right.
questions they're going to ask
Can-
the jurors? That's why I
Any
asked that
chance
question.
we can just get rid of that?
Yeah. we
Okay.
have an objection to that.
There we go.
Just seems like a lot of time being spent, a lot of gas being wasted, and you don't even know if you have a jury. Wow.
And the last one we have is page 185, line 17 through page 186, line 19.
Okay, they're still horse trading. Anyway, this is my bingo board. I'm not killing it today. I'm not killing it at all. I'm a little disappointed. Yeah, I think my bingo board, I think, was really leaning toward there not being a trial or any court. Like it feels like this is stuff that would have been stated in the mistrial. That's what I think my bingo board was thinking. My bingo board was like, we ain't gonna be here long. So anyway, hopefully you all are enjoying bingo. Let's get back to it.
Entirely? Just trying to get clear what you're saying there.
Yes.
Okay, so that'll be 185, line 17 through 186, line 19 will be out by agreement. Okay?
I don't disagree. I don't disagree. I was holding out hope. I was really holding out hope that they were going to do their homework. And the state can't say that the prosecution, the defense doesn't
our
want
next
to meet with them.
Portion of this transcript.
Like they can't even say that
Oh, okay, well.
because they could have.
Okay. What's our next statement we're moving to?
They could have done that.
We can do February 20th.
Okay.
I wouldn't be opposed to that, Monica. I think you might be right.
Send me the transcript.
I think the lawyers are going to ask, but somebody's going to, or maybe it will be the judge. Maybe the judge is going to ask, have you been following this case?
And is there an associated trial transcript where y'all are arguing this that might be beneficial to look at? I mean, we didn't end up using
None of
that
this
other
is
one very
beneficial.
much, but
None of this is beneficial.
I mean, if you're not really using it, then that's fine.
Well, I'm trying to remember. I haven't seen the transcript. that was
Okay.
sent.
And February 20 may have been earlier before the break.
We
Oh,
don't-
well, hey, then we don't need to rehash that one.
And that's, I'm trying to figure out, this for January 11th and February 20th, I'm trying to figure out when we had those arguments, because we actually played those videos on the.
Okay.
We haven't received the transcript when we discussed January 11th or February 20th, so I don't have an independent recollection of what they are.
And those who had the minimal, we agreed on most of that.
Okay.
The actions that came out, we agreed on.
And they've already been played. Y'all just aren't sure whether it was pre or post recusal motion. Is that what you're saying?
Yes, those two videos were played. Let me back up so the record's clear. The video for January 11th. And the video for February 20th were both played in front of the jury.
So
At least on the 14th, and I believe on the 17th of June.
Okay, but,
I assume that the argument may have happened.
okay.
I don't know if the argument happened post the 12th.
Right.
I can't recall, or if it happened pre the 12th. That's what I need to determine.
So I have some notes.
Okay.
That were taken by Tim, who, I have that the June 11th interview, excuse me, thank you, January 11th interview was played on the 17th. And the February 20th interview was played on the 17th. So those were played after the motion. I have.
Laura, thank you. Laura, thank you for the super chat. I don't think they can read omitted because they've been omitted. Otherwise, somebody could come in and read something or say something that's way out of pocket, judicial, that would, contaminate the jury or whatever like that. Be like, oh, well, y'all admitted it, but I got omitted it, but I got to just say it. Like, that would be crazy. I think that would be a dumpster fire.
Was played before what? Okay. So would that indicate to y'all that y'all had already hashed out the evidentiary issues with regard to the January 11th statement prior to the motion to recuse being filed? It would indicate that to me, but did you at least do the entirety of this January 11th statement at the same time? By which I mean, that was not at all clear. Did you handle the evidentiary issues with the January 11th transcript all at the same time?
I knew what you were asking. I don't know the answer to it, and this is why, because.
Okay.
And this matches my recollection. This Hilton used January 11th to one very particular point that she played like 30 seconds.
Right.
To Mr. Coleman. So I don't know if we had reviewed the whole, and she also played a 10-second clip of the January 28th interview before the motion to recuse.
All right.
And
I hope that makes sense, Laura. They're reading it and they're omitting it right there. They don't have to read it out loud, I guess, because everybody there is reading it.
So I know that
I agree.
after the jury leaves and hasn't yet come back, Y'all discussed the January 21st and the February 21st one, so y'all had not done those pre-interview. I'm not helping, am I? I'm making it more. Okay, yeah, no, I don't know what that means. February 21st.
No, they've done
I don't
this,
know.
Judge Whitaker. They've
So-
done this. It's not your
If-
fault.
Y'all don't know whether you dealt with all of January 11th at the same time or not.
Your Honor, initially, I impeached Mr. Copeland as the issue or the topic came
Right.
up. Then when it turned to everything's a lie, then we went to
Okay.
getting in the entire statement.
Okay.
Or playing the entire statement. And so when we had argument,
All right, so you spent a lot of time after the, yes, yes.
I'm looking at, notes for 6/17/24. We have, we sent redactions, regarding, we were discussing redactions, I think on 17, regarding January 11th, January 28th, February 28th.
Mhm.
February 21 interviews. That leads me to believe that these were not redacted prior to the 12th.
Okay. Well, y'all said y'all are close on those anyway, so why don't we just,
so I think
if it's me revisiting and ruling differently, then maybe lucky state, maybe lucky defense. Who knows? I don't know.
So I think the next video we can actually go to is January 28th, because that is where we had some more
Okay.
redactions.
So are y'all just then, as to January 11th and February 20th, y'all said, I think, that there isn't much y'all disagreed with about that anyway?
That's my recollection.
All right, so maybe y'all can get to huddle up together on those two, and maybe y'all can come
Ain't
to
no huddle up.
agreement. If
Ain't no
not,
huddling up.
you can either figure out, was the ruling made before the motion to recuse, or if there are two or three things and we don't know when the ruling was made, just bring them to me.
Yes, Sean.
Ain't no huddling up. We ain't huddling
Okay,
up
so
in
then
here.
we'll move on
We're a
to
gang.
February 28th. Is that what you said?
January 28th.
January 28th. Right, February 21st, January 28th. I am just making it that much more confusing. Sorry, y'all. Mr. Harvey's going to use that later when I say that. Even the judge admitted it. I'm teasing you.
Sis
Mr.
Wit is
Harvey,
wild.
although I bet you will.
Yeah, I understand what
Okay.
you're saying, Laura, but it would
January
cause a
28th.
problem.
Yes.
And that has either not been discussed or it was discussed post recusal motion.
Discuss post recusal.
Okay, and so do we need to look at a transcript, or Mr. Shart, you're just gonna?
If the state has a transcript of this motion, this interview.
February,
I would need-
January
I'd like to
28th.
work on the same.
All right. We can, I assume we have the one that ours came, I don't know where ours came from, if they came from Ms. Weaver or from the state, but Ms. Firstfield will forward you what we have. Is everybody good? Does anybody need a break? Quick break, 10-minute break. Let's come back.
Go
in 3.
home. She is the best. She is so done. Hey, thank you so much, Fred. Hey, Fred came at the last second. Thank you for this group analysis forum you created and lead here. Hey, I'm just learning about this stuff, Fred, by the way. Thank you so much for the very kind super chat. Thank you so much. I really appreciate you supporting what we're doing over here. I just like learning this stuff, man. I'm learning this. I've met so many people, very gracious tube that have been very kind. So, man, thank you so much, Fred. Y'all go ahead and flood Fred in the chat. When we get done flooding Fred, I'll get some of these tips. Let me make sure I can do it right. I just learned how to do it. So, fun fact. So, I think Judge Whitaker is toast, but she's got it somehow or another. She's got to keep her hand on this wheel and keep trying to get this thing back on course. I don't know how. I don't know how she's going to do it, because she just sounds frustrated. She sounds like super frustrated. I expect her to go start snapping off on people in a moment. Like, she just sounds frustrated. She sounds like this is poorly run. I'm pretty sure she might be using, bad words or a lot of bless your heart, something. She just doesn't sound like she's happy about what's going on. And I agree with her. So, man, that's crazy. Oh my gosh. Now, granted, she might be going back there writing a mistrial. She said, look, decree. She could go back there and write it and be done real quick, or I had it ready. But my goodness, anymore, she's got to be double kicking herself. How did I get on? Understand she's trying to keep this ship on track and prove that she's got the wherewithal and she's made of the right metal to hold it together. I totally get it. But my goodness, in the morning, I bet you she's regretting it. I'm sorry. There's no way. There's no way she's like, oh, this is wonderful. This is fantastic. I mean, she even got up. You notice she's up before the camera went off. Usually the camera goes off before the judge gets out. Okay, I'm looking real quick because, man, my daughters are really doing a great job. I don't know where are they? I'm bringing this up because my daughters are commuting home from school. They are. Okay, that's so. Maybe I'll do like a image stream of them coming home one day. All right. I said I was gonna give these away at 3 o'clock. Hey, I'm gonna drop some new memberships in the chat. If you have gifted memberships turned on, you have opportunity. There it is. That's kind of neat. Okay, so I can give away a couple memberships. Got some people love it. I love it. 2, 3, 4, 5. 2, 3, 4, 5. That looks like 6. What kind of math y'all doing over here? YouTube? 1, 2, 3, 4. Okay, no, that's 5. Sorry about that. Well, welcome everybody. Thank y'all so much. Look, I'm telling y'all right now, I really appreciate y'all hanging in here with me. These are long days, man, and these are wild, because I really thought this was going to go a different direction. And lo and behold, it went in another direction, right? And thank you so much for hanging in there. I appreciate all of the support today. It's been a lot of fun. I really mean that. It's been a lot of fun. I really, truly, I'm just kind of gobsmacked. Like, I don't know where this poor woman is going to, how's she going to get this boat back up on the proper course. But we will see, we will see, we will see. Now, please, now in the poll question is, what are the questions that you would ask the jurors when they come back? What are some questions that you would ask the jurors when they come back? I'd love to know, what are some things that you would want to ask them? You could be funny or you could be serious, and just put answer as your response. So I'm gonna go ahead and put mine right there. Start with answer. All right, so I just put my juror poll question. Have you been to Mechanicsville lately? All right. Thank you so much. I appreciate y'all. So Gladiator Girl, if you click, where's the, oh, it's under the video. There's a button. There's like my logo. First of all, it says YSL trial, judge holds nothing back. And then right under there is a join button. Join us. Have a lot of fun. Okay, so my question is lately, what is Q asking? Q says, any of y'all know who Jack is? Not, I'm sorry, know why Jack is not in the courtroom with us today. That's messy. That's hilarious. All right. So you've never been to Mechanicsville? I know where the area is. My point of view, she wants to mistrial the consideration with or without prejudice. I think she wants the mistrial as well. I don't think she, I'm fighting with the idea that she wants to mistrial it, but she just doesn't know, she doesn't have a good path, so it won't get overturned. That's what you don't want. You don't want it to be overturned. So that's what I'm thinking. I appreciate y'all. Can you, if you do have what was this? Mr. Harvey's role is to be passive aggressive with presenting reasons to remind the court it's time for a mistrial. That is true. I totally believe that. Everybody's playing a role, and Mr. Harvey's role is, I'm going to just, we should cancel this. I agree. One. Thank you so much. All right, let me see. Did I miss any other answer? Do you see Yenta? Do you see a Yenta in the courtroom? You know what? Since you used the word Yenta and it's on my bingo board, now I have bingo. Praise his name. I got one solidary bingo today. I at least got one. There we go. Because you did that. Thank you so much. You were in the spirit. There's my bingo board. I finally got bingo. I was holding out like, man, it's been rough today. It's been struggle busting. Yeah, Bruce Harvey seems to have a pretty mellow tone, but people do follow him for sure. Absolutely. He said Yenta, because he said they were gossiping like a bunch of girls. I mean, they're right down the street. I'm opening the garage up for them. I might be late. I think I hear the car. I'd ask them if they know who the agitators are in this case. You all are out of control. You all are out of control. See, this is a very serious question. See, Monica's being serious. I don't know what you people are doing. Monica says, what have you learned about this case during the break? That would be that right there. That's going to be foot into mouth answer. Because I guarantee you they're not going to say nothing. We've been saying that for the last 4 weeks, Thunder Drop. They need to throw this out, but we're still here. I don't know why we're still here. I don't even understand. Throw it out with prejudice. Don't ever come back here again. Yeah, I would love for them to part, and maybe there's already like a set type of question that they could ask them. You know, maybe they don't ask them like, hey, do you know who Woody is? Or do you hang out at Adams Park or anything like that? So maybe they do ask like some specific questions and that will lead them. But I think like Monica's question is a great one. Like, what have you learned about this trial during the break? That would be almost a guarantee, in my opinion, that juror is totally wrecked. Right? Now, the only problem with this question is, and any question really, in my opinion, is, let's say that they don't know. Say, hey, I don't know why you're here, Judge Whitaker. I know that when I left, it was Judge Glanville and Jack, and now you're here. I don't know why you're here. But when I get home, I'm going to want to look it up. That's the only thing. Like, it would really spark me to want to look it up and want to know why it is. I would ask Love how many pairs of donkey ears she has talked off a donkey per Weinstein's famous quote. That was a very good quote. I forgot it was Weinstein. I did think it was Steele, but you're correct. The comment was great. He said that Love could talk the ears off a donkey. Yeah, where are they? I hear them outside. And it's hot outside, so I know they're probably glad that the garage door is open. They can just come in quick. Yep, there they are here. Do you have any idea why you got several weeks off? Why you were able to live your life like a normal person? Do you have any idea why that was? She needs to come back and she needs to come back and end it. Thanks for your membership. Oh my word. Wait, hold on. Hurry up because I'm on a break. Come here.
I need to go clean out Trina's car.
What's wrong with Trina's car?
She left trash in it.
Oh my God. Taylor left trash in the car and now you clean the trash out? Who is this child? Wait, what do you want, the vacuum cleaner next? When did you?
Bag of trash in my car. Get it out.
Oh my gosh. She took the bag of trash and had it in your car?
Yeah.
Oh my gosh. It's almost like I've been saying that forever. Oh, here they come. All right. Well, thank you. How was school today?
Good.
All right. Cool. You had a good time?
Love you.
All right. Love you, big
I
girl.
got a lot of compliments on my outfit today.
Looks nice. Let me see it. Step over. Them shorts look like.
Candle smells like.
What? Got it.
Yummy.
Goodbye.
I love you.
I love you too, babes.
Hi.
Are you are you gonna go paint your parking spot, finish it up, or what?
I might. It's hot.
It is hot. I mean, when the sun
I'm
goes
gonna
down, it
wait
gets
until
cold.
probably like 6-ish.
Okay, that's fine.
I have a beautiful daughter.
What are you talking about? Go away.
The comment was nice to me, unlike you.
Unlike me? Unlike me. Your dad. I'm just trying to figure out what you've done to your sister, make her go clean the car out.
No, she just left trash in there. It's like, go put the trash out.
So, like, okay. I just want to know because I don't know because I got 13, 14 years of y'all leaving trash in my car and y'all never cleaned it out. Y'all can start with your mom's car tonight. Since y'all are all reformed and stuff, y'all can start with your mom's car tonight. I'm sorry, ladies and gentlemen. I know you all expected. I know y'all expected a much serious show, a very in-depth, but that's not what we do over here. I don't know what we're doing. Oh, here we go. All right. Sis Witt is still here with her Ruth Bader Ginsburg collar on. Let's go. Oh, I love my big girl. I love him. Do I have it muted? No, I don't. Judge Witt said, look, we done. Oh, here we go. We're back. Oh, that's a good question.
Your Honor, can we have just 3 minutes? I think we might be able to get through this much quicker.
That's a good question, Laura. I like that one. They're in the building. They're in the building. I think she's going through the process of declaring a mistrial. I mean, I think so. I just don't know at this point. I really don't. I really thought I had this thing locked down. I was like, oh, this is what she's gonna do. Yeah, I think I agree, Monica. I'm I'm literally going whichever way this happens. If it continues, it is what it is. I still think it's a monumental problem, or she, just throws it out the window today. It is. Maybe that's why Love has been so quiet. Maybe Love realizes and knows that this is all performative. There's no, because she's not even adding to the dialogue. If you notice, let me move out of the way. If you notice Love, she's not actually adding much to this. She seems like very engaged in whatever she's doing on her computer. Like there's distance between her and I think his name is Atkins. There's distance there. She's got her hand. I'm sure a body language expert could prove this, but I mean, she's got her hand on her side of her head a lot. She's holding her hand holding up her chin. I don't know. She looks defeated, in my opinion. I thought that as well, Miss B, that she was trying to, position herself for Supreme Court. I did think that. I just don't know. I don't look at this point in the game. I don't even know anymore. And no, I understand completely, Monica. I think that's a solid. We're all like speculating at this point. I like this approach. He says, I am lady says, a new boss doesn't just fire someone. They will go through the proper process to ensure nothing can come back on her or the company, which makes sense. And I think that's what I thought she was doing all this week. But I'm feeling like I wouldn't plead anything. That's the problem. Like I wouldn't plead anything. I'm not going to say I did anything wrong if I didn't do anything wrong, or you can't prove that I done anything wrong. I'm not going to admit, yeah, I was throwing squirrels or kicking gerbils if you can't prove it. And at the current moment, I don't think the state can prove it. Okay, I had an idea about how it could help her career. If she stays on the case and brings it to verdict, that will definitely help her career. Is my man sleeping over there next to Weinstein? It does look like he done passed out. Look, bless his heart over there. He is low in that chair. He is low. Look, and this is terrible. So I can imagine it. I can. There's certain things that probably would be beneficial to her career, like being able to prove that she can fix, because this is a steaming hot dumpster fire. And if you could come out of this as like the hero or the heroine that fixed this crazy case and brought, justice, whether it be Young Thug is guilty, Young Thug is innocent, whatever, but you brought it all the way to jury, I mean, that would probably look good. But on the same note, it's still a big steaming hot dumpster fire. And you said, hey, the state had such a horrible case. I just went ahead and mistrialed it because it was a disaster. I don't know if I think that's still good for her career. I think what's not good for her career is going to appeals or going to appellate and it being overturned. That would be the one thing in a one way that would be bad for her career, in my opinion. I don't know, Thunder Drop. I don't know what Young Thug is even guilty of because at the current moment, they have not proven much of anything. So I don't know. Is Young Thug, like I said earlier during lunchtime, I don't think they can prove that Young Thug has dreadlocks at this point. That's how bad this case is running. I don't think they can't even prove that Young Thug is a black man. How about that? That's how bad this is. Yeah, I don't know, but I don't think they've proven much. I don't even think they're saying that Young Thug is the ultimate gunman. So even in that, I don't know what Young Thug would be guilty of. Even it's very convoluted, in my opinion. The court will remind
So Your Honor,
them to
first
consider the pleas.
time that we have, we're at issue is page 42, line 3 through page 44, line 8.
That's hilarious. Well, while they're quiet, notice also, I don't think Judge Whitaker ever ruled on the motion for mistrial. And she said she was going to take it under advisement and consideration, rather. Right. And nobody's actually pressing her to make a ruling on that. I just think that's interesting. And I might have missed it. Maybe I missed it, which is very possible. And that just kind of slipped past me, but nobody's pressing her about that. I wonder why. Right, boss. I also think if she dismisses, she's being overly cautious as to what the basis of her decision is, which will give her an advantage if she is nominated for a Supreme Court seat. Gotcha. I like it.
Quote unquote beef between Buddy J, who is his name, last name is Usher, and he is allegedly a member of IF, or an affiliated subset of IF, and he's a rapper. And I think the state's theory in some ways is that
He should get on that microphone.
Buddy J and Mr. Williams, because Buddy J said some things about Mr. Williams, Jeffrey Williams, I should say, and Mr. Copeland goes on to say, well, they say that Birdman Williams, Brian Williams, aka Birdman, wanted to sign Buddy J, but Jeffrey Williams didn't want Birdman to sign Buddy J because of the feud that they had between each other, and he was blocking Birdman from signing Buddy J. But so that's the background. But the bottom line is, Mr. Copeland saying they said that Birdman wanted to sign Buddy J. There's absolutely no indication. My understanding is that Mr. Brian Williams is a multi-millionaire who runs a big record label. There's absolutely no indication that Brian Williams is running his ideas of who's going to sign and not to Ken Copeland. And Ken Copeland's just kind of, and he says it. He says they say this, they say that. And so that's all hearsay from our perspective. It's all speculation. It's not based on hearsay. And Brian Williams is on state's witness list. So if they want to call Brian Williams and ask him about what his plan for to sign Buddy J. But Mr. Jeffrey Williams.
I don't know, Robin. This is very confusing at this point.
And Your Honor, the state has no objection to page 43, starting at line 4 through page 44, line 8. The only portion that the state wants in is page 42, line 3 to page 43, line 2. Mr. Copeland, it's either in this interview or one of the other interviews, talks about how he actually brought back, or he tried to get Bloody J and Mr. Williams to kind of, at some point, start working together again. So he has some familiarity, we believe, with the relationship between Mr. Williams and Mr. Ussery. So when he's on page 42, when investigator Dennis asked, so what happened with Bloody J? Weren't they cool? He explains his understanding of when they may have started to fall out. This transcript is not the best, but some of what I believe is in this transcript, if you go to line 12, when you said you was trying to hook them back up, what happened? Like, did they fall out? Was it a beef or something? His response, I think they did because Bloody J joined they gang. Whose gang? If gang is what it actually says.
That's not saying game.
No, it says,
It's gang, G-A-N-G.
and it's saying if gang, I-F gang. He says, and I guess he was down with YSL, and I'm at line 23, and then it says, you know what I'm saying? So he joined them. And so that's his understanding of where their beef started at some point between Bloody J and Mr. Williams. And this is corroborated, Your Honor, because we have video evidence that at least back in 2012, Mr. Williams and Mr. Ussery, they're releasing music videos together. At the time, it looks like it's a ABG or Atlanta Blood Gang music video, but they are friends. And we know that the friendship dissolved sometime after 2012, which will corroborate or lean into what Mr. Copeland knows about their relationship. So we that's the only portion we wanted in, which was page 42, line 2, up to page 43, line 1.
So I understand the effect of that being this, for all we know, is.
Why is her microphone not on?
About why they fell out.
I think it's the way that he speaks, and if you watch it, it doesn't seem like he's saying they, like this is something they told him, because he says, when you said you was trying to hook them back up, what happened? Because he was trying to bring them back together. So it seems the state understands that he has personal knowledge of how the relationship dissolved, not something that he overheard or, but something that he's. Yes.
What does this have to do with who killed Nut, though? We've already concluded that they were a gang or a group of people. Like, you haven't proven that the gang is violent, the gang is resulting in crimes.
Portion that is in.
Oh my gosh.
In disputes, Your Honor, is page 203. Excuse me. I need to find out from Mr. Shard if he looked at.
No, you can't look at anything else.
Of 808,
If you don't have it, it's done.
811.50.
Can I back up? My notes may be wrong. Did you agree to number 5? 750 to 750?
Yes, we're not going to contest that.
All right, so where are we now?
80804
And
to
those are
8.
the timestamps.
So roughly page 178.
This is a big one. We agree from 80804 to 809.
Right, and I don't have the
So
timestamps, so.
page 178, line 7 to page 180, line 8.
And the state wants to go beyond that. What happens after 180, line 8 is very interesting. This is January 28, 2015. He spoke on January 11, 2015, speaks on January 28, 2015. February 20th and 21st, 2015. And then on June 10th, 2015, is the first time he says that my client and other individuals are responsible for Donovan Thomas's murder. In this segment right here that the state's wishing to redact, they ask him about who he thinks or who's responsible for Donovan Thomas's murder. And he says, well, what my understanding is, or what I've heard, now mind you, his stance on June 10th is he knew that my client and others committed this murder that night. So he was in knowledge of it that night. On January 28, 2015, they're asking him, who's responsible for Donovan Thomas's murder? And he says, well, I believe, or I heard, and I'm not asking him for the truth of the matter asserted, I'm asking to show that his story's changed and he didn't say it initially. He said, well, I heard that Kelvin Watts had robbed someone and that and then Donovan Thomas was murdered as a result of that. And I believe, I'm not going directly off the transcript, but he puts forth different theories on what happened to Donovan Thomas. And our stance is that's important for the defense because if he was a truthful person who was telling the truth, he would have said that then. Now, the other interesting thing is on all these other dates that he's given these statements, he's not facing arrest. It's not until he's facing arrest that he points his finger at my client and others. So to us, that's a very important fact. And it's not being offered for the truth of the matter asserted. It's being offered to show that what Mr. Copeland has said at different times, when common sense would dictate if he's being a truthful person, he would have said what the state's saying the truth is.
All right, are you sure this is 178, line 7 through 180, line 8? Because I don't see this without any of.
So that's the part we agreed on. And then they want to go beyond that. And starting at 180, about 180 line 8. And we want to keep it in.
So 180 line 8 through what? The state wants to.
Until 186, line 2.
Yeah, like Adrian Love is really not participating. She just now is participating. She is super calm, really chill, and I wonder why. Oh, what are you adding to the RICO money?
Ms. Dillon, could you just, or you want to
On page 186, line 1.
And the transcript doesn't really.
Is Black Law student here? Can you imagine being a juror
And why?
and you've been off for almost a month and a half?
Why does the state think it?
We, because it's a lot of rumors, this is actually not him testifying from personal knowledge. When he first starts on page 180.
So I would concede it's not personal. I would concede that that's not personal.
So think that they can cross-examine him on whether or not, why didn't he tell the police early on, but all of his speculation about what the rumors are, that's putting in information in front of the jury that's based on speculation and rumors. If they want to cross him and say, you know, on January 28th, you didn't disclose that any of these people did it, I think that's fair for cross-examination, but to actually introduce this statement of him speculating as to what may or may not have happened on the night of the murder, it's just that, it's rumors and speculation.
There's a fundamental difference between not coming forward with information and being asked about something and coming forward with other information.
Maybe I need to listen to it because I don't really see in this transcript at least. Except for on page, the very end of 184 and beginning of 185, maybe. And I'm not even sure if that seems to be the only thing they're talking about, that being killed.
The beginning part of what they want out, and so there's after the part with our agreement, they talk a little bit about an incident where Kelvin Watts shows up at Lucci's mother's house after it's been shot up with a gun.
Yeah.
That is a separate, so I don't want the court to be confused. That is not the the Donovan Thomas murder.
Okay, so do you want that part here?
I do want it in. If you ask me why it should be in, I want it in, but the reality is I don't believe that Mr. Came to the court. I don't believe that Mr. Copeland has firsthand knowledge of that, and that doesn't really fall under my argument about the Donovan Thomas.
Or then you agree that we don't have to talk about that part, so point me to the part where we actually, that you, the defense for Mr. Stillwell, want in and think appropriately come in under the.
I think, respectfully, I think we need to just play it because I can't, the transcript is so long.
Okay, yeah, no, I mean, I think so too, but certainly it's not that part about Lucci and Lucci's mom. All right, so can somebody?
Yes, so I'm gonna start around, I remember we were at 8:08:30, which should usually be, okay, somewhere on page 179, probably around line 7.
Yeah, this is, I don't have a clue where this is.
This is like Rich Homie Quan threw ahead show.
Oh, Rich Homie Quan.
And I was there. And Rich Homie Quan came, but Rich Homie Quan tried to play both sides. So he like the guy, like. Yeah, so he just like, bro, man, I'm telling you how serious it is, bro. Kill try to kill anybody, bro. He told me to call Max and tell her, trick her down here so he can kill her. Just to get back into it. Yeah, he said like he want to kill somebody that way gonna hurt.
Wow.
What the hell? Do what he's saying. Rich on the corner, you born out of jail. Lucci ain't gonna pay his bond. They said he mad at Lucci because Lucci ain't pay his bond. Why? Why Lucci ain't pay his bond? But what don't make sense, let's say, okay, what word did we get, right? Somebody said that Kel was called over there to the house after he got shot up. So at Lucci Mama's house? Yeah. All we heard was Lucci Mama's house got shot up. Kel pulled up with the guns. Then we come to the tree. Kel pulled up with the guns in the car. And police walked up, searched the car, found the gun, locked him up. But why was he there? Who brought him there? I don't know. Lucci Mama's house. Kel, come. Who brought him to Lucci Mama's house? Like, how did he know he got shot up? Like, do we just hang out in the driveway? I don't know. They probably, you know. So if that's the case, and then he got locked up, why did Lucci want to pay his bond? Oh. You know what I'm saying? If I basically called you and said, yo, my house got shot my town. Check out. And then the red Camaro Lucci got, the same car they ran around, they shot my girl mama's house up. They Lucci car. Yeah. You know what I'm saying? But I ain't get it. Like, you know what I'm saying? They got my name on so much stuff. Like, people that come and tell us, they tell us a little bit, then they start talking about it's me. You know what I'm saying? Like, my girl, she get a lot of information from her friends. She got a lot of friends, so they be around me. Lucci and I was talking in the studio, and there was a girl in there, they mentioned one of them, and she my girlfriend. And she said that they know I didn't do that. You know what I'm saying? They was all like Kel and K robbed somebody. You know what I'm saying? Kel and who? K. Who's K? I sent you a picture of that too then. I think I sent to the other too. They had chop on in the picture. Oh, yeah. And the them was in the car. Yeah, them two robbed somebody, and they supposed to came back. They was talking about the studio. You know what I'm saying? They just put my name on it. They covered it up. Make it seem like they ain't got beef in the streets, whatever. Yeah. And then they like, she be like, they know what they ain't do it. You know what I'm saying? But they gonna keep playing on him. And she be like, K, when the nigga got killed, K first one called everybody like, we killed Nut. Tell them on there what did. He the first one started my name. And they like, Kel went along with it. So they just robbed somebody, then they did. Like, Nut died, then they started. That same day? I don't know when. They just robbed somebody. And niggas supposed to be coming back for them. You know what I'm saying? Like, Kel robbed Flat, Flat. He robbed one of them. Like, and then, like, they would have somebody broke in that car. And gave me the phone. And the jury.
Stopping at 8:11:50. So, Your Honor, and look at a lot of it is these just rumors about what he's hearing about what happened leading up to the murder.
I don't even know if they're rumors that he heard. He might be completely making it up and never even heard a rumor, but that's besides the point. They're asking what happened, how did Nut get killed, and he proffers a theory or a story that that Kel and K robbed someone, and then those people came back and killed Nut. And that is and the relevance of that is it's not for the truth of the matter asserted. I don't think anyone in this courtroom, at least on this side of the room, is going to get up in closing and argue that the real killers of Donovan Thomas were, I'm hearing the name Nick, and maybe I'm following the story correctly or not, that Nick, after being robbed by Kel and Kay, came back for revenge and killed Donovan Thomas. We're not arguing that that's true. What we're saying is simply that, according to state's theory, Mr. Copeland had inside information on January 10th, 2015, and about our clients committing a crime, and then he's asked about it on January 28th, and not only does he not, it's one thing not to mention our clients, which is important, but it's a whole nother thing to put a different theory out there. And so we think that's very relevant, and that goes to his credibility. And I understand he's arguing to everyone that he has no credibility. But the state is arguing that there is credibility with his June 10th, 2015 statement, and we're saying there's no credibility to that either.
No, that's not saying, Your Honor. I don't think the two are not mutually exclusive. He can know the truth, but proper rumors, but what those rumors are, is they're not competent evidence. Like what he's saying, they can cross him without this coming in about the fact that he told the rumors. You told the police rumors in January. What those rumors are is not competent evidence because it's all speculation, it's all rumors. They can clearly ask him that on the stand without going into.
And I assume that the only reason June 10th comes in anyway is because he takes the stand and says, I don't know anything about anything, I don't remember. Right, and so June 10th comes in as a prior statement?
Yes, Your Honor. Because prior to everything, his response is everything is June 10th, and then the whole finessing, and then he's now changing the version of facts as to what happened back in January 2015. He's now changing some of those facts. I don't know what he will do when he comes back, but that's what he did.
So the defense, if the state can stand up and go, all right, here's your prior inconsistency.
Why is her microphone not on?
X, Y, and Z, which was all these people over here on this side were in Telephone. Then they want to be able to say, well, look, in January you said something different. Explain that. Why shouldn't they get to do that?
I think they can ask him about, in January, you said it was all rumors. You said that. You said that there were rumors. What those rumors are, I don't think it's relevant. They can definitely ask him. Now, whether or not he says, I never gave anyone a rumor, then maybe that might open the door for something else. But for the state to play it initially, if we even get to play the statement, all these rumors coming in, I think there had to be some foundation about the substance of the rumors if they come in. But they can ask him simply on the stand, you told rumors, and if he says yes, then that's it. What the rumors are will be irrelevant.
We've all been doing this long enough to know that one of the things that makes stories ring true sometimes is the inclusion of detail.
What?
No, it'd be one thing if he just said, John, I heard John killed Donovan Thomas, but he didn't do that. In this story he gave, he gives details. He gives a story, a coherent story. And
Because he's making it up.
It's not just that he gave rumors, he gave a coherent, detailed theory. And the state, I'm sure at some point is going to argue to this jury that, oh, well, he was telling the truth on June 10th because look at the details he gave. How would he ever come up with this story that it was these specific 4 gentlemen in the car? How would he ever, and we're seeing on January 28th, he is giving a detailed story with individuals and a motive and all the rest. And so I don't think that it does. I think something is lost if we were limited to just say
We're lost.
You talked about rumors on January 28th. That really doesn't do it justice. We should be able to get into exactly what he said. And again, we're not going to argue that that's the truth. We're just going to argue that it's Mr. Copeland's ability to think on the fly and come up with detailed stories. And when he was given an opportunity to to explain what happened, he came with a detailed story that had nothing to do with our clients. We think that's fair game.
Well, I mean, you can certainly ask him about it. You can ask him in as much detail as possible as you want to. And I think it's going to depend what he says then. Okay. Oh, me? Yeah, sorry.
So maybe if you're saying I'm not presuming that he's going to deny
Okay.
saying this. So yes, if we ask him on the stand and on cross-examination, leading questions, and he confirms that on January 28th, he told about,
This
all that
story
stuff,
about,
then
right.
I can see that we wouldn't
That's it.
necessarily
Yeah.
get the play.
Okay.
But I think, as I understand it, the state's saying that we don't even get to go there.
Oh, no, they're not saying that. You agree they can cross him as much as they want to on, hey, this was your theory or rumor or whatever that you told the police on January 28th. They can ask him about that, right? I mean, you agree to that.
He can say, this is what I told the police?
Can they say, do you have a dispute with them being able to cross Mr. Copeland and say, well, on January 28th, when you were talking to the police, you told them that you heard from the street that Kay and whomever robbed so-and-so, and it was those people that then killed Nutt.
So the state's concern is, even in the interview, he doesn't say it as fact. He doesn't say, this is what happened.
Well, sure.
He said, this is what I heard.
Yeah.
So to me, it's still speculative as to what he heard on the street. Whatever the rumor was, to me, is still speculation. I think an inquiry could be, you didn't tell them on January 28th that Shannon, Stillwell, these people did. You only proffered rumors, not the.
But they can, so you think they can ask, you told rumors, but they can't ask, what is the rumor you told them?
Correct.
That is not correct. You can, in fact, ask them about the detail of the rumor that he told them. As long as, I mean, obviously he is clearly saying this is a rumor I heard on the street. And I know your point's gonna be, well, that's an awfully detailed rumor. And you could argue that later. But yes, you can get into the detail of, didn't you tell them you heard X and Y and Z? And then if he says, yeah, I lied about that too, then that's the end of it. If he says, no, man, I never said a thing like that in my life, then we may be able to actually play that part.
That's fine. We still believe that the rumor speculation, but we
No, it is. I mean, he says it is. He says, this is what my girlfriend told me she heard from somebody else. It's clearly a rumor. That is not their point. Their point is you, at some earlier point, are telling the police some theory, albeit rumor, albeit street talk, that is some details. And I think they're going to argue whatever they're going to argue, but then get into the substance of what that rumor is. They can't mislead that this is what you said as fact. It has to be still, this was the rumor you told them, but they can get into the detail. Mr. Steele.
Right, I think what you just said is what I want to ensure.
Yes. Okay.
I think we're good. And Your Honor,
He's just saying I'm standing up because I wanted to make sure that you already just explained what I was going to ask about.
But the one position is.
There he is. He's back.
You may know this, but Mr. Copeland didn't say, like, I never said anything. What he actually said was.
I said all of it. I don't remember exactly what I said, but everything I said was a lie, right?
Exactly.
Yeah.
Because the police were making me the number one target. They told me I'm the subject of this murder, and I wanted to push everything I could away from me and onto others.
Mm-hmm.
So that's why it's very important to show that he's just coming up with, Mr. Lamar is Rich Homie Kwan. He put a hit on another person to kill them. Ask Mr. Copeland. He has 17 people that he says put hits on other people.
Okay.
That's outside of people here.
Okay.
But what you said is exactly right. It doesn't matter. I'm not using it for truth. I'm using it for exactly what he's saying. That's what I was doing.
Okay.
And at trial, he said, and that's what I did for the people here on trial.
Okay.
Thank you.
All right. What's our next portion of this transcript at issue?
The next,
or statement.
yes, the next part that's at issue, potentially page 203, line 11 through page 206, line 17.
Okay.
And more specifically.
Man, they literally gonna throw these people in jail because of some rumors. Y'all stop playing. Stop it. Stop this.
Line 15.
I really want to know why love is so quiet though.
Line 17. And Mr. Shaw, are you okay with 82131 through 82137?
So that's 206, 15, and 17. So
Yeah, that's gonna be page 203, line 1 through 16.
Your Honor, could I just ask that at 15 seconds or whatever that is in.
A new poll question is up. New poll question is up.
I don't think I have an objection, but
Okay.
I can't really tell.
Okay. Sure.
And Your Honor, I'll play from 82131 to the whole section.
Okay.
I'm starting to think that's it. Gladiator girl. She can't bully her way around.
Me and G not together. Me and G together don't matter what. Just like DB. We work together. You know what I'm saying? We not doing that. Who killed DB? They don't even, man. They don't even. I don't know. They don't even, man. They don't even.
I think you started right after the
Abortion.
yeah.
Man, besides Shannon and G, you ain't gonna see me hanging with nobody. So is it a question? No, that's what I say. How the hell I be leaving y'all to turn everybody out to me? Like, it's not one man. It's not one time.
I'm fine. The state wanted to play that, and I don't have any problem.
Okay.
So right after that, we're in agreement from, I believe, 82137 to 82252, where the murder of a gentleman by the name of DB is discussed. I believe we agree that is coming out.
Okay.
And then if Ms. Hilton could just play the 7 seconds that on the other end of that she wants to include, I just want to make sure.
All right. So this is going to be somewhere on 206.
Yes.
Okay.
Somewhere, or starting at line 5 or line 6.
Okay.
It's gonna start a little early at 822:02.
Okay.
He just threw it up. He did kill me. It's tough. I know, but just like you said, somebody, it ain't like I'm putting on the team. That's about what we can prove. So, just like the little nigga, Lil Hayden. When he just got out of jail, he see me in the club. He walked right up on me. I'm murdering me. Yeah. Who? Little nigga, little 80. You know, what's supposed to have something to do with DB? Oh, okay. But that nigga walked up on me, man, nigga, who the hell is you? Yeah. I ain't know him. Yeah. What's up? Best friend, what's up? Why you looking at me like that? Yeah. And me by himself, like, I know that's my little brother, like, hey, he just got it. So like he booked, like, man, shit up. Nigga, like, what's up?
Hey, little Haley, the one that got shot in the face?
Yeah.
On Boulevard, right?
Yeah.
He out too?
Hey, that you, like,
So they,
some corn got a video on his page. All them walking in the house. Same night they shut my grandmama's house. I know just all the nigga they did. You know what I'm saying? They pulled up into a house with 3 cars.
so you mean, after this, so it's Rich Homie and Thug beefing?
No. How is that not possible though? That's what I try to say. I feel like
He playing both sides.
I feel like everybody like I feel like when he needs. I feel like they came together and made an agreement to kill me and everything go away. I feel like it, but I'm not gonna run.
Even
We're past the, honor, that portion we can keep out.
All right, so what is the portion that is at issue?
No, nothing, now that.
All righty, I'm glad we all did that.
In 2259 is where we're gonna go back live on the state. This play.
So the full redaction, 82137 through 18.
Go ahead and make sure you answer the poll question, everybody. Lots of good feedback on the poll question. Got a couple minutes left on it.
822:59. And that's gonna be page 203, line 19 through page 206, line 17.
Okay.
We have a series of agreements, Your Honor, and I think there's only one more that we disagree, is that correct? And it's
Only one more?
Okay.
Only one more?
So where's that one?
Page 269, line 19 through page 270, line 14.
This is a disaster, a living, breathing disaster.
All right, and is this the part that the state wants in, defense wants out, or the other way around?
If I can do one more time, this might not be.
We both agree that a certain part of this comes out. There's a portion of it where Mr. Copeland somehow talks about a rumor that Donovan Thomas in his dying breath said that Doug was responsible.
Okay.
A, that's not true, but B, that's hearsay. People that were next to Donovan Thomas said that's not true. So, but it's hearsay nonetheless. But I believe that the state wants to not take out a certain segment of this. And that was our disagreement.
We are fine taking out that part.
Take it all out. Let's take it all out.
Sorry, what Mr. Jarvis mentioned that Doug did.
Okay.
That part we will keep out. We didn't know if the defense has other objections to, and I'm sorry, Your Honor, we're on page 270, line 7. It actually says, he said the as has something to do with it. It's unintelligible, but that is the line that we're referencing.
Okay, so y'all are by agreement taking that out.
So, but I guess at the bottom of 269, we have it written down as 269, 19, 270, 14. Is that correct?
That's what I wrote down, but what y'all might have an objection to, I don't know.
Well,
So 269:19 through 23, where he's saying some detail about what he heard about not getting shot. Is there any dispute about whether that is in or out? I mean, I don't know, y'all.
I agree that that is out. My understanding was the state viewed that those timestamps were too large and that something within that time period can get in. But
Okay.
maybe not.
All right, Ms. Hilton, was that something y'all intend to put in?
Initially, yes, but Your Honor,
How about now?
we will not put it
All right, so then 269, line 19, all the way through 270, line 9 is, I'm sorry, 9 or 14 is out by agreement? Which one was it? The end, 9 or 14? No. Okay.
I don't think you can do that to certain files. It sounds good though.
Line 9. Okay. Yeah. She is out by agreement. All right. So was that the last thing?
Yes.
We're done.
Okay.
And Your Honor, our agreements for redactions, I guess they'll just, when we email them, they'll be made part of the record that way.
When you email them to whom? What I'd like y'all to do, I mean, for this, we actually, anything we didn't discuss that y'all have an agreement as to, like all of Mr. Adams' stuff, just make a little list and say, the state and the defense agree that XYZ is out. Okay?
Here, I already compiled it from the first time.
Super, just get together with your colleagues on the other side and make sure they agree and get it filed. Okay, so
She
that's
sounds so
that
tired.
statement.
She sounds so tired. Bless her heart.
That's the January 28th statement is taken care of.
I don't know how I think they are rumors, Bruce.
And y'all are gonna, on January 11th and February 20th, figure out the couple of little things that might be in dispute and then bring those to me. And I doubt if y'all got a chance to do that already. So it seems like then the next statement is June 10th, right?
You wouldn't do that, that's what we did this morning.
That was,
You started with June 10th.
We'll go in reverse.
You went over.
all right, okay, you're right. So if we've done
all the 3 that we can do.
And, okay, and then the other 2, y'all are just gonna figure out what the small little differences are. Okay, so then I think the next thing we have to sort out is
Motions for mistrial.
with regard to the testimony of Mr. Copeland that occurred post recusal motion. I don't know how many days of transcript of that y'all have yet. I think you have
The whole
at
thing that y'all
least
went over today.
2 or 3 days worth of that, but maybe
No,
not all of it.
all of
from
it.
Ms. Weaver, Judge Glanville's court reporter. Some directly from her, some
It's
through
all
Ms.
of it. That's the
Hurstfield.
problem.
Because, right?
No, it's
Have
the
y'all
whole.
discussed that at all yet?
Lord have mercy.
So Mr. Shard and I discussed briefly that the defense needed to talk amongst themselves.
Okay.
And then they were going to come.
All right. Okay, so over the weekend, y'all figure out both amongst yourselves and then between the defense and the state, if there is anything, and if there is, what?
That's literally everything y'all been
of
wrangling
Mr.
through.
Copeland's post recusal motion testimony, there might be some agreement to. And then also, if y'all can think and propose to me on Monday, whatever y'all think might be appropriate in terms of explaining to the jury if they're going to have to sort of rehear any part of Mr. Copeland's testimony.
Oh my gosh. Yeah, I forgot about
Just what
that.
we're going to tell them about.
New
that.
instructions.
Okay.
This is a disaster.
And then after Mr. Copeland testifies, what's next?
See, that's what they should have been doing.
And how long do y'all anticipate that taking? Y'all have no idea, do you? Because who knows what he's going to do.
That part is true. Does the court mean like which witnesses?
Yeah.
Okay,
Yes,
so
yes.
I anticipate there will be two other potentially Mr. Sledge, Mr. Zachary.
Okay.
Those two.
This is what you gave me. That's basically an order, right?
Yes.
Okay.
Yes.
So then, Mr. Sledge and Mr. Zachary, are there anything about their evidence that we need to hash out? And I can't remember, what did I give you as your deadline to? give us all
A long
the
time ago.
details about the evidence?
A long time ago.
The exhibits was Wednesday, but then the witnesses was Monday, and
I thought the first 30 might have been Monday.
the first 30, yeah,
Okay.
Monday.
You ain't got the first 30. Y'all supposed to have it this past Monday.
Okay.
This is craziness. We got 200 people watching. What's
So
up?
I honestly did not think we would. I am really glad that we did. Congratulations to everybody. Get through as much as we got through today. But given the last couple of days, I'm pleasantly surprised that we did. So I actually, at this point, told the jury, don't come before Wednesday, because I figured we had enough work to do Monday and Tuesday. And I think that probably is true. But yeah, with everything that you're, and if y'all get finished early, you don't have to wait till Monday morning. You can go ahead and email whatever you get finished with as you're finishing it. All right. So yeah, we can start working on all of that. All right. So this is a good time to adjourn for the day, or do we have other things we?
You got motions, I
want or
thought,
need to
that you had
take
to-
up right now?
There may be one more thing that we can
Okay.
take up if the court would allow us one more.
Uh-oh, don't ask for no ex parte.
Your Honor, we do have the 5 jail calls that we intend to get.
Oh,
out.
Lord.
Perfect.
Oh,
Yeah, we can do that.
Oh, my
Okay.
gosh.
And I've already listened to the portions of,
And there were portions that we did not object to, Your Honor, so I
Yeah.
can go through by call which one we didn't object to.
I object to them all. There, how about that? I object to them all. Whew,
so you're
goodness.
working off of, so I know that Mr. Shart had provided kind of June 19th-ish, his proposed redactions, right? Is that what you're working from to tell me which ones you agree to?
Yes, is
Okay.
that what Mr. Steele sent? No, for the jail calls, I'm looking at Wednesday, June 26th. There was an email that Mr. Steele sent.
I don't know that I have that.
Okay.
What I've got is it may be the same list. Oh, it may be. I don't know. It's what I have is whatever Judge Glanville had made a court's exhibit when y'all were talking about them. And
What does that mean?
says forward Stillwell proposed redactions. Anyway, it's a list of like 10 proposed redactions. Is that the same thing when we get down to it, or?
No, I
Okay,
have,
well, give me what it is that I need to be looking at.
I can find it. For it.
What are y'all doing? Love looked like why she had her computer sideways?
You know what? What I'm looking at right now is not even about the jail calls. So never mind. But I don't have what it is that you're talking about. I'm looking. So there are
just
5 jail calls and there are portions of the 5, is that right?
Yes.
Okay. And then you have agreement as to certain portions of those? Okay.
Yes, so the
All
state's
right.
intention was to play the entirety of the calls, but
All right.
then there were some objections, and so
Sure.
we don't have any objections.
Okay.
We don't have objections.
All right, so do you want to put on the record what portions?
As, if the court has the email, I can go through the areas where there was objection and.
I don't have the email. I do have the email. I just don't know where to find the email. Okay. All right. All right. I am now looking at the email. So go ahead.
So for the first call, which is on March 11th, 2015, there's an objection from 10 minutes and 45 seconds to the call to 10:50. And the state has no objection to not playing that portion of the call.
Okay.
From 15:15 to 15:32, the state has no objection to stopping, to not playing that portion of the call. For the June 10th call, from 7 minutes to 7 minutes and 3 seconds. We have no objection to not playing that portion.
Okay.
From 8 minutes to 8 minutes and 12 seconds, we don't have an objection. And from
Okay.
9 minutes and 57 seconds to 10:15, we do not have an objection.
Okay.
For the June 13th call, we do object to that portion of 2:55 to 3:10.
Okay.
June 14th, we have no objection from 13:51 to 13:58. No objection from 14:11 to 14:13.
All right, new poll is up. New poll is up, party people. New poll is up. Hopefully you'll enjoy it.
Objections to 4:53 to 5:11.
As in y'all want that in?
Yes, you're
Okay.
right. 6:01 to 6:12, we object. We want that part in.
Right.
6:42 to 6:49. We want that in.
Okay.
But I don't know if someone told me this, but I wrote in 13:10 to 13:17. And we don't have an objection to that part. I'm not sure if maybe someone called me, but I wrote in another portion of that call, and we do not object to. Oh, that's on the email as well? Okay, I wrote it, I have it handwritten,
Okay.
so, because it's on the back side.
All right.
So we have no objection to 1310 to 1317.
Okay, great.
I object.
All right, so then our issues
I object.
are with June 13th, 2:55 to 3:10. And then June 15th, 4:53 to 5:11, 6:01 to 6:12, and 6:42 to 6:49. Is that correct?
Yes, Your Honor.
It's the states, Laura. It's the states.
And so we're pulling those two calls up now, Your Honor.
Okay.
Wait, she done got up. Where's she going? Where Judge Siswick going? This case is Swiss cheese, man. This case is littered with holes. This has so many holes in it. Like, what is the concrete evidence that you have that this, again, I don't even think they can convict and say that Young Thug is a black man at this point. I mean, that's how bad their evidence is. I don't think they can even prove that. They can't prove that Brian Shard is bald. I mean, let's just, come on, call the truth. She run away like, Lord, what was I doing? What was I thinking? She said, is that Supreme Court that important? This evidence is horrible. I'm like, this is just sounds like a bunch of hearsay.
As Mr. Box is here and Mr. Steele is handling this portion, may I step out?
Sure.
Mr. Steele, what Mr. Steele doing?
This is a free call from.
And I'm gonna start, Your Honor, around 2:25.
He booked the Brian. Meet me on University. On University where? At that gas station we always, you know what that gas station Chevron. That's Chevron. Meet me at Chevron. Hey, man. Okay. Yeah. Look, you ain't right, bro.
Almost 2 years, Donna.
I'm gonna say too much, bro. Be told. You come out rock crew, D? Yeah. I told him. He told on Roscoe too. You think I'm fucking playing, bro? He told on Roscoe. He told on Roscoe just cause Roscoe ain't no fucking blood. And he don't give a fuck. Roscoe ain't free. Hey, D-Shot come meet you.
And that concludes at 3:11, Your Honor. And to give some context, on this call, this is a call from June 13, 2015, which is 3 days after that June 10th interview. Mr. Copeland is now in custody. He calls his girlfriend, Ms. Quarterman, who then calls the person who you hear is Max, but is also Dolly White, also known as Dolly White, but is Mr. Williams' sister.
Mm-hmm.
She is a person that the state alleges a number of the gang members will call to get in contact with Mr. Williams or for her to facilitate a number of different things throughout the trial.
Mm-hmm.
And while on the phone, there's first talking about money to help with his bond. That's
Mhm.
when you hear her talking about meeting the girlfriend at the gas station.
Right.
Then he says, little D ain't right. At that point, they jump to, because he snitched, because he told on Roscoe, and they're talking about him not doing what a gang member is supposed to do, which is then snitching, Your Honor. So we believe that that is relevant information for this jury to hear, that the gang members are talking about the failure of another gang member to be supportive of the gang, to actually tell or snitch on another gang member. And that's what's contained in that portion of the call.
Okay. And the objection,
Hearsay, Your Honor, it is not, I don't know, I've listened to these so many times, and I don't know if it's fair to you, but he never said about, oh, this is what gang members should act like, this isn't appropriate for a gang member to snitch on someone. That's not in there. What he said is, something to the effect, I'm not quoting it, hear what little D did.
yeah, and then she says, D ain't right, D done told, blah, blah, blah.
Yeah, so how does he know that? Who did he hear it
She
from?
is hilarious, man.
Well, I don't know that that matters because they're not offering it for the truth of whether D ain't right.
I don't know.
We are not offering whether D is or ain't right. It's the fact that literally it was, everything they said about him, and overtly the fact that a YSL member, they believe, told if he did or didn't, and their anger towards it.
I just don't see it like that. I see this is after Mr. Copeland. This is after Mr. Copeland has cooperated with the authorities. He is in contact with Detective Gaither on a daily basis.
Yeah.
And he is speaking now as a government agent.
Do you have proof of that? I mean, that's not an issue in this trial. This is him on the phone with his people, still thinking nobody knows he's said a word.
Of course, no one knows it. That's why he's an agent for the government. He is being told on June 10th, you need to work with us, otherwise you are going to get severe time. And he says, great, I will work with you. That's in the recording that you listened to. You didn't listen to that part, but it's in the 9-hour recording. So I don't see how this comes in. It is hearsay that he is just saying, did you hear what this other person? We have no idea the context. And it is being asked for the truth of the matter, because that's why they are talking about it. This is not, oh, it doesn't matter if it's true or not. He's specifically saying this man said something. I don't see how that comes in. You know, we could ask him about it, but I don't see how the jail call comes in. I think the state has to lay a predicate or a foundation before you can.
Well, I mean, I would assume they're going to have to lay some kind of foundation for some reason to get it in.
They lay a foundation down.
And I don't know what that's going to be, but assuming, I mean, I don't know, maybe you want to elaborate, Ms. Hilton.
We believe this is also evidence of the overarching gang conspiracy. Again, we have to prove that this is a conspiracy, that this is in furtherance of that conspiracy around. We believe that one YSL member telling another YSL member that one YSL member snitching is in furtherance of protecting the conspiracy, protecting the gang, Your Honor. And this would be evidence of that. So essentially it would be a co-conspirator statement between these co-conspirators talking about gang activity.
I don't know if it works like that, but
I mean, I think if the proper foundation is laid, that comes in over a hearsay objection. Okay, and then, excuse me, June 15th, a couple of different portions.
Your Honor, it's of course I would just start at 450 and play through 649 because it's only about 2 minutes for those 3 sections.
I'm still sitting on the phone.
this is getting so out of control. That's was a dare to be bold. Dare to be bold. Shout out. I agree with this right here. Just sound like
calling
look.
his girlfriend on 3-way, but at this point he has asked his girlfriend to call Detective Gaither, and so the portion that you're hearing is Mr. Copeland and Detective Gaither on the phone.
Okay.
Gotta
I'm gonna start at 4:47.
for everything. Like, I'm not gonna sit here and promise you like you're gonna get out of jail next week or in 2 weeks. All that, like I told you, you gave us a lot of good information, but we gotta still do our job. We're not just taking your word for the gospel just because it's coming from you. We still gotta investigate shit. So all of that will be taken into consideration at the end of the day.
So my brother,
like I said, do your brother know what?
that federal put the feds could touch him.
I'm not talking to nobody about your case, but to you and who you got on the phone. That's up to y'all. Like we don't do that.
I'm saying, so is they trying to work with me though? Is they gonna try to work something out?
I can't say what they're gonna do. Like I said, everything that you told us, we want to speak with you again. All of that will be taken into consideration. That's what she told what the ATF agent when we first came in, lady.
Yeah.
That's what we do in the beginning. A lot of what you say will kind of determine your future. That's why you need to be completely honest with stuff.
Yeah.
So at the same time, we still got to look into it. We're not just going to take your word for everything you say. We got to be able to, prove what you say is true.
So if I prove it, then y'all let me have it right.
Are you hearing anything that I'm saying? Because I feel like I'm talking in circles.
Nah, I hear you, but it's confusing.
If you provide us with some things that we can verify, it's not up to us to let you out of jail. That's totally up to the DA's office, all that stuff on what they want to do with you. They do take into consideration if you helped or not. And so far, it appears as if you've helped, but we still have to do our job and investigate.
Yeah. So I still got state and
I conclude at 6:53.
Okay. And so what is at issue? What statements specifically are at issue?
Detective Gaither's statements, bolstering so far. You've helped. We still have to corroborate, but so far this was helpful. I don't know what the right word is. And I believe that that's bolstering his statements.
All right, and what does the state say to that?
Sure. Yeah, we don't know what he's going to say on the stand. But if he goes down the same line of, I was just lying to finesse investigation, I made it all up. This is in complete contradiction to that because she's telling him, just like she told him in the interview, we have to verify what you're telling us. So if he was telling lies, he wouldn't continue to say the same things over again because she keeps telling him, everything you told us, we appreciate you telling us, but we have to verify everything that you said. So there's nothing I can do for you until.
Well, he's not really saying anything over again. He's saying, hey, I told y'all something. Can you let me out now?
Right.
Right.
So he's saying everything I said is a lie. So
he is now, yeah.
He is now. So what this shows is a contradiction because he wouldn't be calling the detective trying to continuously see if he can get out of jail if what he said was a lie. Especially when she's telling him.
All right, the objection is that Detective Gaither's statements, well, yeah, I mean, you seem to have helped us, but whatever. Why do you want any of this? How do you envision using that particular
love to
thing
know
I just
that.
heard?
So there's a few things. So part of this trial, some of the defenses that have come out is that the police didn't fully investigate.
Okay.
That they took.
Oh, thank you, Claudia. Thank you for the super sticker. Thank you so much.
Supports that that's not what happened. That
I appreciate it. Thank
Is
you.
Detective Gaither going to testify?
She has
All right.
testified.
Has she said already, man, we didn't just take his word for it, we investigated?
She testified
Yes.
to that.
Okay, so it's not necessary for that.
But again, I think it gives context to, while Mr. Steele's focused on Detective Gaither, we're focusing on Kenneth's actions, that if he lied, he would not continue to call the police to verify how they're gonna help him when he knows, listening to Detective Gaither, every time she speaks to him, she says, we can't do anything yet until we verify what you told us. So clearly what you told the police isn't a lie, even though you're saying that today in 2024.
I see what she's trying to do, but I don't think that works like that.
In 2015, you believe to be true because you wouldn't keep calling if you just want to tell them one lie and that was it. You wouldn't keep calling the detective.
All right. So let me ask you this. If what you want that in, or those portions in for is Mr. Copeland's, hey, y'all, come on, I gave you the truth. Let me out now.
Right. That's
Is there some way that you could redact that where we don't hear big chunks of Detective Gaither saying something she's already said on the stand anyway, which is I got to verify this stuff? See what you can do.
But why
okay?
though?
We can see what.
Okay.
We think we'll be out of
Well,
Man, thank you, MS. Thank you, retired. I think so.
Yes.
Again, putting everything in context and thinking back to some of the testimony that Mr. Copeland had put forth previously.
You know, the state's position that he put to the court as well. If he wasn't telling the truth, why would he call and try to follow up and see if they were checking on his truth or not? When he testified, one of the things that he said, it was probably the biggest thing that he said is, hey, they don't know that I'm lying.
That's
And
right.
he said, yeah, I lied to them. I'm trying to finesse my way out of this, but they don't know that I'm lying. And that was in response to a specific question that Madam Prosecutor, Ms. Hilton, asked Mr. Copeland. So I think that kind of, that goes against what they're saying as their rationale.
I mean, don't get me wrong. I'm not sure that what they're saying it's going to come in for is going to in any way show or be a convincing argument, but I mean, they can.
Yeah,
it's not inadmissible for them to try it.
No, I understand. But I think our objection, as Mrs. Steele stated a little while ago, is, why is any of what the detectives bolstering of Mr.
I understand, which is why I told her if she can come up with a way to get her part in without the objectionable part, she needs to try to do that.
I'm confident that she can.
Let's have it. All right. Okay, so that is all of the jail statements. Yes.
Please, Jesus.
Okay.
Please, Lord.
Super. All right. One thing I wanted to do is do some test run of this, and this doesn't need to be on the record, where I just don't have it. I've never used these before. So how is it that y'all are doing this? Do I hand these out to all of y'all and then? All right, I don't need to, y'all have them, so.
We need the base.
Okay, and I mean, everybody doesn't have to do it. If a couple of people want to.
Okay. I have no idea. It looks like they're just handing out microphones. I'm gonna pass over that real quick because and I'll bring it back, I promise. So in a few minutes, I was asked by Phil Holloway to do a joint stream with him so we can kind of unpack this, if you will, and kind of talk about it. So at the current text is, hold on, let me send them my email. All right. So the current plan is for me and Phil Holloway to come back on in a few minutes. I'm gonna end at 4:30, even though they're still fooling around with these walk headphones. I'm gonna end this stream at 4:30, so basically in 5 minutes, and come back on at 4:45. Me and Phil are gonna be doing a live stream, a co-stream together to talk about this and kind of hopefully make a little bit more sense of it. So make sure you have your questions, all that kind of good. Oh, they cut us off anyway. Make sure you have your questions and all that kind of jazz, and we'll be ready to talk with Phil in a few minutes. And just to get the lay of the land, if people just kind of jumped in, it looks like Judge Whitaker is going to take this thing all the way to the end. She looks like she's going to drive this train. She's going to get it back on track, and she's going to take it all the way into a verdict. So that's where it looks like at the current moment. I don't know. I think she has more than sufficient evidence for a mistrial. Maybe if you can take a mistrial and turn it into a verdict, maybe that looks better on you. I don't know. But it is what it is. So that's what's going to happen. So I'm going to end the stream now. Look, it looks like they ended it. So I'm going to end the stream now, and we'll literally be back in like 15 minutes because Phil is just sending me the link right now. So we're going to just do a test run, make sure everything works right, and then we'll be back. So everybody, I want to thank you so much. Thank you to all the support. Everybody hung out with us for almost 8 hours. That's crazy. So I appreciate y'all so much for hanging out. Thank you so much to all the super chats and stickers and all of the conversation in the live. I really, really appreciate it. It'll be on my channel. So the link will be showing up on my channel in a few moments. So as soon as I get it from Phil, you'll see it populate. A new live stream will be starting up. And like I said, in about, let's see, 15 minutes. So it'll be me and Phil again talking about all this kind of stuff and kind of making some sense out of it. So everybody, I'm going to see you all in a few moments. I thank you again and see you real soon. Grace and peace.